Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. I'm Ann Carney, and I'll be chairing the meeting this morning. This morning we have hearings on two bills, LD 842 and LD 776. We'll also briefly take action on LD 917. That bill we will vote ought not to pass at the sponsor's request. I just wanted to announce that so that folks who are in the attendee space who may be here for that bill will know that we most likely will not be taking any testimony on it again at the sponsor's request. We'll start our meeting today with our usual round of committee introductions. And Representative Evangelos, could you start us off with introductions, please?
Thank you, Senator. Good morning. It's Jeffrey Evangelos, House District 91. I represent Waldoboro, Friendship, Union, and Washington. Thanks.
Thank you. And let's see, Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. And next, Representative Sheehan.
Good morning. My name is Erin Sheehan, and I'm proud to represent Biddeford's House District 12.
Representative Moriarty.
Good morning, everyone, and happy Earth Day. I'm Steve Moriarty from District 45, which is Cumberland and part of Gray.
Representative Reckitt.
Yes, my name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County and two communities in Androscoggin.
Representative Harnett.
Thank you, Madam Chair. Good morning, everyone, and happy Earth Day. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside. Nice to see you all.
And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I want to extend happy Earth Day wishes to everyone as well. And with that, we'll turn to our work for the day. The bills that we will have public hearings on, again, public hearings are the opportunity for the committee to hear from the bill sponsor and any co-sponsors, and also from members of the public. We will have an opportunity to have committee discussion and debate on all of the bills we hear today later when they are scheduled for work sessions. I will be pulling people in and out from the attendee list onto the panel when it's time for members of the public to testify. And I did want to just alert people who haven't been through the process before that the transition from the attendee list to the panel can feel a little weird. You disappear and then you reappear on screen with all of us. So just be patient and it will happen. Another reminder is that members of the public, actually any speaker other than the bill sponsor, will be asked to keep remarks to 3 minutes. I wanted to welcome Representative Newell, who just joined us, and give her a chance to introduce herself as well.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the tribal representative for the Passamaquoddy tribe.
Thank you. And with that, we will begin our public hearing on LD number 842, an act to reestablish parole. And this is being presented by our committee member and colleague, Representative Evangelos. And
Here you go. Thank you, Senator Carney. And good morning, Senator Carney, Representative Harnett, and other distinguished members of the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, and I represent House District 91. I am speaking today in support of LD 842, an act to reestablish parole. Before I continue, I'm lodging an official protest under the circumstances in which this hearing is being conducted today. On 3 occasions in the last 2 weeks, I wrote Commissioner Liberty and the Department of Corrections, and because of the extraordinary circumstances revolving this bill that could result and the possible freedom of people who have held themselves accountable and redeemed themselves. I ask that they be allowed to Zoom in at the hearing and testify so we could see their faces and hear their voices. And I was denied. I copied the entire committee these emails. I appealed to the governor and I never heard a response. Now I can accept a denial. The denial came from a high official in the corrections department, but the denial contained patently false information. Information that said that the prison lacked the technology and the prison lacked the staff. I tailored my appeal to Governor Mills down to just allow 2 or 3 residents at just one facility, the Maine State Prison. Because I know for a fact, in the day room of the state prison, they have a big screen and they have Zoom capability and they use it all the time. And this denial was unjustified and it was based on false information. And that's my protest, that when a cabinet level organization in our state government provides patently false information to a committee of the legislature, that needs to be addressed. I'll continue my testimony. In 1976, Maine became the first state in the union to abolish parole. This move came in a time of strict law and of a strict law and order movement, followed by a move toward truth in sentencing, or the adoption of determinate sentencing in the 1970s, 80s, and 90s in 16 states. In plain language, these states adopted the "you do the crime, you do the time" standard. Lock them up and throw the key away. 16 states abolished parole during this period. 34 states still have parole systems in place, including all of our New England states and New York State. Without parole, states rely mostly on the discretionary powers of governors, that of pardons and executive clemency. Truthfully, in Maine, while pardons are sometimes issued, often for politically connected individuals, pardons are never issued for incarcerated individuals who have worked tirelessly to improve their lives and have held themselves accountable for their mistakes. Shamefully, Maine pardoned Don Gellers, an attorney who was assisting the Passamaquoddy Nation in the 1960s and 70s. Gellers was framed by the police in the Attorney General's office. Gellers died in 2014. He wasn't pardoned until 2019. A posthumous pardon? We can't do better than that. In reference to the other executive power available since the abolition of parole in 1976, that of executive clemency, Maine's governors have never granted even one application. Since 1976, no one in Maine has ever been granted executive clemency, underscoring the failure of Maine's determinate sentencing system. The denial of executive clemency last year for Brandon Brown motivated me in part to pursue this bill. In an unprecedented development, Brandon Brown was accepted into the PhD program at George Mason University last year while sitting at the Maine State Prison. A 500-page dossier of evidence and supporting documents were presented to the Executive Clemency Board in April of 2020. 12 people testified at Brandon's clemency hearing in support of his petition so he could pursue his doctorate. This included the District Attorney Natasha Irving, University of Maine Rockland Director Deborah Meehan, 3 PhD professors from George Mason University, a member of the clergy, myself, and several others. Brandon's victim also wrote a letter supporting his release, and I quote, I'm sorry, "I've been meaning to write this letter for a while to say, I hope your growth continues. And then I let go of anger and pain. Forgiveness and bettering ourselves is the way to be. So with that said, I hope this helps toward an early release for you. Take care, my dude. Jimmy Sanders." On February 9th, 2021, in testimony before the Judiciary Committee, Attorney and now District Court Judge Sarah Churchill told the committee during her confirmation hearing that Brandon's sentence was 3 times more severe as normal, and I quote, was the result of human error in the court. Despite all of this, Brown's petition for clemency was denied by the governor. As I was quoted in the press last summer, if Brandon doesn't qualify for clemency, no one ever will. A model in Maine has failed. LDA 42 reestablishes parole. It is a critical step in recognizing the good reform work being undertaken at our prisons. Many of our incarcerated residents are in prison for 30 years all the way to life for mistakes they made when they were 18 to 21 years old. We all know the brains of a teenager isn't fully developed. In one case in 2005-2006, a 14-year-old boy was tried as an adult and sentenced to 25 years in prison. In 2013, he had this to say: the person I was at 15 is almost unrecognizable from the person I am today. I've grown in ways, emotionally, in ways I couldn't begin to describe. My relationship with people are so much better. I'm so much more of a calm person, said Patrick. I wish all of it could be taken back, knowing at the time what irreparable harm you've done to a person, to a family, to a community. There's no way to express that or put it into words. There's no action I could possibly do that could apologize for the damage I've done. I want to share with the committee that Patrick's mother called me 5 or 6 months ago. He was 7 or 8 months away from being released. For 20 years, he's been a model prisoner, never gotten in trouble, never gotten into a fight, and earned a 4.0 average in his bachelor's degree at the University of Maine. The mom asked me if I would ask that Patrick, due to the COVID crisis, and he was at the Bolduc unit, which had COVID cases, that Patrick be released to home confinement for the remainder of his sentence. He was already out in the community working. That request was denied. As you're going to hear, I'm sure, the answer is always no in Maine. We never get a yes from corrections. The answer is always no. LDA 42 would make current and future prisoners eligible for a parole hearing if, for a sentence of 25 years or more, they have served 20 years, including those now sentenced to life. For shorter sentences, they would have to serve half their sentence in order to qualify. Before I go any further, I wanted to recognize the journalist, Douglas Rooks. Honestly, he's been working on this issue for over 20 years, and by being able to find and access his articles, I wanted to recognize him because it helped me prepare today. In 2019, the Prison Policy Initiative graded the prison release system in all 50 states. Maine earned an F-, the lowest grade due to the harshest determinate sentencing in the nation, combined with no parole system. I have attached the Rabina Institute for Criminal Law and Criminal Justice report on Maine for your review on this matter. That's located at the University of Minnesota. In a February 13th, 2020 New York Times article entitled "It Didn't Work," the Times reported that states which abolished parole are now re-examining that decision. Quote, "We thought we were fighting crime and it didn't work," said David Marston, a state senator in Virginia who had previously introduced bills to restore parole. But more recently, we've stopped trying to teach lessons and started trying to solve problems. People are more likely to believe that people deserve a second chance. Senator Carney and Representative Harnett. I believe in the dignity of people. You know, I believe in second chances. I believe in accountability, and most importantly, I believe in redemption. The capacity of human beings to right the wrongs of the past. Yes, I feel deeply for the victims as well, but society is not made safer when Maine's correction system frustrates hopes and redemption. All this does is increase recidivism when a resident is released. and let's be clear about this, 95% of incarcerated people are going to be released. Maine state prisons are doing a great job in promoting college education and other training inside the walls, but this great work does not get recognized like it does in other states. In New York State's parole board, they carefully examine the progress made by residents each year when it examines the applications for parole. In Maine, you can earn a master's degree with a 4.0 average, work hard, never get into trouble, and you get out of prison the same time as someone who refuses to work and gives the guards a hard time. I call Maine's prison and release system killing hope. That's all I have. I'll answer your questions.
Representative Evangelos, thank you very much. Committee members, do you have any questions for Representative Evangelos?
Madam Chair,
Yes.
I neglected to mention that I did have Peggy assist me in drafting an amendment around the composition of a parole board, and it's just something I wanted to share with you at the work session.
Okay.
Because I think the parole board needs to be beefed up, and we borrowed from Massachusetts and Rhode Island's model, and we've come up with a pretty good suggestion, and it was sent to you this morning. But you'll have it for the work session, and we can talk about incorporating it or not at that point. Thank you.
Thank you. And is it okay with you if committee members have questions about it this morning that they ask you?
Absolutely.
Thank you. Representative Reckett?
Thank you. Representative Evangelos, I am, as is often the case, moved by your testimony, and I appreciate you bringing this bill. I have a question, just of something that I don't quite understand, that I believe is directly related to this bill, or inside it maybe. The differences around commutation as opposed to pardons, or what's the other word I never get right? Yeah, clemency, right. My understanding is commutation happens when somebody's released after whatever it is they've served, but it's not really a pardon. That does happen occasionally here in Maine.
Well,
I mean, the last time I'm aware of was in Baldacci's administration. And the only reason I'm aware of it is because I worked very hard to have it happen. But
yes, I can
so
answer.
it is, yeah. So thank you.
A commutation and a pardon are not the same thing as a petition for executive clemency. A commutation or a pardon is outlined in the Maine Constitution as a prerogative of the chief executive.
Mm-hmm. Okay.
When we adopted determinative sentencing in the 70s and 80s, the executive clemency process was set up. It's a 4-member board. It's a long and lengthy, difficult process. I know firsthand because I sponsored Brandon Brown's. You present at a hearing, they make a recommendation to the chief executive, and she or he decides. So it's a separate process.
Okay.
Not once have we granted an executive clemency petition since 1976.
Thank you, Jeff, for clarifying that for me.
Thank you, Lois. You think it was emotional for everyone else? It's tough for me.
Sure.
Representative Harnett?
Thank you, Madam Chair. And thank you very much, Representative Evangelos, for bringing this important bill forward. And as always, for your detailed research and the reasons why this is an important issue for this committee to consider. At the outset of your testimony, you said a couple of things that struck me. One, that Maine was the first state of the 50 states to eliminate parole as an option. And also that during the 1970s, 80s, and 90s, a total of 16 states eliminated the option of parole. My first question is, do you know if any of those other states that eliminated parole after Maine have reinstated it?
I'm not positive. I know that efforts have been, I quoted the senator from Virginia, bills are being put in to reestablish it because we realize that the determinate sentence model doesn't work. It frustrates redemption and accountability and produces people that are bitter upon release. And I'm not discounting the rights of the victims at all. They should have a say in the process, and I support that. But I know that part of criminal justice and prison reform, that this is being addressed in a variety of states. I'll try to find out more for the work session. It's a good question. Thanks.
Thank you. May I have a follow-up, Senator Carney?
Yes.
Also for the work session, and you might not know it offhand, but I would be interested in success stories from other states about people who have really improved their life while in prison, subsequently released on parole, and the contributions they were able to make to society. And I know that's a big question to put on you right now, but that's something I would certainly like to see.
I can, those stories are all over the country, and as an adjunct to that question, I can tell you the statistics around residents of corrections facilities that earn a bachelor or master's degree. The rate of recidivism drops to about 1%.
Thank you. And one final question, Senator Carney.
Yes, go ahead.
Thank you. Many times in your testimony and in answering questions, you refer to the Department of Corrections. And I'm not sure how to phrase this question, but there's a part of me that thinks that's not a correct title for the department. That in essence we have a Department of Punishment, and that there is no opportunity or no incentive to better one's situation, to acknowledge your misdeeds, and to improve oneself, because doing all those things does not change the length of time that you are incarcerated. Am I getting that right?
Yes, you're getting it exactly right. That's why we earned an F-. I mean, given the storied history that the state of Mississippi has gone through, they earned a C because they've gone through a truth and redemption process and they've accounted for the mistakes of their past. We don't. Whether it's post-conviction or police shootings or these prison issues, the answer is always no. And that's how we crush people's spirits. Representative Harnett, you just said it. We have a Department of Punishment. And you might want to be enlightened on the fact that Foster Bates, who I was advocating for in my post-conviction bill, has been retaliated against over the weekend at the prison. So we do have a Department of Punishment, and that's all we have. Some of the states that did adopt determinative sentencing have adopted some form of parole, so at least the Department of Punishment grants an exit for good work and accountability. But a state that has a fully determined prison sentencing system and doesn't allow for what you're talking about, a Department of Rehabilitation, it's a dead end. And that's why our recidivism rate is so high in the state, because we crush them while they're in prison, and then we turn them out into the streets once their sentence is served. We've got to do better. And all I ever hear around the country are the few cases of an incarcerated individual who failed us on their release and they reoffended. That always gets the big headlines. But the vast, vast majority of people who succeed through the parole process, which is a carefully vetted and reviewed process, go on to be productive citizens. And that should be the end game, as your question suggests.
Thank you, Representative Evangelos, and thank you, Senator Carney.
Representative Moriarty, you can go ahead with your question. We're not able to hear you.
Thank you, Madam Chair. Good morning, Representative Evangelos, and thanks for your moving and sincere testimony. I have a couple of questions for you. I took a look at your amendment, and I frankly didn't know that we apparently currently have a standing state parole board. And I take it that that must be for people convicted or sentenced before January 1976?
That is correct, Representative Moriarty. I believe there are 4 remaining residents of the Maine State Prison at last count. Somebody told me it was only 2, but at my last count, there were 4 who were sentenced pre-76. And therefore, the current parole board is still in operation. I believe all 4 of those individuals were involved in serious homicides, and their petitions for parole have been denied regularly. I'm not taking a position on that, just giving you a factual answer.
Sure.
But I don't believe that the new process we're setting up, the current parole board meeting so infrequently, and I believe it only has 5 members. We need to beef it up, and I want to talk to you in the work session about why I brought a larger board forward. I also think that we're probably going to have to talk about a couple of alternates in the case of a lawyer or a prosecutor who serves on the board, may have been involved in one of the cases.
Okay, thanks. Thank you. I do have one follow-up question. Parole was abolished when the Maine Criminal Code was adopted, and I think it was effective January 1, 1976. And as I recall, the code was the product of a prolonged study by a good-sized committee representing diverse interests, and it was adopted as a whole new statute, repealing and replacing prior criminal law. And the abolition of parole was part of that major legislation. In the years since 76, have there been studies on the reintroduction of parole here in Maine? Has there been any comparable committee, to your knowledge, for example?
Representative Moriarty, every effort to bring forth these reforms have been quashed and defeated. I think the last effort was 10 years ago. I saw Clack's testimony. They suggested that the criminal code have to be amended to accommodate this, but I don't think it's rocket science. We already have a parole process and a parole board, so we have an established legislative process. What we've done in this bill is adopt standards used in the state of Colorado and some other states. So 35 states seem to be able to manage it. And I know that I testified in front of Clack several weeks ago to explain the bill, and I will oppose sending this to a study group because that's Death Valley in this business. You know it as well as I do. We should be able to accomplish what other states are doing on a normalized basis, and the fact that we already are practicing parole for pre-1976 sentenced offenders.
Thank you very much.
You're welcome.
Committee members, are there any additional questions for Representative Evangelos? I am not seeing any. Thank you once again, Representative Evangelos, for presenting this bill. Representative Recca, go ahead.
I just have one more question, Representative Evangelos. Do you know if there is I mean, I know that there are racial disparities in the correction system. Is it your belief that the people who might be eligible for parole under the system have the same, may have this similar problems, or have you thought that through it all? The reason I'm thinking about it is the woman that I worked on the commutation for was a Native woman from upstate. And when I appeared before that board on her behalf, and frankly, when I approached the governor at the time, the chief executive at the time. I also felt there was a dynamic that was in play because of the fact that she was I can't remember, I regret to say whether she was a Penobscot or Passamaquoddy woman, but in either case, there was a whole racial thing that went on behind the scenes. Do you think that could be, my guess is you believe it's a problem now, but the question is, do you think there are ways for this system to make sure that doesn't happen if if we reestablish parole? Are there safeguards that you think should be built in or are already in your bill?
Well, first of all, first part of your question, it absolutely is a problem. We have a population of 1.5% African Americans and 12% of the residents of the state prison are Black. Secondly, there have been some pretty harsh sentences meted out to African American youngsters. And there's something in our state called the innocence penalty, where if you accept the plea deal on a very serious crime, you'll get offered 30 to 50 years. But if you're innocent and you insist upon pleading innocent, you're going to get life. And there have been multiple African American men in the Maine State Prison who have been targeted by this, who have pled innocent. You heard Attorney Tina Naidu 2 days ago tell you about one of them. He's an African American male. And I'd be honest with you, when I was allowed to visit the prison pre-COVID and I was helping this individual, he told me, Mr. Evangelos, I made one mistake. I had sex with a white woman and I lied about it. And my DNA was found in her, but I did not hurt her. And as Tina said, new evidence has emerged that would clear him, but he's been prevented to bring it forward because of the time limit. But Representative Reckitt, the other work we're doing in regards to indigent legal representation will also help address your concern, because when we assure a quality defense, we won't even be addressing these problems, because a quality defense will result in an acquittal if you are innocent. So it's a whole package of criminal justice reforms. We know Representative Talbot Ross is leading us in recognizing these racial inequities. We think because we're a 98% white state that we're free from these problems. My view is we're so white that we're not only not free from these problems, they're very severe. We know that African Americans are being targeted all over the state. We talked about it yesterday in regards to the racial profiling. And I just received a court filing overnight regarding this trooper. And there is another action and more evidence that's come forward. And the language he's using on these tapes regarding African Americans, and he's still on active duty, I just shake my head. How blind can they be, given what's going on across the country? We've got to get with it. So yes, to all of your question, it's a comprehensive reform effort that has to recognize these inequities. And it's everything from indigent legal to a better way of sentencing, to a conviction integrity unit that protects the rights of the innocent, and post-conviction reform, among other things. Thank you for the question.
And thank you for the answer, Representative Evangelos. With that, I don't think we have any more committee questions. Our first speaker today is Olivia Hochstadt. And Olivia, I've brought you onto the panel. I hope that you are able to unmute and activate your video, and then you can proceed with your statement as soon as you're ready. Welcome to the Judiciary Committee.
Good morning, everyone. I'm Olivia Hochstadt, and I'm going to be reading Brad Chesnell's testimony today. Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Brad Chesnell. I live at Maine State Prison. I'm speaking in support of LD 842, an act to reestablish parole. My eyes water typing this. Thank you. Thank you to all of you in this room. You give me hope, direction, structure, and overall comforting thoughts. With this proposal, Maine people are doing what I learned to do growing up. They are supporting their family, friends, and neighbors. If you do wrong, there are consequences, but if you've taken the time to work on your inner self, there will be a time to present that change. LD 842 would give us that opportunity. Again, I thank you. No matter if this goes through or not, all of you need to be appreciated. The number 4207 has been attached to my name since 1997, when I made a lot of bad decisions and didn't think about the repercussions of my actions. Today, I awake and look at myself in the mirror. My physical appearance has changed. I'm 49 this year. My age is showing. It's been a long road. Today, all I want to do is apologize for my actions against others and myself. At the age of 23, I was told I was no longer teachable. At the time, I had 2 charges with the law, a driving offense and an assault charge. That was followed by the charge for which I am now serving a life sentence. If you can envision a long corridor, empty and white, a light sound of chain hitting the floor, a young man being escorted in full chains, one grown man behind him, a fist in the back, one grown man on each side, walking me, not me walking. They are walking me. Turn the corner and I am pushed into a room. I am made to kneel on the cement bed, head pushed against the wall. Chains are coming off, clothes come off. They hand back the boxers. Told to stand at the back of the room. The grown men leave, slam the door. The hole in the door opens. The grown man says, "You'll earn the rest." Hole slams shut. No mirror, only silence. Watery eyes coming on, thoughts are going crazy. Today, I think of others first. My heart tells me I have to, and I follow my heart. I have to repair others in order to repair myself. The word discipline comes from disciple, someone sent to another to become teachable. Since learning that, I have begun to really absorb as much knowledge as possible. I have to prove to others I have become teachable. Now I am an instructor. This year, technology has allowed me to talk to my son. I have not seen him since he was 2. He's 27 now. I am so grateful for technology. I spend a lot of time reflecting. I'm hoping that today is the beginning of a chance to earn freedom back. Thank you for listening. Stay safe, and may God bless all of you. Brad Chesnell.
Thank you. Thank you very much, Ms. Hochstad. And since she was speaking on behalf of another, I think it's not appropriate to open up for questions. So committee members will move on to our next person. And again, thank you for joining us this morning. And next we have Representative Pluker, who is going to join the panel in just a moment.
Thank you very much, Senator Carney, Representative Harnett, and the entire committee of the Judiciary. I'm a co-sponsor of this bill, but today I'll be presenting testimony for Foster Bates, who is a resident at Maine State Prison, who is the president of NAACP, and we're going to take care of that dog in a second. President of NAACP inside Maine State Prison, and he advocates in a daily way for the people who live there, and as Representative Evangelos mentions, puts himself at some risk in doing so. His testimony begins, parole is a fundamental privilege that allows eligible Maine Department of Corrections residents to reintegrate back into society and become productive citizens. Please be cognizant of this important fact that parole does not imply early release from a court-ordered sentence. Parole only changes the final term of where the sentence can be served while still in the custody of the Department of Corrections. Parole does not reduce a prison term. When an MDOC resident is on parole, he or she does not earn any good time deductions to shorten their length of their court-ordered sentence. Parole is continuing custody under strict restrictions imposed by the Maine Department of Corrections and Maine Parole Board. LD 842, an act to reestablish parole, was structured on the guiding principles of positive reintegration, rehabilitation, treatment, education, vocational, and job training. These evidence-based core principles have successfully helped parolees nationwide become productive citizens and avoid reoffending. The importance of reestablishing parole in the state of Maine is threefold. One, it will significantly reduce the cost of incarceration, which is approximately between $50,000 and $55,000 a year, $50,000 to $55,000 a year per individual in the Department of Corrections. And my own personal note here is that number does range between maximum security and minimum security, but he's accurate for where he is living at Maine State Prison. This cost does not include the cost of housing an elderly resident, which is roughly around $65,000 per year and up depending on what sort of treatment they need. Maine has the 8th highest percentage of an elderly prison population in the country, which is with a staggering 15.2% of the population over 50 years of age. Allow me to put that in perspective. In 2011, Maine spent $17 million on residents' health care, $8,000 per resident, an increase of 16% from 2007, and has increased every year since. LD 842 will considerably alleviate the cost of incarceration by potentially reducing the MDOC's budget by tens of millions of dollars over the course of years, especially in housing, food, and medical expenses. Parole, when properly implemented, converts a class of citizens from taxpayer burdens into productive tax-paying members of society. 2 of his 3 points. Parole will increase public safety with direct supervision by MDOC residents who are eligible parolees. LD 842 mandates that all parolees continue rehabilitation and treatment programs, maintain employment, and/or receive education, vocational, or job training. The bill also assures that parolees have acceptable living arrangements. This type of monitored structure will increase public safety and successfully reintegrate MDOC residents back into society. And his 3rd point, LD 842 will also incentivize and encourage MDOC residents to receive and complete evidence-based treatment programs that lead to rehabilitation. This positive incentivization will significantly reduce Maine's high recidivism rate of nearly 70% and will help to build meaningful partnerships and bonds between parolees and their community. Simply put, an act to reestablish parole provides the necessary rehabilitation and treatment programs to improve the quality of life for MDOC residents while incarcerated within the community as parolees. Instead of searching for reasons not to pass LD 842, state representatives and senators should come together in a bipartisan manner to find common ground to institute criminal justice reform in Maine, beginning with the abolishment of the 45-year ban on parole. Whatever the circumstances that led to the ban in 1976, it is time to put the past behind us, adopt a new parole system that is focused on rehabilitation and treatment. Does anyone even remember why parole was abolished in 1976? Please take a moment to think about the following question. Does Maine truly believe?
Representative Pluker, we really appreciate you providing this testimony today. We have a 3-minute limit and it's been passed for a while. Could you please wrap up?
Yes.
Thank you.
The country is marching forward with criminal justice and prison reform, and Maine should be the drum majors in this progression. Respectfully submitted, MSP NAACP President Foster Bates. Thank you very much, committee, for your indulgence. I appreciate it.
Thank you, Representative Pluker. And again, I think it's not appropriate to ask questions at this point, although Representative Pluker is a bill sponsor. So I guess I'll check in with committee members. Does anyone have a question for one of the bill co-sponsors? I'm not seeing any. Thank you very much, Representative Pluker.
Thank you all.
And the next person speaking in favor of this legislation is Representative Rachel Talbot Ross, who has joined us. Welcome, Representative. You can proceed whenever you're ready.
Thank you. Good morning. Thank you, Senator Carney. Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Rachel Talbot Ross, and I represent House District 40, which comprises the neighborhoods on the peninsula in Portland. I want to thank you for the opportunity to testify in support of LD 842, an act to reestablish parole. As you have heard through the sponsor, Maine became the first state to abolish parole in 1976. 16 states, including Maine, abolished or severely cut back on discretionary parole at the end of the 20th century. When Maine abolished parole in the 1970s, the country was undergoing major sentencing reform, leading to mass incarceration. During this time, determinate sentences was introduced, which created fixed prison sentences that could not be decreased. The only exception was the allocation of good time, which could be revoked. In the 1980s, truth in sentencing was established, eliminating many parole programs and good time policies. This tough on crime era created an immense growth in our prison population, as well as significant disparities among our communities of color, which still sadly exist today. While the United States makes up 5% of the global population, it accounts for a quarter of people incarcerated. The United States still incarcerates its citizens at a rate of 5 to 10 times higher than other industrialized countries. Some 2.27 million people were incarcerated in jails and prisons across the country in 2017, a 500% increase over the last 40 years. The number of people in prison sentenced to life reached a record high of 206,000 people by the year end of 2017. 1 in every 7 people in prison is serving a life sentence. The Sentencing Project found that 2/3 of the people sentenced to life in prison are people of color. A data analysis revealed another troubling trend. The rate of women's incarceration has been rising at a rate 50% higher than men since the 1980s, and declines in incarceration rate for women has been slower than for men. As of 2018, there were over 2,300 people incarcerated in Maine's prisons. No one convicted of a crime before May 1st, 1976, as you have heard, is able to qualify for parole, and we believe there are only 4 people on parole in Maine. Currently, Black Mainers, as this committee has heard numerous times, are 6 times more likely to be incarcerated than white Mainers. Black Mainers are 6 times more likely to be incarcerated than white Mainers, and it has nothing to do with criminogenic behavior. According to the U.S. Sentencing Commission, Black defendants generally receive longer sentences than their white counterparts for the same crime. The lack of a fair restorative parole process in Maine disproportionately affects people of color. In Maine, a Black, brown, or Indigenous person can still be tried by all white judges and all white juries. Parole provides hope and opportunity and incentive for people who are incarcerated. Reestablishing parole will greatly improve our correctional system, offering incentives for good behavior and growth while incarcerated. This bill incorporates the concepts of positive reentry parole, creating an easier transition for people who are incarcerated back into their communities. Maine currently has a prison system where punishment is the only purpose. The reestablishment of parole is a first step to a fair correctional system that prioritizes rehabilitation. I will end by stating my unequivocal support for Representative Evangelos and his call for residents in our correctional facilities to be able to offer live testimony, as well as my unequivocal, unwavering support for Maine State Prison President Foster, President of the NAACP, Foster Bates, and the questionable disciplinary charge he just recently received. I will note for the committee that there have been several written testimonies submitted by residents of the correctional facilities in support of this bill. And I hope that you will approach those testimonies, read those testimonies that have been submitted with an open heart and an open mind, because it is of little doubt, as Representative Evangelos courageously reminds us, that here in the state of Maine, this administration does not support parole. This is an uphill battle. This is going to take all of us. This is going to take a lot of courage. We need to match Representative Evangelos in his courage and his brilliance in defending freedom and justice. We need to meet Representative Evangelos where he is at. So I hope that the honorable members of this committee will approach this again with an open heart and an open mind. The individuals that Representative Evangelos mentioned this morning, and many, many more, are human beings, and we need to treat them with all of the humanity we can. Thank you, Senator Carney, for the time frame, and I hope that you all take this bill very seriously and hear our strong support. I am a co-sponsor of the bill. Thank you very much.
Thank you, Representative Talbot Ross. Committee members, are there questions for Representative Talbot Ross? I'm not seeing any, but I did have a question for you, Representative Talbot Ross. You noted that the increase in incarceration in women that's occurring nationally. Do you have figures on the rate of increase of women being incarcerated here in Maine?
Thank you, Senator, for the question. I do not. I can make sure that you have that for the work session. I know that, you know, the one shining light in all of this is that the Maine Department of Corrections has taken very significant steps to reduce the female population here in our state. And I think our numbers are dwindling, in fact.
Could you please share with us what they're doing to reduce the number of females incarcerated?
I do not have a specific strategy that they're using. I know that some of it really is about the number of programs that they're offering for women. We do have a women's reentry center in Wyndham, as you know, and a lot of that can be attributed to the director, Amanda Wolfall, that she really takes an individual approach to each and every resident and tries to work on a rehabilitation and a reentry plan from the moment that they arrive. So some of this is just the good heart of that director, making sure that the women there have opportunity for advancement. So I will inquire as to specific programs and get you those numbers for your work session.
Excuse me, thank you. Yeah, I'm just thinking about the progress being made with regard to women being incarcerated and hoping that we can do it for everyone. Thank you very much.
I join you in that. Thank you for your time.
Committee members, any additional questions for Representative Talbot Ross? Not seeing any. Thank you for being here today. And the next person who will present to the committee is Mark Brown, and I am moving him over from the attendee space. And as we are waiting for him to join us, I would ask those in the attendee space who are here to speak in support of this legislation, in support of LD 842, to please raise your electronic hand, and please keep it raised until after you've presented your testimony. Thank you very much. Mr. Brown, thank you for joining the Judiciary Committee this morning. You may not have been present when I said this, so I'll just remind you, we have a 3-minute limit on testimony, and I'll show you the timer when we're about 15 seconds out. And with that, you can proceed whenever you're ready.
Thank you very much. Can everyone hear me? Okay. Before I start, I'd like to ask a question to the board. Well, actually, before I start, I want to thank all the representatives of the Judiciary Committee for your service, not only on this bill, but to all of our residents of our state. I highly respect what you do. A quick question is, could someone tell me what the current recidivism rate in the Maine State Prison is?
Mr. Brown, this is an opportunity for you to present to the committee. It's not an opportunity for you to question the committee. And I would just encourage you to abide by the procedures of our legislative process and proceed with your testimony, please.
I will. Thank you. This is the first time I've been involved with something like this, so I apologize. Before you can fix something, you have to admit that it's broken. And I know that this is a parole bill, but it really, truly is a recidivism reduction bill, in my opinion. The recidivism rate in the state of Maine is essentially 6 or 7 out of 10 inmates reoffend and come back to prison. My son's name is Brandon Brown. Brandon committed a crime 12 years ago and has been incarcerated since. And I want to bring on a tale of 2 inmates, if I will. 3 minutes is impossible, but I'll do my best. Inmate 1 and inmate 2 have the same sentence, committed the same crime, and they're both incarcerated in the state of Maine. Inmate number 1 volunteers on a regular basis. He's a tutor. He's a mentor to other prisoners. He's part of the hospice program. He's a dog trainer. Inmate 2 plays cards and sweeps floors, sometimes polishes handrails. Inmate 1 continues with his volunteering and gets his associate's degree. Inmate 2 continues not being involved in anything whatsoever, but is keeping his nose clean and staying out of trouble. Inmate 1 continues on with his education and gets a bachelor's degree. He continues from there and becomes the first inmate in the state of Maine to get a master's degree. He continues volunteering. Inmate number 2 plays dominoes, plays cards, works out, sweeps floors, while inmate number 1 applies for clemency. After all that he's done in 10 years, he has the support of his victim. He has the support of state representatives. He has the support of an acting district attorney, college professors, business owners, people who don't even know him. He goes through the clemency process, hoping for transparency, accountability. He holds himself to that. The people who support him, including his victim, say that he deserves to be released early. Inmate number 2 continues doing nothing. We go to the state clemency board. We have a 3.5-hour hearing where there's all sorts of support. It goes to the board, who does not publicly state whether they support it or not, and I'll wrap up very quickly. Then it goes to the governor, who decides that clemency should not be given to inmate number 1. No reason is given to the public of why that decision was made. There's no transparency. Meanwhile, inmate number 2 continues to do nothing.
Mr. Brown, I'm very sorry to interrupt you, but we do have a 3-minute limit. Let's let committee members ask you questions. Perhaps somebody can ask you a question related to the remainder of your testimony. Representative Harnett.
Thank you, Madam. Excuse me. Thank you, Madam Chair, and thank you, Mr. Brown, for being here. I've had the opportunity to meet your son and to talk with him about his series of accomplishments and his recognition of the horrible mistake that he made when he was a young man. You in your hypothetical about inmate number 1 and inmate number 2, regarding the fact that disparate behavior and accomplishments while incarcerated result in the same period of punishment, the same period of jail time, do you think that if there were a parole system, that not only would it benefit people like your son, who have done as much as they can to improve themselves and to ready themselves for reentry into society, do you think it would also incentivize or provide incentive to people like inmate number 2 to do more of that, rather than knowing that it didn't make a difference what he or she does in terms of improvement?
Unequivocally, yes, it would make a difference. My point being is the inmate 1 and inmate 2 get the same amount of good time. So there's no difference between inmate 1 and inmate 2 in the Department of Corrections philosophies.
Thank you, sir.
Representative Moriarty.
Thank you, Madam Chair. Mr. Brown, I just have a question, and I wonder if you can educate me on one point. I may have misheard it earlier. Does the Clemency Board have the authority, in fact, to grant clemency, or does it merely have the authority to recommend clemency to the governor?
It's my knowledge that they only have the ability to recommend clemency to the governor, and the decision lies in the governor's hands, if I'm correct on that.
And is an award of clemency distinct from a pardon?
It's very different. A pardon is done, I believe, after someone has been released from prison and their crimes are pardoned, where clemency is involved with someone who's still in prison and looking to get out early. In my son's case, it was to attend PhD classes at George Mason University.
Okay, thanks for your answers. That's helpful.
You're welcome. Thank you.
Committee members, any other questions? Representative Libby, go ahead.
Thank you. I apologize for the technical issues that make it impossible for me to raise my electronic hand. Thank you for being here today, Mr. Brown. I don't really have a question. I just wanted to say thank you for being here. I found it very compelling and very helpful to hear the story of inmate 1 and inmate 2. And if there is a little bit of a tail end, I would be happy to hear that.
Well, thank you very much. It's literally impossible to speak for 3 minutes to get my point across, and I apologize for that. I'd be available for an hour or for a day or for a week. If you need that time, I'm happy to provide it. It's quite simple. The system is broken, and we have to admit that. We have to look at the numbers. And really, that should be the first thing before you even think about approving or not approving a bill, is to look at the numbers. And the Department of Corrections in Maine is failing. They're getting failing grades, and there's many reasons behind that. And I actively support parole because you need incentive to have people understand the process of healing.
Thank you very much, Mr. Brown.
Thank you.
Thank you, Representative Libby, as well, for helping Mr. Brown conclude his testimony. Mr. Brown, thanks for joining us today. Representative Newell has a question as well.
Thank you, Madam Chair. Good morning, Mr. Brown. Thank you for being here. I think you were running along the timer at the time that I heard you possibly state that there was no reason given following the clemency hearing. Did I hear that correctly? Or could you clarify that for me?
Yes, thank you for the question. That is correct. Not only was there not a public reason given, but no reason was given to Brandon and no reason was given to myself. So the decision was simply no, and there was no reason behind it.
Thank you, Mr. Brown. Thank you, Madam Chair.
Thank you. Any additional questions for Mr. Brown, committee members? Not seeing any. Thank you once again, Mr. Brown, for appearing before the committee today.
Thank you very much.
You're welcome. And I just wanted to make a note for those who are testifying with regard to this bill. The 3-minute time limit is, I know, difficult for a lot of people. It does ask you to just speak for 3 minutes. Part of the reason we have that rule is because committee members will have questions for those who are speaking, and it really assists the committee members to have an opportunity to hear from members of the public and then to really focus in on the questions that we have. So we do really appreciate you fitting your testimony in within the 3 minutes. And again, it's not intended to be a harsh rule. It's intended to really help us focus the committee hearing. So again, appreciation to everyone for working with that. And Mr. Lehman, welcome to the Judiciary Committee, and you can begin your testimony whenever you're ready.
Thank you, and good morning, Senator Carney, Representative Harnett, and distinguished members of the committee. My name is Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition. Our goal is to promote restorative practices in order to increase public safety and the health of the community. I'm also a sociologist, a criminologist, and a tax-paying citizen of Maine, and the vice chair of the Maine Prisoner Reentry Network. And every piece of this background leaves me to support this bill and urge you to find a way to reinstitute parole. In 1983, Don Anspach and I conducted research on the abolition of parole in Maine. The research was sponsored by the National Institute of Justice. We found that abolishing parole increased the number of people in prison because abolition increased sentence lengths and increased disparity among sentences. In addition, abolition took away a source of hope and an important correction management tool that I believe has led to increased recidivism. By 1979, the Department of Corrections itself was actively pushing for reinstatement of parole because abolition didn't work. We believe there are 4 compelling reasons to reinstitute parole, and I've outlined those in my written testimony. The key to these is the positive effect parole has on programming, reentry, and recidivism. And it also would be a budgetary bonanza. Corrections programs work. They help us reduce the numbers that come back. And the incentive of possible parole will be able to increase the number of inmates taking advantage of these programs. The arguments against parole seem to come down to the fact that we will make mistakes. We will. Inevitably, we will parole a few who should not be paroled and who will reoffend. In all honesty, we release people who reoffend. First, I want to tell you that corrections staff, the officers and staff who work with prisoners every day, have a pretty good idea about who is simply hustling the system, who are the cons. And parole boards tend to listen carefully to those insights. Secondly, I would remind you that these people are going to get out sometime. They are going to be back in our communities, whether we reinstate parole or not, whether we like it or not. Parole gives us a better chance to make that reentry successful and productive for both the inmate and for our communities. We strongly urge you to vote ought to pass on LD 842. Thank you very much for your attention and support, and I would love to answer questions that you might have. Thank you.
Thank you very much. Committee members, are there questions for Mr. Lehman? Go ahead, Representative Harnett.
Thank you, Madam Chair, and thank you for being here today, Mr. Lehman. In your testimony, you stated that you conducted research in 1983 about the impacts of the abolition of parole.
Yes.
And you were able to establish that it increased sentence lengths and increased disparity among sentences. And
yes, I did.
And then you said you believe that it led to an increase in recidivism. Do you have data that demonstrates that has recidivism increased? The level of recidivism, has it increased since 1976 in the state of Maine?
The problem with recidivism is that the way people measure it changes over time and place, and we don't have good data from before 1976. We actually don't have very good data after 76. It's only recently that we have reasonable data with the department's return to custody rate. And the only good thing I can say about return to custody rate is that we know it, it's precise, and it's comparable among, you can compare from state to state. But it's a lousy measure of recidivism because it only says how many people did we release from the prison who are back in the Department of Corrections in 3 years. It doesn't say how many of them are successful. It says how many of them are actually back in prison or back in the custody of the department. So, you know, it's good and it's bad, whatever. But even at that rate, it's 30%. Even at that rate, it's almost 1 in 3.
Thank you very much, sir.
Committee members, are there additional questions? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Mr. Lehman, can you give us some insight into the operations of the Executive Clemency Board?
No. The Executive Clemency Board, I can tell you what we all know, which is that there is one, and that the governor doesn't have to accept their recommendations and doesn't have to give a reason.
Well, I guess what I'm asking is, does the board itself function fairly, meet frequently, meet upon request? I know very little about it.
Are you talking about the parole board or the
No, the Clemency Board.
I have no idea.
Okay, thanks.
My, yeah, I can guess and you can guess, we can all guess, but the fact is that it's pretty much a hidden process. And it has never, and they've never granted clemency. It's very different, it was, I can tell you a little bit about how it came about though.
Mr. Lehman, I'm sorry to interrupt, but the Clemency Board is related but slightly different. And that is something that we could have some information at the work session on, Representative Moriarty, if that would be acceptable to you.
Yes, I'd like to learn a little bit more about it. Sure.
Yeah.
I wanted to just note that in 1975, when this was being put together and the code was on the one hand, and then the question was the sentencing, that Maine decided not to do determinate sentencing, at least in our terms, just flat sentencing, but it did institute some things it thought would help to mitigate that, and the Clemency Board was one of them. The clemency provision was one of the things it was hoping would take care of those extreme disparities and those cases of discrimination. And obviously it hasn't functioned to do that, but that was in fact the conscious and stated intent at the time.
Thank you. Yeah, thank you for including that information, Mr. Lehman. Committee members, any additional information for Mr. Lehman?
Thank you all very much, and I wish you a good morning.
Thank you so much for being here. And Ms. Hilton, you have joined our panel, and you're welcome to begin your statement whenever you're ready.
Thank you so much. Did I hit the right button? Can you hear me?
We can hear you just fine.
Okay. Thank you for bumping me up in the line. I do have another meeting I have to get to. I wanted to make sure I had the opportunity to speak for my brother, especially since he wasn't allowed to speak for himself today. And on that note, thank you, Representative Evangelos, for speaking up for Leo, for Brandon, and for all the other present residents who can't be here today. My name is Cologne Thaswer Rosie Hilton. I'll be brief. I'm cautiously hopeful that this bill could actually change my family's lives, as well as enrich Maine's community. Leo Hilton is my baby brother. He's been incarcerated for the last 13 years. He's currently set to serve another 27 years behind bars at the Maine State Prison. My brother was arrested a few short months after reading the eulogy at our father's funeral, and unfortunately caused additional heartache to our already grieving family at that time, as well as his victim. Our hopes for the future collectively dimmed when he was sentenced, and we all lost hope completely for a while in those long years. Leo has worked diligently to rise from a truly dark place. He's now a light in this world again. He has educated himself continuously. He's currently in progress towards receiving his master's degree for restorative justice. He's dedicated himself to mentoring and advocating for other members of the prison community. He served on that Maine State Prison Hospice program. He writes a monthly column for the Mainer to inspire the public. He works respectfully with prison and state legislatures towards a brighter future for all of us. On a very personal note, it's all personal. But Leo is a loyal and loving son, brother, and uncle. He provides us all with priceless advice and emotional support. I want for my brother to be a part of the community, not just so his family can enjoy time with him, real time again, not just so our aging mother can hug her youngest child as a free man. I want, and we all need, for Leo to be a part of the community so that he can share what he has learned and make Maine a better and safer place to live. Leo's endless drive, his focus on recidivism, and solid plan of community action make him a shining example of the positive change that this bill can bring to our home state. I really appreciate all of you for attempting to correct this failure in our correction system. That's all I have.
Thank you very much for being with us today, Ms. Hilton. We appreciate your testimony. Committee members, are there any questions for Ms. Hilton? Not seeing any, and once again, thank you for speaking with us today.
Thank you. I apologize for being so emotional. I do have to step out early from the meeting in a few minutes, but I'll be keeping an eye on the results. I have faith in you. Thank you.
Thank you. Next, we'll hear from Jeremy Pratt. And while we're waiting for Mr. Pratt to join us, I know that additional committee members have joined since we did introductions. And so wondering if Representative Libby and Representative Thorne can please introduce themselves.
Good morning. My name is Laurel Libby, and I'm state representative from District 64, which is part of Auburn and all of Minot. And I will keep myself on mute much of the morning so you don't hear my children in the background.
Representative Thorne.
Good morning. Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in beautiful Penobscot County. Thank you.
Thank you both. And Mr. Pratt, welcome to the Judiciary Committee, and you can proceed with your remarks whenever you're ready.
Thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jeremy Pratt. I'm the Vice President of the Maine Association of Criminal Defense Lawyers. MACDL supports LD 842. Parole has many benefits. It reduces prison populations. It gives inmates hope. It encourages growth and development in inmates, and it encourages good behavior. It offers supervision and support of released inmates. It should be noted that there is no form of supervision for people who are released from sentences of murder currently in the state of Maine. And it provides a safer correction experience for inmates and staff. MACDL supports parole in concept, but has concern regarding its implementation. At one time, Maine and many other states had parole, but abandoned it for a variety of reasons. We hope this committee can learn from the past mistakes of Maine and other states. MACDL is concerned that sentences will increase because judges will know that parole is a possibility. This is an unfortunate reality of parole in many jurisdictions. Some safeguards should be built in to prevent the inadvertent increase of sentences. Additionally, we are concerned that sentences will increase if the parole board is not made up of a diverse group of stakeholders appointed by all three branches of government. MACDL requests that individuals seeking parole should be given court-appointed counsel. MACDL does not support section 5824 sub 1 subcapital B, which allows for victims or victims' families to provide testimony at parole hearings. Parole should focus on reform of the individual, not relitigating the original case. Additionally, MACDL would like LD 832 to be clear what the presumption is at a parole hearing. Is it the presumption that the individual will be granted parole, or is it that parole will not be granted? What is the standard for making those decisions? This is not currently clear. Despite these concerns articulated, MACDL remains very excited and optimistic about the potential return of parole. There must be some pathway for early release for individuals who are currently incarcerated. We would request to be part of any work session on parole, and we would welcome the opportunity to work with all stakeholders and legislators on this very important issue. And we are very thankful for Representative Evangelos for bringing this bill forward. Thank you, and I'd be happy to answer any questions.
Thank you very much, Mr. Pratt. Committee members, are there any questions for Mr. Pratt? I am not seeing any, and with that, we will return you to the attendee portion of the meeting. And Representative Babbage, thank you for joining us. Do you want to do an introduction while I am bringing in our next speaker?
Absolutely, Madam Chair. Thank you very much. My name is Christopher Babbage. I represent House District 8, which is part of the town of Kennebunk. And I've been busy in the Committee on Education, and I am glad to return. Thank you.
Thank you very much. And we've been joined by Al Cleveland. And you, welcome to the Judiciary Committee. Please proceed when you're ready.
Hi, thank you everyone. My name is Al Cleveland and I'm here reading testimony on behalf of Ryan Hopkins. Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Ryan Hopkins and I've been incarcerated since 2004 and I'm speaking in favor of LD 842. During my time at the Maine State Prison, I noticed a significant change in the culture beginning when Randall Liberty became warden. He used a more progressive approach to incarceration that focuses on health and wellness rather than punishment. Randall Liberty is now the Commissioner of Corrections and Punishment. Matthew Magasin is the current warden here at the Maine State Prison, and he's continued to provide the positive transformation to the prison's approach to rehabilitation. At some points, the majority of inmates will be released into Maine's communities. Reintegration into society is not just a criminal justice and convicted criminal issue, but it is a public health issue. Reintegration of healthy individuals back into society is what the justice system should strive for. Communities are safer if individuals are treated rather than punished. Extreme long-term incarceration causes inmates to become institutionalized, a disease that gives individuals the impressions that they're alien to a free world. This cannot be healthy for our communities. People should be released after they are well so that they are not released with new health issues caused by long-term incarceration. Most people who are incarcerated had some underlying issue prior to their incarceration. In the state of Maine, these issues were taken into consideration at the time of sentencing. The Maine State Prison has a comprehensive agenda that is focused on treatment. Inmates are not given wellness, but they have to work hard to achieve it. A major aspect of treatment is evaluating why the person causes harm to others. The reason is often rooted in childhood trauma or being marginalized in society. Communities do not benefit if those who have been rehabilitated and could contribute to society continue to be incarcerated. The goal is crime prevention. The formerly incarcerated must partner with the criminal justice system so that we as a community can better recognize and treat issues in society before it leads to crime. There are many people in Maine's prisons that I'm confident can make a difference, but they cannot make a difference if they're locked up in a cell. Keeping the rehabilitated locked away only places a burden on the state. We are dependent on the state to provide for all of our health, rehabilitation, and basic necessities of life. Long-term sentences only make people dependent on the state upon the state even after we are released. Let us loosen this burden and trust the progressive form of rehabilitation that our wardens and commissioner have worked hard to implement. Communities in Maine suffer from crime. Give us a chance to partner with our justice system and make Maine a healthier, safe place for everyone. We want to help. Sincerely, Ryan Hopkins.
Thank you very much, Ms. Cleveland. Committee members, are there any questions? Not seeing any. Once again, thank you for appearing before the committee today. At this point, committee members will take one more proponent of this legislation, and then we're going to alternate and take those who wish to speak in opposition, and then neither for nor against, and then we'll return to the proponents. And so with that, I think our next person in line is Jan Collins. So I'll move Ms. Collins over to the panel. Welcome to the Judiciary Committee, Ms. Collins, and you can proceed when you're ready.
Thank you so much. Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jan Collins. I'm Assistant Director of Maine Prison Advocacy Coalition, and I'm here to support LD 842, an act to reestablish parole. I am also the parent of a son who's incarcerated at Maine State Prison, and that has changed my life. Maine made a mistake in 1976. It did away with a system that worked and traded it for one that contributed to increasing incarceration in Maine by 400%. It took funding away from reentry programming in favor of walls and bars, increased our recidivism rate, and has steadily expanded the number and percentage of geriatric patients held behind bars. This is despite decreasing crime and decreasing arrests in Maine, and at the expense of family, community, and state budgets. The financial costs have been staggering. The cost per inmate provided by Maine's DOC in committee hearings this session is $73,000 a year. The cost to maintain aging inmates is estimated to be about 2 to 5 times greater than that. Double the cost would be $146,000 a year. Multiplied by 5, it would be $365,000 a year. In 2018 to 2019, the average per pupil cost in Maine was $12,000, $442.95. The savings from placing just 10 to 20 geriatric inmates on parole would pay for 120 to 560 students attending public school for a year. It is clear that it is the legislative prerogative to define crimes and sentences, the judiciary's prerogative to make and modify sentences, and the executive's to commute. Both federal courts and state courts around the country have ruled that a legal judgment can be revisited. I include case law in my addendum. That is, in fact, what parole is. It is an opportunity to leave a sentence open for review, to consider the future, to assess rehabilitation. When our criminal justice system does not consider the rehabilitation of inmates, our communities pay the price. We waste resources that could be used to prevent future victims, resources that could be used for rehabilitative and reentry programming, community mental health resources, substance use disorder treatment, after-school programs, and education. Please vote unanimously to reinstate parole. Thank you.
Thank you very much, Ms. Collins. Committee members, are there questions for Ms. Collins? I am not seeing any. Thank you once again for appearing before the committee today.
Thank you.
And at this point, we are going to put a pause on those who are the proponents, because we've heard a significant amount of proponent testimony, and typically we do some alternating when we have many members of the public wishing to speak on bills. And so I would ask those, actually I'm going to lower the hands of those who are in the attendee space and ask anyone in the attendee space who is here to testify in opposition to this legislation to please raise your hand and to keep it raised until you've presented your testimony. So again, anyone in the attendee space who wishes to testify in opposition, and I will bring on the Vicky Dill, who is joining us to speak in opposition to this legislation. It did not work. Hang on a second. Ms. Dill, welcome to the Judiciary Committee. It looks like you're in the process of joining our panel. Hi, welcome. Thank you for being here.
Thank you.
And if you could go ahead and present your testimony, and I think you probably heard it, but I'll let you know when the 3-minute limit is approaching. So go ahead, Ms. Dill.
All right, thank you. Thank you, members, for allowing me to speak today. I have sent this, you will have it in your files. I'm going to read what I wrote to you. This will get emotional for me. I am in opposition of this bill. My name is Vicky. I'm a survivor of murder. My sister Debbie was 18 years old and I was just 10 when she was murdered by a man with no regard to her life. He hid from the law for 15 years. That's 15 years. My family and I lived with fear and uncertainty about a predator on the loose, not knowing if he would strike our family again. The man who murdered her did this with intent and deliberation. This is not the type of person who should be considered for parole. The year of Debbie's murder was factored into his sentencing, and the inmate is allowed to ask for parole hearing every 5 years. This victimizes my family each and every time. We revisit her murder every 5 years. My family and I go through sleepless nights, fear, anxiety, nervousness, lack of eating, and trauma of that day every 5 years. This is very trying on our family and is cruel at best. Considering this legislation will just add unnecessary anxiety to more families should it be passed into law. When there's a parole hearing, my family and I brace for the pain. Attending a parole hearing is traumatizing for all of us. We have to travel to the prison, the inmate's house, pass through a metal detector, walk to the left of the yellow line, down a long, scary hall, into the bowels of the Maine State Prison. Traumatizing? You bet. Our nerves are on edge and headaches set in. This makes me feel very uncomfortable, and this process is completely unfair to us, the victim. We get to meet the parole board and beg them not to let the inmate out. This is what a parole hearing is all about, victimizing our family all over again. The nightmare just never ends for me and my family. After the meeting, it's now a waiting period for a call to inform us what the decision was, grant parole or deny. This process lasts a few hours and our nerves are on edge. There is no eating because our appetite has been taken away by anxiety. We are nervous and shaking, waiting on a phone call. When the phone rings, dread is present. Do we want to hear what the decision is? This is unfair to our family and continues to traumatize, and the continued traumatization is painful. Maine abolished parole in 1976. There was a decision and discussion made. This was what was best for Maine. It works and should continue to work. This legislation should not be voted into law. The undue trauma that I and my family go through isn't something others in the state should or want to go through as well. I hope you consider the impact of the families and the victims as you make your decision on this hearing. Being a victim is tough. Being victimized is wrong. I ask that you cast your vote ought not to pass on this bill. At the end of your day, you can throw all of this away. At the end of mine, I can't. Debbie's still gone. Thank you.
Ms. Dill, thank you very much for sharing your testimony with the committee today. I would like just to ask you when you're able to respond, if you could let us know. Typically we ask people to introduce themselves, including their residence, and if you could just give us that information, please.
Yeah, I'm sorry. My name is Vicki and I live in West Gardner.
Thank you very much. Committee members, are there any questions for Ms. Dill? I'm not seeing any. Thank you for being with us today, Ms. Dill, and presenting your testimony.
Thank you.
I'm looking again to those who are in the attendee portion of the meeting. If you are here to testify in opposition to this legislation, again, I would ask that you please raise your electronic hand. I'm not seeing any other hands raised at this time. And so I'm again speaking to those in the attendee portion of the meeting. If you are here and wish to testify neither for nor against this legislation, raise your hand. And we do have Ms. Ward Saxel who would like to provide neither for nor against testimony. I will bring you on to the panel. Welcome to the
Senator Carney, represent. Oh, thank you.
You can begin.
Okay, thanks. Senator Carney, Representative Harnett, members of the committee. My name is Elizabeth Ward Saxel. I'm here on behalf of Maine Sexual Assault Support Centers. For 20 years, I've stood in front of the committee next door, criminal justice, where parole has typically been heard, and testified against parole. But after many long conversations, both internally within our organization and with Maine Sexual Assault Support Centers, I think we have come to a place where we could see a parole system that we could get behind. We know that survivors of sexual violence have a wide range of views on incarceration. We've surveyed them, and it runs the gamut, right? And as a result, I also believe that that individuals can change their views about incarceration over time, and could certainly imagine a scenario where victim survivor supports parole for the individual who caused them harm. That said, the bill as currently drafted, we can't quite get behind. There are a number of elements that that we don't feel like are fleshed out well enough to create the kind of parole system that we would want to see as victim service providers, but believe that we might be able to get there, which is not a place that we've been in before. So we have concerns about the process for victim input, which of course you might suspect we strongly support and are grateful that Representative Evangelos included that in the bill, but also have a lot of questions about both how often the process would be repeated. You just heard from the last individual that every 5 years is really hard. 5 years is better than 2 years. And what happens when it's a child victim, for example? Is there an opportunity for a sort of an ex parte, a third party to weigh in on victim issues, et cetera? We also are concerned about the current structure for good time and whether good time would continue as it is without any modifications, with the opportunity for parole to be there. And that the way that we would want some consideration around that, we'd hope for some. Additionally, risk assessment has been mentioned. We're very interested in crime-specific risk assessment and need to do some more digging in there. And also are very aware that when parole was abolished, there was a lot more programming that was available. And so additional programming has got to be part of the mix, both pre-release and post-release. And so I'm afraid we support the idea of a study. I know Rep. Evangelos thinks that's where things go to die. I actually think we could come up with something that lots of people could get behind. I certainly have been part of study commissions that have enacted the work on the other side, and I believe this is a possibility here.
Thank you very much, Ms. Ward Saxel. Committee members, are there any questions? I am not seeing any raised hands. Thank you very much.
Thank you.
And thank you for providing the suggestions and feedback.
And we'd love to participate in the work session or be available to should you want to speak with us further.
We appreciate
Thank
that. Thanks. And that next we have John Pelletier. And Mr. Pelletier, welcome. And you can begin.
Representative Harnett, members of the committee, my name is John Pelletier. I'm the chair of the Criminal Law Advisory Commission. And I have thoughts similar to what Elizabeth expressed. For many instances, the commission took a position against reinstituting parole. At this time, our makeup, there are definitely our members and not only the defense attorneys who believe that prisoners should have an opportunity through behavior and self-improvement to be released from long prison sentences. Other members do not share that view. They feel that the criminal code was enacted. One of the principal reasons was to eliminate parole. And they also have concerns about the impact on victims of regular parole hearings for convicted inmates. And with respect to were parole to come back, there are questions with respect to applying parole to current sentences. Parole would lessen the sentence, so there's no danger of an ex post facto law, but there would have to be analysis of whether instituting parole would impinge on the commutation power because it lets people out early, although it does so pursuant to an executive branch decision. So there may not be, but that requires some study. Another issue is the interplay between the criminal code and people on parole. Most of the people, even serving long sentences in the prison, their sentences are followed by a period of probation or a period of supervised release. And there would need to be some study of what is going to be the interplay between parole and probation, or parole and supervised release. It's unclear how that would fit right now. And also, it did come up, our members felt that it would require a lot of resources to have a parole board that could handle the expected volume of work and staff so that the work could be done appropriately. And so we came down sort of where Ms. Ward-Saxel did in terms of suggesting further study. But I would say for those who've worked with our commission over the years that there is some movement with respect to the opinions on the big question of whether or not parole should come back. And with that, I'll end my testimony and be glad to answer any questions.
Thank you very much, Mr. Pelletier. Committee members, are there any questions for Mr. Pelletier? Not seeing any. Thank you once again. The next neither for nor against is Marie Hayden. And I just did want to alert committee members. I goofed with not recognizing people who had signed in with a telephone number. And so once we complete the neither for nor against, we're gonna go back and take two other people who are opponents, but who were not able to raise their electronic hands. Just wanted to let everybody know what to expect. Welcome, Ms. Hayden, and you can proceed when you're ready.
Hello, can you hear me?
We can hear you. Are you able to activate the video as well?
I'm not sure.
Okay, if you could, well, introduce yourself and let us know your town of residence.
Okay.
And then you can go ahead and you're
Okay.
speaking neither for nor against, right?
No, I am for, actually.
Okay, then I'm going to move you back to the panel because we are doing those who are speaking neither for nor against at this point. Let's see. We have two other neither for nor against, and so they'll be joining our panel. And Ms. Annis, if you could please activate your audio and video and begin your testimony when you're ready. And to those who are in the attendee portion of the meeting, we will in just a few minutes continue with those who are speaking in favor of the legislation. So just be patient and we'll ask you to raise your hands shortly. Ms. Annis, are you here to testify neither for nor against?
Yes, I am. Thank you.
Go ahead.
Good morning, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Jennifer Annis. I'm a member of the Maine Commission on Domestic and Sexual Abuse. I'm here today speaking on behalf of the Commission, neither for nor against LD 842. The Commission recognizes the need for criminal justice reform in Maine, joins in prioritizing this conversation, and believes there is much common ground to be identified. Commission members are aware of the need for Maine to address equity in the array of crimes that appear to stem from inability of offenders to access adequate substance use and mental health treatment. Nevertheless, the Commission recognizes that reestablishing parole will have a negative impact for many survivors of domestic and sexual abuse, as well as surviving family members of homicide victims. In the state of Maine, approximately half of all homicides in a given year are related to domestic violence. Perpetrators of domestic violence, sexual assault, and homicide are a large part of the population who are incarcerated and are among those who would benefit from LD 842. Reinstating parole would pose risk of future harm to survivors in the community and remove comfort in knowing the time of accountability for offenders is previously remedied by the truth in sentencing laws. Those serving time at the Department of Corrections already get good time credited off their sentence according to the good time statutes, and it can be approximated at the time of entry in the prison system. So survivors and family members will have some idea of the release date. If parole were reestablished, no such approximation could be made, leaving survivors and their families in constant fear. The current good time statutes prohibit domestic violence and sexual assault offenders from earning maximum amount of good time. LD 842 contains no such considerations. Many victims of domestic and sexual abuse don't come forward at all to report crimes against them for a variety of reasons, including concerns about their safety. The parole process would add an additional barrier to individuals coming forward at all. For those who bravely participate in the criminal justice process, this new bill would ask them to relive the experience each time the perpetrator had a parole hearing and each time there is an appeal. Survivors who want to address the parole board, if they are available or even still alive, have to take more time off from their life, healing, and recovery in hopes that it will keep the offender away for a bit longer. Should some version of parole be reinstated, equity considerations throughout the parole process should also be incorporated to safeguard against bias of people who are Black, Indigenous, people of color, and women. In addition, the Commission recognizes that most individuals who are incarcerated and released back into the community at some point, and the reentry process can be important to help those individuals lead successful and productive lives. Given that knowledge, we support a deeper look into supportive reentry services for incarcerated individuals, while also acknowledging the need to provide victims with certainty, information, and adequate time to prepare for the release of an incarcerated individual. Thank you.
Thank you very much, Ms. Annis. Committee members, are there any questions for Ms. Annis? Representative Reckitt, go ahead.
Hi, nice to see you again, Ms. Annis. I know that we were working together, I believe, when we worked to have the woman released from Wyndham, who was in there on a murder charge. And my question to you is, has anyone looked in the last 5 to 10 years to see whether there are any other such people who were, in my view, mistakenly sentenced?
I am not aware, Lois. I could definitely look into that and get back to you.
Thank you very much. I appreciate it.
Committee members, any additional questions? I am not seeing any. Thank you, Ms. Annis. And we've been joined by Ms. Mancuso, and you can begin whenever you're ready.
Thank you, Senator Carney. Good morning, Senator Carney, Representative Harnett, distinguished members of the committee. My name is Andrea Mancuso, and I'm here today on behalf of the Maine Coalition to End Domestic Violence and our member programs, neither for nor against LD 842. As we look at the possible impact of reestablishing parole on survivors of domestic abuse and violence, we believe it's important to lift up, as it is true for many of the other criminal justice reform proposals. And as Ms. Ward-Saxel noted, there are crime victims who would support a system of parole and others who would not. Despite this broad spectrum of perspective on the value and impact of incarceration, there's one thing that we know to be universally true. The overwhelming majority of those who commit crimes in name each year are people who will at some point again live in our communities. And we submit that we all need to do better at ensuring there are sufficient community supports to attend to that reality, regardless of whether this proposal goes forward or not. We'd encourage you to, at the same time you consider this proposal, also ask important questions around what type of rehabilitation and recovery supports would need to be bolstered alongside the reestablishment of parole to ensure that any available parole is achievable for Maine's incarcerated population, not only to be granted parole, but also to be successfully reintegrated into the community, because these are the things that are going to enhance safety in our communities long term. And most survivors would tell you that behavior change and a reckoning with the harm they've caused would indeed be the most meaningful outcome. We appreciate and share the beliefs of the sponsors in the capacity of many of those who have committed crimes to change, and also the desire to address the disproportionate impact of the criminal justice system on marginalized communities, specifically including communities of color in Maine and those impacted by substance use for whom the criminal justice system was the default community response. However, particularly for those who have used violence to cause harm, investment in recovery and rehabilitative supports, both within our facilities and within communities, must go hand in hand with decarceration in order to properly attend to the safety of the community and of the victim who was harmed. We also think careful attention needs to be put into mechanisms for appropriate and accurate risk assessment, as well as post-release monitoring and accountability upon reintegration, so as not to put that burden on the victim. With respect to the issues we see with this particular proposal, I would say ditto to the things that Ms. Ward-Saxel has already lifted up this morning. We would also encourage you to really consider the wisdom of an automatic 2-year renewal, as well as including as immediately eligible for parole anyone who is incarcerated regardless of the crime committed, particularly those convicted of homicide. This is an important conversation, and we are certainly happy to continue to be part of that and remain a very interested stakeholder in the outcome. I'm happy to address any questions that you have, including Representative Ricketts.
Thank you very much, Ms. Mancuso. I think I'll start by asking you if you could answer Representative Ricketts' question from earlier. And Representative Ricketts, did you want to re-ask the question? Go ahead.
Well, I do want to re-ask the question, but I also want to raise up something you said. I think that the whole issue of utilizing risk assessment, validated risk assessment tools would be an important piece of this process. But I am curious to know if you know any other cases that other than the one that I am so aware of.
I am not aware of any particular cases where that that has been attempted. However, I would note that a couple years ago, New York State implemented a Survivor Act that essentially created a path for women who committed homicide through the use of reactionary violence to have a path to readdressing their sentences.
Thank you.
Committee members, any additional questions? Not seeing any. Thank you very much for being before the committee today.
Thank you.
I'm going to return you to the attendee space. And then, as I said, there were 2 people who, for technological reasons, I wasn't aware were here to speak in opposition. So we're going to take those 2 people, and then we'll return to the proponents of the legislation. The first person to join us is Arthur Jett, and he should be appearing momentarily on our panel. And Mr. Jett, we can see that you've joined the panel. If you could activate your audio and video and begin when you're ready, please. Are you able to hear us, Mr. Jett? try one other thing.
FYI, his last name is Jetty.
Jetty, thank you. Thank you very much for that. This shows my technological insufficiencies here. Mr. Jetty, are you able to hear us? Mr. Jetty, are you able? Is this
Am I
Mr.
here?
Jetty?
Yes. Yes, it
Okay.
is. Are you hearing me?
We can hear you. We can't see you, but if you could just
That's okay. I don't have a camera.
oh, then that explains it. If you could please let us know your name and the town you're from, and then begin with your testimony. Thank you.
Sure. Just give me a second here. I'll be happy to. I did send a copy of the testimony, and I apologize for my technological limitations. So my name is Arthur Jetty, and I'm from Cambridge in Somerset County, and I'm ready to begin. Senator Carney, Representative Harnett, members of the committee. My name is Arthur Jetty from Cambridge in Somerset County. I lead the main chapter of the National Organization of Parents of Murdered Children, and I'm speaking in opposition to LD 842. I'm going to assume that everybody will have a copy of this testimony and will undoubtedly take the time to consider it. I'm going to just cut to the chase. I represent, the interests of people who have had their loved ones killed by the actions of someone else. Most of those cases are intentional homicides. And since 1976, Maine family members of victims of homicide have had the comfort of knowing that under the guidelines established by Maine's truth in sentencing laws, and particularly in cases where the crimes are so vicious, so heinous, and so purposeful that the equivalent of capital punishment, that is life imprisonment, is sometimes warranted. It's also true that since Maine's parole system was abolished, there have been approximately 900 more murders committed in Maine. You multiply that by the number of families, friends, coworkers, and communities who've been severely affected by murder alone. That amounts to thousands of individuals in Maine whose lives were severely shaken by the actions of a killer. With the truth in sentencing, life sentence provides the closest thing to a guarantee that such a murderous person capable of the most taboo acts will no longer be a threat to our society. And as leader of the group representing survivors of murder victims, I listen to countless families who say that this is the closest thing to justice that victims, and in the particular case of homicides, their survivors can hope for. There is no restitution or restorative justice for the wanton taking of another person's life. Now, there are many factors that the court considers before sentencing, and since 1976, sentences served in Maine have at least been close to the imposed sentence, except for the good time sentence reduction programs for those who have determinate sentences. Those convicted in crime already have a means for early release. It also seems to me that the public views parole boards as highly politicized through the appointment processes in states where there is parole, and including, remarks that have been made about our current parole board. Maine sentencing guidelines have weighted factors which have been proven themselves over and over since parole was abolished, as evidenced by the Maine Supreme Court decisions. I believe Maine is a safer place to live because of our current system, and I hope that we can keep it safe by rejecting this attempt. But for me, reducing a sentence by parole is similar to the story told by Abraham Lincoln, who, while recollecting his time as an attorney, said, "This reminds me of the man who murdered both his parents, and then when the sentence was about to be pronounced, pleaded for mercy on the grounds that he was an orphan." Now, I can only appeal to your sense of justice.
Just ask that you wrap up your
I will.
comments.
I will.
Thank you
I've
very
got
much.
a couple more sentences. I can only appeal to your sense of justice, hope that you will equate justice with innocence and righteousness. And let's not forget that the real victims are, as we look for possible remedies to injustices elsewhere. So sometime, somewhere, there needs to be a joint standing committee on victim justice. So on behalf of the survivors of major crimes, murder victims' families, I hope that this is the time and this is the place, and that you stand together as that committee on victim justice and unanimously vote ought not to pass on LD 842.
Thank you,
Thank
Mr.
you.
Jetty. Let's see if committee members have any questions. Committee members, are there any questions for Mr. Jetty? Representative Reckett, is your hand up for Mr. Jetty? No, okay. Representative Harnett, go ahead.
Thank you, Madam Chair. And Mr. Jetty, thank you very much for being here today, offering testimony and for the work that you do. And this is a difficult question to ask, but I do want to ask it. Does your opposition to parole extend to all crimes or just to homicide?
I don't think that the issue of parole itself, in and of itself, is a bad thing. I think it should be incentivized for individuals who are doing positive things for positive reasons to be able to become full participants in the society. What I am opposed to is the basic elimination of life sentences in those cases where it is already factors who have to be met in order for that to be a consideration under the Maine's sentencing requirements. There are multiple factors. There are, everybody who has a murder in their family is understandably wanting that person who took the life of somebody they love to pay for it with his or her own life. However, the reality is that it could be a sentence as low as 25 years or as high as life, depending on the factors, the circumstances under which the murder occurred, the vicious nature of it, the torturous nature of it, whether it was multiple murders. And so we abolished in Maine capital punishment or death penalty years ago. The closest thing that we can do to protect the society against the very most vicious members of it for the rest of us is to incarcerate some people for the rest of their life. And that should not be subject to parole. I mean, if the factors justify the sentence, then the sentence should be served regardless of what the sentence is. And so there's a lot of things we could be doing. We could be working on sentencing, the factors. We can tighten up a lot of things. We can incentivize. The good time thing could be not just for living and breathing every day and not stabbing somebody while you're in prison. You get your good time to be something that could be earned good time. There's a lot of things that people could do to help reform criminal justice programs. But let's not make the victims serve a longer sentence than the people who've been convicted of crimes against them.
Thank you, Mr. Jetty. I appreciate your answer.
Committee members, are there any additional questions for Mr. Jetty? I'm not seeing any. Mr. Jetty, I apologize for mispronouncing your name initially.
Oh, that's okay. No, I like it. I like it both ways.
All right. Thanks for joining us.
You can call me anything.
Thank you.
Thank you.
And then next we have Vance Gill, and I don't believe that he can join us with an audio, so we're going to try to connect him with video. With just audio rather than with the video. Mr. Gill, I believe that you are on the panel and that your audio is active. You can proceed whenever you're ready, beginning with your introducing yourself and letting us know the town you're from.
Okay, my name is Vance Ginn, and I live in Abbott, Maine, and I'm a board member of Parents of Murdered Children. I just want to tell you a bit of what my family went through when my daughter was murdered. We went through 68 days of hell because it was a 68-day search for my daughter's murderer. As far as spirits being broken, my family spirit has been broken for the last almost 6 years, and it will not regain itself. Parole cannot happen for the most violent people in our state. It's pretty much well assured that things like this will happen again. The murderer of my daughter was only off probation for 1 day when he murdered my daughter. Snuck in through her window at night and shot her 3 times in the back. The last time with her laying on the floor, already dead. Proceeded to run, took up an amount of dollars that we had to spend to find this man. And I could not live with the idea that my grandchildren, of which found my daughter, would ever have to live with the thought that the murderer of their mother would be able to walk the streets again. I can't ever have my daughter back. She will never be given parole. These most violent people, they have to stay in jail. The only way to protect the public is to keep them in jail. Either they stand a good chance of murdering, or what if a family member of the victim finally has had enough and they create a murder of the murderer? So now you have more murders being created by the passage of parole. I can't see how people could vote for it. It would cut my daughter's time, her murder's time in jail cut down, so he would get out at 61 years old. He would still have life left. My daughter has no life left, and she never will. And our family has to live with that forever. His family can still go visit, they can still bring him presents, and they can see his face. The only time I see my daughter's face is in a dream at night. I never see her walking the streets. I never get that call on my birthday. I never get that call on Christmas. That's about all I have to say, and I really hope that you overwhelmingly vote against parole. And I do want to thank everybody that is there for hearing me out. It's things that I've had inside for a long time. And that's about all I have to say.
Mr. Ginn, thank you very much for sharing your testimony with us today. I apologize for mispronouncing your last name, and we appreciate you being here.
I've been called that my last name since I've been a little kid, so no big deal.
Let me see if any committee members have questions for you. Committee members, are there any questions for Mr. Ginn? I'm not seeing any questions. Again, thank you for providing testimony to the committee today on this legislation.
Okay, thank you all for hearing me.
You're welcome. And now, committee members, we're going to resume with those who are speaking in support of the legislation. I want to check in with people and see if anybody would like to take a brief break. I'm not seeing a groundswell of support in favor of that suggestion. So for those who are in the attendee space, if you have not spoken in support of this legislation and you wish to present testimony, please raise your electronic hand and please keep it raised until after we have heard your testimony. And first we'll be joined by Representative Charlotte Warren, and I am promoting her to the panel. Welcome, Representative Warren. Please proceed with your testimony whenever you're ready.
Good morning. Thank you, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. My name is Charlotte Warren, and I represent House District 84, which includes the city of Hollowell and the towns of West Gardner and Manchester. And I also, as many of you know, have served on the Criminal Justice and Public Safety Committee for all of the 7 years that I've been in the legislature so far. And I'm here to testify in support of LD 842, an act to reestablish parole. And I'm not going to restate all of the data that you've heard today about the costs associated with unlimited incarceration or the issues around long-term care and hospice costs, etc. And I'm not going to take a lot of your time. I just ask that as you all are deliberating the question that Representative Evangelos has posed to you, that you ask yourself what the mission of the Department of Corrections is. And if the mission of the Department of Corrections is actually to correct Mainers, to help correct Mainers and then return them to our communities, I ask you to further think about, is time the measure of that corrections? So in my personal life, or my professional life, I guess I should say, I'm a social worker and a teacher. And I know that in my work, in both of those roles, somebody's development or change or learning, or you might even say corrections as a human being, it's not dependent on the time they're in my classroom or the time that I spend with them as a client. And I don't think that's true in our correctional facilities either. So if we believe that there's something other than time that grades when people are corrected, then really the only answer is there should be parole. And I hope that you'll consider that. You have a big decision here to make, and I hope you'll also take those thoughts in as you consider. So thank you. I'm happy to answer any questions that you might have for me.
Thank you, Representative Warren. Committee members, are there any questions for Representative Warren? Not seeing any. We appreciate you appearing before the Judiciary Committee today.
Thank you.
Our next door neighbor, as it were, when we're in the State House.
Yes, exactly. Thank you all.
And next we'll be joined by Ross Hilton.
Good morning. Ras, by the way. No
Ross,
offense.
thank you. You can go ahead whenever you're ready.
Thank you. Good morning, ladies and gentlemen. Particularly thank you to Mr. Evangelos for your work. As you may know, my younger brother is Leo Hilton, who has been a resident at the Maine State Prison for about 13 years now. And it overwhelms me sometimes how much folks like myself who don't spend a lot of time looking at legislation don't know that there's no parole available. There are so many, if my brother wasn't Leo, I wouldn't know that there was no parole. There's been this 45-year gap where there's been no hope. And I don't know how many of you know where Wayne is, but that's where our mother grew up, Susan. And she grew up there with horses with her father. And one thing that I heard a lot growing up was for horse training, you need both a carrot and a stick. A carrot to motivate the horse and a stick to drive them where they need to go. And to me, it seems that 45 years without a carrot and getting treated like a horse with just a stick is not enough for a human being to see a path forward, let alone to work for one. But Leo's working on his master's degree right now. He achieved a lot of educational steps forward whilst inside the Maine State Prison facility. I've met Brandon. He's a good man. There are good people in this who have gone through one of the worst places in their life, recognized the horror of their mistakes, and are now stepping forward and pushing to make changes for other people. Yes, absolutely. I want my brother outside. I want my mother to see her son before her deathbed. But more importantly, these are just two shining examples that we know of. There are so many of us in this state that don't even know those names, let alone the work that it takes to continue to push forward positively in an atmosphere that does not promote what you're doing or reward it at all. There are so many great examples there who I've personally met traveling back and forth to Warren. I live in South Portland. I make the trip. Well, we made the trip prior to COVID as often as possible so that we could maintain that connection and provide the type of hope that not everybody gets from inside those walls. Now, there's a gaping hole of information that you're all privy to that not everybody is. So please take the time, give us the hope that we need, and give us the benefit of the people who have made the effort to better society from inside there, and see what they can do out here with the rest of us. Thank you.
Thank you very much, Mr. Hilton. Committee members, are there any questions for Mr. Hilton? I'm not seeing any. And Mr. Hilton, I didn't realize you are a constituent, so I just wanted to extend you a special thanks for appearing before the committee today.
And again, to Mr. Evangelos for reaching out and staying in touch, keeping up with this. And please, obviously, there are people who are going to try to abuse any system that is put in place. But the overwhelming majority of the people who apply are going to be the ones that we want out here helping us. Thank you.
Thank you very much. Next, we'll hear from Kelly Taylor.
Good morning, and thank you for the opportunity to speak before the Judiciary Committee on a bill that I'm very passionate about, LD 842, an act to reestablish parole in Maine. My name is Kelly Taylor, and I live in South Thomaston. I'm a social studies teacher in Rockland and have been for nearly 40 years, having taught all subject areas in grades 7 through 12. So today I want to speak to you from the point of view of a teacher whose students write legislative documents and hold committee hearings and debate the pros and cons of their bills. And I ask, what makes a good bill? In the words of former President Obama, quote, "A good compromise, a good piece of legislation is like a good sentence or a good piece of music. Everyone can recognize it. They say, huh, it works. It makes sense," end quote. Reestablishing parole in Maine does make sense. In a government system where both the preambles to the US and the Maine Constitution list as a primary goal of government to establish justice, not having an active parole board does not make sense. The justice system's use of a parole board is a check and a balance against injustice and against one branch of government, i.e. the executive branch, having too much absolute power over such matters as reprieves, commutations, and pardons. A parole board would allow more voices to be heard, especially those voices who are incarcerated members of our society and who want to do the right things. In today's world of restorative justice practices, incarcerated men and women are looking for ways that they can be restored, rehabilitated, and are eager to exercise what they've learned. Over the last 5 years, I've been a frequent visitor to events at Maine State Prison. I've seen how many men are actively involved in making the world they live in a better place through access to higher education, through hospice volunteering, and through sharing their hopes and dreams for the future. When I was an 8th grade social studies teacher at Rockland Middle School, I had an advisory of 6th, 7th, and 8th grade students. One spring day, a 6th grade student named Leo Hilton walked into my room to join my advisory, and I can still see his smiling face. He continued with me through 7th grade, and in 8th grade was also in my history class and in my homeroom. I got to know him and I got to like him very well, and we connected. Leo was a foster child who had moved on to another school, but over the years, he always kept in touch. 5 weeks after his 18th birthday, Leo committed a very serious crime. The trauma of his young life contributed to that crime, but today at 31, Leo is a changed man full of wisdom, kindness, and compassion. Leo reconnected with me while at Maine State Prison when he completed his associate's degree in liberal studies, and I began to make frequent visitations with him. I was invited to 3 hospice conferences and saw for myself the restorative power of hope, caring, and love. The men all gave their testimonies, and there weren't many dry eyes in the room. As more men joined the group from the Bolduc facility, 2 other former students who were brothers also came over and talked with me. Thankfully, they have since been released. Overall, I left feeling very inspired by all the men and their genuine commitment to the betterment of their fellow man. I've also attended several talent shows and a legislative forum put on by the NAACP. I've always leave there wanting more time with them. A highlight of my life as a teacher was being invited in 2019 to witness the graduation ceremony at the Maine
Ms.
State.
Taylor,
Yes.
your 3 minutes has run, so if you could wrap up, please.
Okay. At this graduation ceremony, then Warden Randall Liberty approached me and said it's a victory, and it certainly was. Leo is now getting his master's degree, as you know. In all of these visits and in all of my day-to-day communications, I'm truly inspired by Leo and these men who don't want to be remembered for the worst decision of their life, but how they can and are changed when given the opportunity. Therefore, I strongly urge the committee that this bill ought to pass and a parole board should be reestablished in the state of Maine. Thank you very much.
Thank you. Committee members, are there any questions for Ms. Taylor? Not seeing any. Thank you very much for being here, Ms. Taylor.
Thank you.
And we'll next be joined by Foster Bates, who was going to come over to the panel. And Mr. Bates, it looks to us like you've joined us on the panel. When you're ready, could you please activate your audio and video?
Don't seem like I can get there, Representative. I'm trying.
Well, we can hear you, which is great. That's halfway. Let me see if I can send a signal that will help you start your video.
Okay, it says start my video. Good morning.
Good morning. We can see and hear you, and welcome to the Judiciary Committee, and you can proceed with your testimony.
Good morning to you all, Representative and Judiciary Committee members. My name is Foster Bates, and I'm the father of Foster D. Bates, who is a prisoner in the Warren State Prison. I came here to speak this morning to support the LD Bill 842. What I first would like to say, and I'm going to be quick, I was aware of the criminal justice system when I was an early teenager, 12 years old. That's been 63 years ago. And during that time, I have seen injustices all over the place by the judiciary, by the criminal justice system. I want to say that I support this bill, LD 842, because I know that it can really help people who have served their time in prisons, in jails throughout the country, and who should be given a second chance to participate in our society. And it really behooves me how the state of Maine, when I found out, did not have a parole system. I said, what? How can we as citizens in this country not have the heart and understanding the ways and means to create a system that's going to be right for people who are coming out of prison to re-enter into our system? I mean, it can be done. I really do believe that. And for a state not to have it, this just doesn't make sense. We are all connected to each other in the sense where right is, sometimes where wrong is. But when you're trying to do the right thing for people who are in prison that's coming out, we know what needs to be established to get that done. I believe we know what needs to be established to let them come out back into the society, giving them that okay. I really do believe that we have all these abilities to do that. We just need to do it. And I support this bill because I think that all of us who deserve a second chance should be given a second chance. That's about all I wanted to say. And I want to say thank you again, Jeff. And I thank you all for working as hard as you are doing to decide whether or not you're going to pass this bill.
Thank you very much, Mr. Bates. Let's see if committee members have any questions for you. Committee members, are there any questions? I am not seeing any. So once again, thank you so much for joining us.
Thank you. Thank you for having me.
And next we'll be joined by Irving Fonts. Whoops. Mr. Fonts, we can see you, but we are not able to hear you.
Sorry about that. Can you hear me now?
We can. Go ahead with your testimony.
Okay, so you're in.
My name is Irving Fonts. I live in Wilton. I'm the chair of the board of the Maine Prisoner Advocacy Coalition, and I have a son who is incarcerated at the Maine State Prison. Today, I'm honored to present the testimony of Daniel Fortune.
Unmute.
According to Daniel, the testimony reads, I would like to start by thanking everybody who set aside the time required to be present and listen to the testimony in support of Parole Bill LD 842. My name is Dan Fortune, and I am currently incarcerated at the Maine State Prison. I support this bill because I see on a daily basis the work that does occur inside the prison. This has not always been the case. When I first came to the prison, I was a scared, hurt child who thought my life was over. I was numb and in shock. As the numbness wore off, I was forced to examine my life. This was not easy, as I was not sure why I was alive. There seemed to be no purpose to my life. I was not suicidal. I was hopeless. I was blessed enough to meet people who cared about me and saw my humanity, even when I didn't. It took some years and a lot of work on myself, but I began to take advantage of some of the programs offered here, namely education. In the years since, I've been fortunate to earn my associate's degree, and as soon as the next college graduation is held, I will be marching to receive my bachelor's. There are 3 programs up here that fundamentally change the lives of every man that participates in them: college, the hospice program, and the yoga teacher training. I have been fortunate enough to participate in college and yoga, and I'm on the waiting list for hospice. The present administration of the DOC, Rand Liberty, has, beginning in his time as warden of the prison, encouraged, supported, and fought for the addition of and improvement to the programs offered here. And most importantly, of us as human beings. Parole seems to be the next logical step in improving the DOC. Maine is the only state in New England that does not have parole. As a result, we have an expanding and aging prison population. I know that parole will just be a means to allow violent prisoners to come home before they have served the full sentence, but parole is something that must be earned through enrollment and completion of programs. Thank you for listening and thank you for your consideration. Sincerely, Daniel Fortune.
Thank you very much, Mr. Fonts, for reading Mr. Fortune's testimony. Committee members, are there any questions? Not seeing any. Thank you for being here today. And the next person we'll hear from is Mackenzie Salinas, who will be joining the panel in just a moment.
Hello.
Hi, welcome to the Judiciary Committee. If we can hear you, could you please activate your video and begin?
I'm not quite sure how to do it.
Okay, let me try. There's something I might.
Oh, wait a minute. Nope, I got it. Okay. Here we go. Okay.
Great. Go ahead.
I'm Mackenzie Salinas. I have a son, Stephen Lee, who has been incarcerated at Maine State Prison for the past 25 years. A lot of people that have come in to comment have made my points. So I'm just going to say a few things that people haven't said. I want to talk about redemption. Redemption really is who I was is not who I am now. And I want to bring up a redemption story. Shaker Signar from Detroit was an inmate who spent 19 years in prison for killing somebody in a drug deal gone wrong. He is now a New York Times bestselling author of Righting My Wrongs, a college lecturer, a TEDx talker, a mentor of youth, and a board member of Cut 50, an organization working for prison reform. What Cigar says is the ability to change is infinite. Another redemption story is Robert Miller. He was incarcerated for 12 years for armed robbery and shooting. When he re-entered society, he met a dog named Shadow, who became his lifelong companion. Robert Miller is now the founder of SOS for the Strength of Shadow, an organization that rescues dogs from high-kill shelters, rehabilitates them, and adopts them out. And as I was reading about his story, I thought, what is the strength of Shadow? And I was thinking, is it acceptance? Is it faith? Is it second chances? Miller says that we do a lot of things for these dogs so they will have a good chance of success. Do humans deserve any less? I want to talk about the older inmates. Of course, my son is one of those. The very definition of people who have served 20 years or more are they're going to be older individuals. And they're likely, those older individuals are likely to be successful in the parole system. The Vera Institute affirms that there's a 2% rate of recidivism in people aged 50 to 65. And that drops to almost zero after 65. Radley Belko of the Washington Post reports that arrest rates peak around age 20, and then they go down, they quickly drop in the decades that follow. So older people are extremely unlikely to reoffend. So, why do we have, 70 and 80-year-olds in prison paying all that money for them, for their healthcare issues and to maintain them when really they're not a danger to society anymore. We already have the
Ms. Salinas?
Yeah, am I back?
I'm sorry to interrupt you, but the 3 minutes has passed, and at this point, I want to just see if committee members have any questions for you. Committee members, are there any questions for Ms. Salinas? I am not seeing any. Thank you very much for appearing today and for providing your testimony to the committee.
Okay, thank you for giving me a voice.
You're welcome. At this point, I think the next person that we will bring over to the panel is Callista Cross. And Ms. Cross, it'll take us a moment for you to transition to the panel. And Ms. Cross, we can see you on the panel, but we can't hear you and the video isn't up yet.
Okay, it's under my grandson.
We see your beautiful grandson.
And I don't know how to get that out. So I don't know if you mind me leaving it like that. I don't dare touch anything. I'm afraid I'll mess it up.
Okay, I sent you a message to try to turn on your video, but if you can, there you go.
All right. Okay. It's nice to see everybody. Senator Carney, Representative Harnett, honorable members of the Judiciary Committee, and Representative Jeff Evangelos. My name is Callista Cross, and I live down in Cornish, Maine, and I'm here to speak in favor of the LD 842, an act to reestablish parole. I'm 78 years old, and I've always lived in Maine, and I worked in Maine for 44 years, and so I know a little bit about Maine. I have a nephew, Tracy Megson, who has been in prison for 32 years now, and he is at Maine State Prison. He was with the wrong person at the wrong time and convicted of something that he did not do. However, we have been dealing with it over the years the best we can. We need parole back into Maine prison and give people like Tracy a second chance. He was 18 when he was arrested and now 51. He has been locked up all these years, and the wardens and staff know him well and know he should be released. He works with a hospice and helps the dying inmates. He works with training the dogs. He works with bees and making honey. He puts together fundraisers. He is well liked and does what he is supposed to do. He has a clean record over the years, and he just lost both parents while being in prison. In fact, his father just passed away a few days ago, and his mother 3 years ago this month, so he won't be able to see them when he gets out of prison. Tracy is a good person and learned many lessons while being in prison. He wants to go back to work and prove to society he is not a threat. He is concerned about serving 10 more years. He will be 61, and who is going to take care of him if he can't get a job and he can't put in for Social Security? We need parole in Maine, and staff and warden knows who is ready to go and not. But we need to get parole started to help the prison system get this new start. It costs taxpayers $45,000 or more a year per inmate. These funds can be used for the homeless, our veterans, the hungry, and much more, as we see so much bills that need to be paid in Maine. Tracy said to me, I will not be any different in 10 more years than I am to serve this as I am right now. So why are we keeping prisoners in these cages when they can do good outside of prison? We have to give them a chance, and Tracy is one who certainly followed all the rules and still has time left to work and take care of himself as he wishes to do. But without parole, he and so many others, they won't get this opportunity. Let's get them out of the cages and let them prove to you and I. We don't allow dogs to be locked up in cages, so why prisoners? They get locked down often, especially weekends, because of lack of workers. No one seems to want a job at the prison for many reasons. And with parole, we won't need as many guards and staff. Let's work together and make parole happen for the good of us all. Try it, you should like it. If you don't try it, one will never know. Thank you.
Thank you very much, Ms. Cross. Committee members, are there any questions? I had a question for you, Ms. Cross. You said in your testimony that You listed a bunch of people, including the wardens. You said they all know he should be released. Can you tell us a little bit more about that, please?
Yes, because he's been under 3 wardens, and I have met the last 2, and so they were really good friends. And because of what they had gone through with the prison system themselves, and they know Tracy very well, and because of his behavior, and he just does everything that they've asked. He doesn't cause any trouble, and he's dedicated himself to helping the different inmates. And because of all of that, they just felt that, that all they needed to have was the okay. When I sent Governor Page a letter, and Governor Randall, Commissioner Randall said that all he needed to hear was from Governor LePage, and that, and then you take it from there because he knew that Tracy was ready to be released and go. He's not going to be any different with the 10 more years he's got to serve. So, why keep him in there when they can go out in society, earn their own money? And that's what a lot of them want to do. And their behavior and everything should tell. And the commissioners know that, and the staff people know that up there, from his friendship and for everything that he's done to help the prison system.
Thank you. That helped me understand your testimony even more. Appreciate it.
Thank you for asking.
Committee members, any additional questions? Okay, the next person we'll bring on is Holly Reed, who will be joining our panel.
Hello.
Welcome.
Thank you. Greetings to the distinguished members of the Judiciary Committee. My name is Holly Reed, and I reside in Bath, Maine, and I appreciate you taking time to hear testimony this morning. I am testifying in favor of LD 842, an act to reestablish parole. My primary employment is as a pastor, but I am also a registered nurse. And for me, LD 842 represents 2 important things. One, which has been mentioned over and over this morning, is the importance of hope. If a person receives a life sentence or even a very long sentence, and there's no possibility of parole, I feel like that means that then there is no hope. And as a pastor and as a nurse, I know the importance of hope for coping, the importance of hope for living, the importance of hope for making positive change in your life. The purpose of the Department of Corrections is to rehabilitate people, to help people change their behavior. But why would you choose to change anything if you didn't have any hope? I think one of the most important tools that we can give to people to encourage change of hope is hope. And I believe that having a system of parole would provide that tool of hope that would inspire people to change their lives. The second thing that's important to me about LD 842 is that I believe it helps us to define who we want to be as a society. It means that we believe that people can change. It means that we believe that change should be rewarded. I believe that incarceration without parole is incarceration without hope. And for me, I believe that to be cruel and inhumane treatment. I think it's important that when we make these decisions, that we remember our common humanity. We like to think that we would never be the ones who are incarcerated. We like to think that it would never be our sons or our daughters or our brothers or our sisters. But I believe that given the right set of circumstances, any of us could end up incarcerated. And if it were you who were incarcerated or your beloved who was incarcerated, wouldn't you want the option of parole? These are the reasons that I support LD 842. Thank you for hearing my testimony.
Thank you very much, Ms. Reed. Committee members, are there questions for Ms. Reed? And I am not seeing any. We appreciate you being here today.
Thank you.
And the next we'll hear from Marie Hayden. And Ms. Hayden, it looks like you've joined our panel, so you can start your video and audio whenever you're ready.
Can you hear me?
We can hear you.
Okay, I don't know how to do the video. I'm not sure. Okay, here we go. All right. Now, can you see me?
We can see you and hear you.
Yay.
Welcome.
Okay. Greetings, Senator Connie, Representative Hartnett, Representative Jeff Evangelos, and the honorable members of the Judiciary Committee. I'm sorry I have to read this because I had a slight stroke a few months ago and I just have to, I can't just talk and talk. I just have to read what I write. So forgive me for reading. My name is Marie Hayden. I am from New Bedford, Massachusetts. I'm speaking today in support of Bill LD 842, which would reestablish the parole system in Maine. Sorry. I support this bill not only for my son Joel Hayden, who has served 10 years of a double life sentence, but for all prisoners in Maine. In 2013, Joel was sentenced to double life, plus $26,000 in restitution, which the family is paying. And also he was told by the judge that he could not ever be rehabilitated. The Maine Department of Corrections offers lots of great classes and self-help programs, but for those serving long or even life sentences, the newly learned, life skills will never be applied. It's very sad. The Department of Corrections should be confident that their programs will have a positive and lasting impact to deter negative behaviors once a person is released into the real world. It doesn't take long for a prisoner to become institutionalized. This hopeless and helpless state of being becomes embedded in their heart and mind when there seems to be no light at the end of the tunnel. In my opinion, the possibility of parole would be an incentive to positively prepare them for their future. Thank you in advance for letting me be part of this and also for voting in favor of LD 842. I appreciate this. Thank you.
Thank you, Ms. Hayden. Committee members, are there any questions for Ms. Hayden? I am not seeing any. We appreciate you appearing before the committee today. I'm going to bring in, I think our last presenter today is on this bill is Andrew Hutchinson, though I would ask if there's anybody on the attendee part of the meeting who wished to speak on LD 842 and hasn't, please raise your electronic hand and keep it raised. And I'll call on you shortly. And Mr. Hutchinson, you can activate your camera and video and audio, excuse me. Welcome to the committee, and you can proceed when you're ready.
Thank you. And like the lady who preceded me, I'm afraid I have to read my testimony, Madam Chair. First of all, good morning, I think, Senator Carney, Representative Hartnett, and honorable members of the Judiciary Committee. My name is Andrew Hutchinson, and I live in Arundel, Maine. I'm here to speak in favor of LD 842, an act to reestablish parole. My wife, Lucille, has a son, and thus I have a stepson, who was sentenced to 59 years in prison in 1996. Because of the quirks in the law at that time, he was not entitled to parole, and his good time only allowed him to receive 15% of his sentence for early release. My stepson's name is Douglas Burr, and you may know this name because the Maine Law Court recently, by unanimous consent and decision, allowed the trial court wide discretion in granting him injunctive relief. Federal court, in addition, allowed him to pursue a case of retaliation against him. His case in the state court system was a civil rights case for placing him in solitary confinement for 22 months without proving a charge against him. He earned his associate's degree prior to being placed in solitary confinement, and he earned his bachelor's degree while in solitary confinement. If you can imagine, they had pencils that were no more than 2.5, 3 inches long, and they had to complete all of their assignments with these ridiculous tools. If that achievement, or should I say self-improvement, is not enough to have him considered for parole, what does? By the prisons, that's Maine State Prisons' own account, he has always been a model prisoner and has never been in any trouble. If that doesn't fulfill Maine State Prison's mission statement, what does? But Doug Burr is not alone. Many other prisoners also qualify, as you've heard time and time again today, but cannot afford legal fees. We were fortunate to be able to support Douglas all through this. Okay. Many other prisoners qualify. Please dig deeply into your hearts and as you consider this bill, and remember that Mainers are forgiving people by nature and believe that everyone deserves a second chance. And just before closing, Madam Chair, our very, very sincere thanks to Representative Evangelos for all the work he has done in bringing this to yours and others' attention. Thank you so much for your time. His mother and I appreciate it. Thank you.
Thank you, Mr. Hutchinson. Committee members, are there any questions for Mr. Hutchinson? I am not seeing any, so we appreciate you being here today, Mr. Hutchinson.
My pleasure.
And at this point, I am not seeing anyone in the attendee space who wishes to speak with regard to 842. This is a final call before we close the hearing. Please raise your electronic hand if you're here for 842. And I am not seeing any raised hands. So with that, we will bring the public hearing on LD 842 to a close. And we will, committee members, do you wish to proceed with the next bill or do we need a short break? If you feel like you would like a short break, please wave your actual hand. Okay. I'm seeing some waved hands. Let's take a break. It is just about noon. And if we could all return at, say, 5 after 12, and then we'll finish our morning work and have maybe a half-hour break before the afternoon. See you all at 5 past 12. Thank you. Hi, committee members. Looks like a number of us are back. And so at this point, we are going to move on to our next bill, although I don't see the bill sponsor here. So let me just, I'm going to check in with our committee clerk for just a moment. Hang on. Hi, Soupy.
Sorry.
Thank you. Have you heard from Representative Costain?
I have not, Madam Chair, and he didn't.
There may be a scheduling glitch. Yeah.
I'm looking for co-hosts. It's Senator Deschambault. One of the committee members present it, perhaps?
Yeah, I think that probably makes a lot of sense because I know we do have some witnesses here. And so let's go ahead with that. Is there a committee member who would like to step forward and present LD 776 on behalf of Representative Costain? Representative Harnett, being a really helping out legislative colleagues, we recognize you to present LD 776 to the committee.
Thank you very much, Madam Chair. On behalf of Representative Costain of Plymouth, I am pleased to introduce LD number 776, an act to amend the length of time and circumstances for which a sheriff may furlough individuals incarcerated in a county jail. In essence, this bill extends from 3 to 7 days the length of time that a sheriff may furlough a person who is incarcerated in a county jail. The bill also adds to the purposes for which furlough may be granted, participation in a program operated by a jail that conditions release on a regular daily reporting to the jail of the prisoner's location and activities. It amends Title Chapter 30A MRSA, Section 1556, subsection 1. And I know we have people that will be testifying in support of the bill, so I would ask the committee to hold their questions till that time. Thank you.
Thank you so much, Representative Harnett. And now we are joined by the first speaker in favor of this legislation, and that is Sheriff Troy Morton. Welcome to the Judiciary Committee, Sheriff Morton, and you can begin whenever you're ready.
Thank you, Senator. Can you hear me okay? I guess the words of 2021?
Yes.
Good morning, good afternoon now, it looks like. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Troy Morton, and I am the Sheriff of Penobscot County and President of the Maine Sheriff's Association. I am pleased to offer unanimous support from the Maine Sheriffs on LD 776, an act to amend the length of time and circumstances for which a sheriff may furlough individuals in a county jail. This bill came to fruition through several discussions with the Maine membership of the Maine Sheriff's Association. Currently, a sheriff's furlough of an inmate is overly restrictive, with a maximum of 3 days allowed and restricted to visiting a dying relative or someone receiving medical care. These limitations prevent us from using furlough to offer positive options, such as enrolling them in programs that are designed specifically to offer a therapeutic approach to incarceration. In Penobscot County, for example, we offer PACE, a program that replaces the alternative sentencing program. PACE, Purpose, Awareness, Connection, and Education, is a community-based program that offers seminars as an alternative to incarceration for first-time offenders. These day-long seminars cover a wealth of topics to include guidance on obtaining a job, finding housing, substance abuse, and a plethora of other application topics to better equip these individuals. These individuals who select PACE rather than incarceration find themselves in a classroom setting in their own clothes, and they're providing meals and snacks. Additionally, the shortage of beds that many jails are facing is an unintended benefit that we hope you consider as you evaluate LD 776. Self-esteem has long been a discussion item when measuring tools to reduce recidivism. We see potential value toward this ultimate result by flipping the discussion from incarceration to finding solutions to avoid poor decision-making. It's not often that we see a clear and intentional opportunity to best support Maine citizens when they're at their most vulnerable time. LD 776 is an evidence-based mechanism that Maine sheriffs urge you to support by voting ought to pass. I appreciate your time, and I'm happy to take any questions that you might have.
Thank you very much, Sheriff Morton. I have a question right off the bat, which is, would you anticipate there being programs that people would be given furlough for in addition to the PACE program, or is this legislation really focused on that particular program?
No, I actually anticipate it being in other programs. So if you look at current statute, it does talk about passing of a relative or a serious medical condition. And then it's got a very wide, broad, and I apologize, Senator, I don't have it in front of me, but the last definition is extremely broad that says something in the best interest of the inmate's well-being, which could be almost any type of programming. As you may or may not be familiar, in the late 90s, there were a term called alternative sentencing that county jails offered. It really focused on driving offenses such as operating under the influence and others. We actually envisioned our program going far beyond those type of charges. In our past, we've had about 50 or so individuals, only impacted today because of the pandemic. But I believe that our numbers will soar, and they'll include far more charges than just traffic offenses, lower end minor offenses, but still those that come with sentences. But I do believe others will look at the PACE program in Penobscot and develop some of those throughout the state, and some of those that might work in their region better than it does here. We based ours on an educational format because we have an education program in the jail, and we see tremendous value there.
Thank you. That was very helpful information. And Representative Libby has a question for you.
Thank you so much, Madam Chair, and thank you for being here today, Sheriff. My question is regarding the medical piece for medical care of the inmate. I'm assuming that this is a different mechanism than any kind of emergency care. So can you speak to that a little bit? What we're talking about here for medical care versus is there a different mechanism for when a prisoner needs medical care that may extend longer than the 3 or the 7 days?
Right. Yes, certainly. So short-term medical treatment, there are individuals, that happens an awful lot when somebody may receive a stay of execution sentence, meaning that they may be, their sentence has been stayed so that they turn themselves in. And sometimes that comes with medical challenges, or maybe perhaps they're in a program or something along those lines. When they eventually come to the jail, a sheriff, through medical providers, maybe a substance abuse provider, mental health provider, can furlough them out to continued treatment. And our problem is that it's for 3 days, and you have to furlough them again, and you have to furlough them again. And sometimes in these cases, this would allow sheriffs to evaluate what's best for that individual, whether it's attending a program like PACE. I'm going to keep throwing out PACE because I think it's really the direction we should be heading. But yeah, certainly medical procedure. It might be an overnight procedure that might take place. Could be a follow-up on MAT treatment. That is something that couldn't happen in the jail. Most of the jails now are running that. But if you couldn't and you had to furlough somebody out for a day, you can do that. So there are so many options, and I think that's where we should be headed. And I don't know that we should define it so much, because tomorrow's new creative initiatives might allow us to do even more.
Thank you. A follow-up, Madam Chair?
Go ahead.
So the mechanism for something right now that would take longer than 3 days is that there are serial furloughs authorized, and that's done every 3 days right now?
Well, it could be, Representative, I'm probably my point, and I apologize. There are circumstances that somebody may have to be hospitalized for long term.
Right.
That's a whole different category, and that could be done through our pretrial service programs. Some folks are guarding it in hospitals if it's weeks. We've had people in the hospital for 2 or 3 weeks at a time that had to remain in custody by statute for one reason or another. But there are other mechanisms such as pretrial services and things like that. This is really, I hope our focus here is really on the ability to fix alternative sentencing practices, give us some greater options. But with that being said, it does impact the passing of families. It impacts, it certainly impacts the ability to overnight procedures of medical things like that.
Thank you so much. That's very clarifying.
Thank you, Representative.
Representative Thorne, go ahead.
Thank you, Madam Chair. Welcome again, Sheriff Morton.
Good to see you, sir.
The best sheriff and the best committee.
I'll take that.
What I am trying to understand is, and I assume that you were in the discussion on crafting this bill or some of the wording perhaps with some of the other sheriffs getting together as far as what would work and what time frame. And the part I guess that sticks out to me is the 3 to 7 day window that is suggested. Well, I'm just curious why the 7 day. Why it seems like an arbitrary number.
Yep, and I can explain that. And I'll be quite frank, Representative Costain, who did a tremendous job working with us on this, I actually helped him craft some of this language. And we looked, Representative, at 3 to 7 days, as those were what alternative sentencing programs generally used to run. What I envisioned some of these creative alternatives in sentencing programs would be sentences that would range in the 3 to 7 days. And so currently, and Senator Carney seemed to had recognized past alternative sentencing programs where we went from first offender programs, we actually went to second offender programs, and even third offender programs. And so some of those came with minimum mandatory sentences that were longer. And so we felt like 3 to 7 days would get us in the time frame that would allow us to take on not just first offenders, but we could certainly take on second offenders, perhaps third offenders. And so that's why we were trying to stretch out that time. And I asked him to increase that time so that it would open the window of opportunity for the criminal justice system to say, if we're providing a sentence to this person, that I could furlough them to this educational program. Here in Penobscot, they attend just like class. They only attend during the day. They go home at night. They earn credentials for classes or work or whatnot during the day. So we're trying to expand it. The 3 to 7 days would allow us to expand the length of our programs.
Thank you for that.
You're welcome.
And if I may, Madam Chair.
Yes, go ahead.
I had a conversation with Representative Costain at the beginning of this session, and he just tried calling me back while I was getting my response from Sheriff Morton. So he's making an attempt trying to get into the session, but I don't know that he has the link for whatever reason.
All right, thank you very much. Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Sheriff, I just have a couple of very quick questions. Am I correct in understanding that a prisoner on furlough, in fact, is still in custody for the duration of the furlough?
That's correct. And so they sign similar representative to bail bonds, maybe a probation terminology. So we obviously, like anything, we conduct a risk assessment, make sure this is appropriate, and sign folks out just like we have for alternative sentencing, which have been there for years. Representative, if I can make one quick point, if you don't mind, one incredibly important thing that this committee should know is those alternative sentencing programs cost money. And the reason that they failed because the cost started to go up so high. When you're incarcerating people in a school, in a community center to run one of these programs overnight, you're paying correctional staff overnight fees. We pass that on to those that are incarcerated. And you become a debt of society when those folks can't afford to do it. In our programs, we've gone from a $350 range to now charging $75, which essentially helps us pay for their meals. And so there are so many benefits behind us doing this alternative sentencing process this way. But yes, they do sign it out. And so if somebody walks away from the program, they're jeopardizing. I will knock on wood, but I will say straight face, in my many years, even under the alternative sentencing program, do we have very many problems at these programs.
And then secondly, do the days spent in furlough status count against the person's total sentence?
Yes, so absolutely. So as we walk through this, and I think we have part of this in there, we call a day as a day. So when we explain this to judges and DAs, when we started this process up here in Penobscot, we've been running it for a while under the 2 and 3 day. We made sure that the courts are aware, defense, prosecutors and all, that know if your intent is to serve for a day, that's really 8 hours in our program. But they earn the same time. So their 8 hours completes a day.
Okay, thanks so much.
Thank you, Representative. Great questions.
Committee members, any additional questions for Sheriff Morton? I am not seeing any questions. Representative Thorne, go ahead.
Thank you, Madam Chair. That was an emergency hair race before you went on. Sheriff Morton, how many prisoners does this, would you say this accounts for? I mean, we're talking 5%, 10%, 20%?
I don't have a percentage, sir, but I know in our program, we've run 50 people through this program. There are a few other furloughs that we do now and again, particularly if somebody has passed. We conduct furloughs for that, or those 1 day or 2 day medical events where we need to furlough somebody, but that does occur. I only believe that when the pandemic is, if we make it out of this at some point, I believe we will, it will open our opportunity to do more of these. When we started this at the beginning of or middle of last year, our intent was to have about 20 or 25 individuals in each one of the classes and run it all the time. We've been held back because of the pandemic. We've limited our crowds to about 10 or 12 participants. That way, instructors that are volunteered to come in, we can have social distancing and all the other mechanisms to make it risk-free. So I think this will have a great impact. More importantly, Representative, is what they get out of the classes. And instead of putting somebody, I listened to the testimony all morning, and instead of having somebody sit in a county jail in cinder block walls and walk out with really spending 3 or 4 days with maybe no lessons, individuals can come to these classes and walk away with a certificate. Perhaps it's in CPR, perhaps it's in an educational format. More importantly, we're connecting them with all the programs that you folks talk about, how we should connect people. That's why we have free volunteers come instruct our classes, because they want to make those connections, whether it's housing. We hear an awful lot about the need for housing through homeless. They're there to present. And I apologize, Senator, for going on, but this is something we're passionate about. If we want to try to make a difference, this is one of these bills that can make a difference.
And if I may ask a follow-up, Madam Chair?
Yes, go ahead.
And I'm not sure, Sheriff, if you've looked at other states that have incorporated this as a model.
We have not. So we looked specifically at our program, and again, Representative, this is a 1990s concept, and we feel like we brought it to the 21st century, and we feel like this fits today's correctional needs in our state. And while I know that it's important that we continue to study across the nation, I think we do things pretty good in our state, and that we can advance things here in our state.
Thank you for that. Thank you, Madam Chair.
Thank you, Representative.
Thank you, Representative Thorne. And we actually have 2 Representative Thornes. I'm thinking that one of them is actually Representative Costain, who has joined us. And You'll know that your bill is in good hands. Representative Harnett presented it, and we've had a great discussion. And you're welcome to speak with the committee now or join us at the work session. Or both, your choice.
Thank you. And sorry, I didn't get the email somehow through the legislative email that it was today. So I apologize for that. Mr. Representative Thorne advised me. So the bill was already presented and Sheriff Morton has spoke on it. I'll wait for the work session if that's fine with you folks.
Yeah, I think that's, that would be completely fine with us.
And do you have a date for the work session?
I don't think we have that yet, but we'll make sure to get that to you as soon as it's scheduled.
Great. Thank you so much.
You're welcome. You're welcome to stay on the panel. I'm just going to see if there are any other folks who are here to speak on this bill. I don't think there are, but let me just check. So looking at the attendees, and I see that Attorney Nadeau is in the attendee space. Are you here to speak? If you're here to speak on LD 776, could you raise your hand? Okay, I think she's here on a different bill. And so with that, we are going to close the public hearing on LD 776 and thank the bill sponsor and Representative Harnett and Sheriff Morton for all speaking on LD 776. And then now, committee members, we're going to move very briefly to one final bill, and then we will take a short break before we resume at 1 o'clock. Thank you all. And so that closes the work session on 776, and we're going to open the work session on, I think it's 719. Nope, 917. And Representative Harnett, you can proceed.
Good afternoon, and thank you, Madam Chair. Again, I'm standing in for another colleague in the House, and I am presenting a bill on behalf of Representative O'Neill of Saco. And she has asked me to present LD number 917, an act regarding electronic monitoring of pretrial and post-conviction defendants. Representative O'Neill has also indicated that this was submitted as a concept draft and that she no longer wishes to pursue this legislation during this session of the 130th legislature. So after presenting it, following her direction, I'm going to ask to go into an immediate work session and offer her assent to and ought not to pass vote by the committee. Thank you.
Thank you very much. Committee members, is there anyone who wishes to be heard on 917? Is there a motion? Representative Evangelos?
I move we suspend the rules and move into work session.
Is there a second?
Second.
Seconded by Representative Sheehan. We're now in work session on LD 917. And is there a motion on this bill? Representative Harnett?
Thank you, Madam Chair. I move ought not to pass on LD 917.
And is there a second? Representative Evangelos is a second. Is the committee ready for the vote? Looks like we are, and our wonderful clerk, Soupy, has appeared on the screen. So this is an ought not to pass motion on 917.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. So the motion ought not to pass on LD 917 carries, 10, 0, and 4 absentees. And with that, we will bring our public hearing and work session on 917 to a close, and we'll be in recess until 1 o'clock. And then we'll resume with, I believe we'll start with Representative McCrate's bill, LD 858, and then one that we didn't get to on Tuesday, which is Representative Terry's bill, LD 1374. Is that your recollection as well, Representative Arnett?
I believe, I'm not sure of the order of the first two. I thought we were doing LD 1374, Representative Terry's bill, because I knew she had to travel, and then Representative McCrate.
Okay, thank you for, I think you're right, and I misspoke. Appreciate that.
And I'll go over the, well, we can go over the order when we begin, because there's a couple other things that have been moved.
Thank you. All right, everyone. See you at 1 o'clock.
Great. Good afternoon. If we have committee members on, if you could activate your cameras and unmute yourselves. That would be helpful. Good afternoon, Representative Poirier, Representative Sheehan.
Hello,
How are you?
I'm doing well. Just to give you a heads up though, I am going to have to excuse myself around 2 o'clock for an hour or so. I have to CPR test.
Okay, we have lots of moving pieces this afternoon. We will carry on as best we can. Going to wait for more members to join and we'll begin our public hearings. Good afternoon, Representative Moriarty, Representative Thorne, Representative Reckitt.
Hello, Tom.
Wait for more members to join and we'll begin our public hearings. Somebody has the YouTube channel on in the background. If they could shut it off, that would be helpful. Going to give a couple of more minutes for my co-chair to arrive. Let's see how many people we have. 1, 2, 3, 4, 5, 6, 7. I have to make a quick phone call to a bill sponsor to make sure they get here on time. I'll be right back.
Okay.
Using audio. Good afternoon again. I had to run out to get a link to our first bill presenter this afternoon, but looks like we have a good critical mass. And I see a hand up from our analyst. Peggy?
Hi. Yes, thank you. I just want to let you know that because we moved this public hearing from Tuesday to today, the electronic LD file is not accessible in the normal way, but if you go to the judiciary calendar and you see LD 1374 on today's date, and instead of going to the little blue icon that we've all learned to love, go to the little plus symbol underneath LD 1374 in the main part of the calendar, and you will have the written testimony that has been submitted. I believe there are 3 pieces.
Thank you very much, Peggy. We appreciate it. And again, I welcome everyone to the afternoon session of the Joint Standing Committee on the Judiciary. We have 5 bills we will be doing this afternoon. I'd like to run through the order because we've had a series of requests for accommodations. It's a crazy time of year. We will first be hearing LD 1374, then going to LD 858, then to LD 834, then to LD 1134, and finally to LD 1226. So with that, I am going to open the public hearing on LD 1734, an act to extend the time period for filing a complaint under the Maine Human Rights Act for discrimination based on an alleged sexual act, sexual contact, or sexual touching. And I welcome to the Judiciary Committee Representative Terry of Gorman to present the bill. Welcome, Representative Terry.
Good morning, Representative Harnett. How is everybody today?
Just wonderful. How are you?
Good. Wind blowing. I was just outside and the wind down here is obscene. Thank you very much for having me. I appreciate it so much. And thank you for accommodating the timing of things. I really do appreciate that. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I'm Representative Mo Terry, and I represent the people of District 26 in the west part of Gorham. I'm here today to present LD 1374, an act to extend the time period for filing a complaint under the Maine Human Rights Act for discrimination based on an alleged sexual act, sexual contact, or sexual touching. This bill is deeply personal for me. The need for this legislation became clear to me when I was approached by a dear friend and constituent who was sexually harassed by a fellow employee at her job. After building up the courage to talk to her employer about what was going on, she was devastated by her employer's unwillingness to take action. My friend stayed at the job for a while, suffering on a regular basis out of terror for what she would face when she got to work each day. Eventually, she left her job, but the trauma and pain of her experience stayed with her. After some time had passed, my friend decided to report the abuse. This is a critical part of processing trauma that happens for some survivors of sexual abuse. It doesn't happen for everyone, and it doesn't happen in any specific time period. When she went to formally report the abuse and inaction of her employer, she discovered that the statute of limitations had run out. In the eyes of the law, the months spent paralyzed by fear, being subjected to repeated violations of her autonomy never happened. Here in Maine, the statute of limitations for reporting these types of crimes to the Human Rights Commission is 300 days after the alleged abuse occurred. LD 1374 would extend that time period to 2 years after the alleged act of unlawful discrimination if the complaint is based on a sexual act, sexual contact, or sexual touching. According to findings from a 2015 survey conducted by USM's Muskie School on Maine crime victimization, 1 in 5 Mainers will experience sexual assault at one point in their lifetime. And each year, 14,000 Mainers will experience sexual violence. However, in 2019, only 514 rapes or attempted rapes were reported to Maine law enforcement. Trauma like this impacts people in so many different ways and at different times. We all have distinct coping mechanisms, and it often takes months, if not years, to come to terms with this type of abuse. 300 days is simply not enough time. Extending the statute of limitations will ensure greater deliverance of justice. And on a personal note, my mom was a victim of abuse as a child for a very long time. And her coping mechanism is not great. Had this happened to her in a workplace, it would have taken her well over 2 years to come up with the courage to speak out to it. I think 300 days is certainly too short. 2 years is probably too short as well, but I'm willing to, compromise a little bit for forever to a couple of years. So thank you very much for the opportunity to testify to this, and I will happily answer any questions you all may have.
Thank you very much, Representative Terry, and thank you for bringing this important bill to the committee's attention. Are there questions from committee members for the bill's sponsor, Representative Terry? Representative Reckett.
Welcome, Representative Terry. I'm just puzzled. I'm trying to figure out why sexual acts of this sort are restricted on this time frame in the workplace, where I think we've been trying to change the statute or eliminate the statute of limitations on, or make it really long on some of these same acts in a different context. So I'm curious as to why, how did you settle on the 2 years to begin with? I understand you might be willing to compromise to that, but where did that number come from originally?
Honestly, it came from how long it took my friend to get the courage up to open her mouth.
Mhm.
I want to say it was somewhere in the vicinity of 18 months or so before she felt comfortable enough going to, in her eyes, the authorities. Again, if it were, I'm perfectly comfortable with forever, but I understand that this has, a little bit to do with business as well.
Mhm.
And I think that we can't all assume that businesses will be around forever. So I guess that's kind of where my time frame came from. I too would be happy with it being a forever thing. But I understand that there are, responsible parties and people that maybe aren't responsible but are complicit to it. So I'll go with that. If the committee feels like they need to make that stretch longer, I'm happy to oblige.
Madam, who's chairing? Tom?
Yeah.
Would I just do a follow-up?
Absolutely.
I'm a little concerned about you said your friend took 18 months before she was even willing to do something. I'm worried about the time period between 18 months and 2 years being only 6 months, that she not only got up the nerve, but then had to find the commission, get the forms, figure out, all that kind of stuff. And I know that sometimes, and I don't know if this is true anymore, it was decades ago, sometimes, I'm a great fan of the Human Rights Commission, but sometimes you have to get your own attorney on top of everything else.
Yeah.
And so I'm just worried about, I'm not necessarily arguing for forever, because I agree with you, businesses are different, I guess. I don't know why the businesses are any different from the church, but the reality is it's a business thing, and you're in an employment situation for a period of time. So I would be more happy if it was 3 than I am with 2, frankly, because I think it doesn't give enough time for a person to actually do something about a decision they've finally decided to do. So I don't know.
I can say that I'm very comfortable with that as well. Without a doubt. I do know that it was a challenge for her to figure out where she needed to go, but kudos to her that she did figure it out finally. And yeah. So I do not have a problem at all with stretching it to 3 years.
Yeah. It doesn't seem like an unreasonable thing to me.
No.
On any front.
Yeah.
Thank you.
Thank you very much, Representative Reckett. Are there additional questions for the bill's sponsor from committee members? Seeing none, thank you very much, Representative Terry, for presenting this bill. I know you're on a bit of a tight schedule, but if you're welcome to stay as a panelist. And I'm sorry, Representative Carney Senator Carney has a question.
I don't. I was just trying to subtly wave to my seatmate from the 129th to greet her.
Apparently it wasn't subtle enough because it startled me. So, but
I did see it and I responded in kind. Yeah.
we need a little wave hand function.
I know, right? A little.
I don't think we don't need more buttons to play with on this. But again, Representative Terry, you're welcome to stay as a panelist, but I understand you might have to leave. And we, as the committee knows, this hearing was scheduled for another day, so I don't have access to the folks that signed up to testify. I know who signed up the first day. 2 of those people are unavailable. That is Jeffrey Young and Amy Sneerson of the Maine Human Rights Commission. I encourage committee members, as you always do, I know, to review their written testimony. But at this point, I am going to ask my clerk, I'm going to ask, is there anybody in the attendee room who would like to speak in favor of LD 1374? If you are, if you could raise your electronic hand. And Subi, I am not seeing anyone. Am I missing anything?
Mr. Chair, I just moved over Megan Sway.
Okay, thank you very much. Then welcome, Ms. Sway. It's always good to see you in front of the Judiciary Committee. As you know, we have a 3-minute limit on all persons speaking other than the bill sponsor. Whenever you're ready, get started, and I will let you know when you're nearing the end of your 3 minutes. Welcome to the committee again, Ms. Sway.
Thank you so much. I will go away. I apologize for the inconvenience. I had not intended to testify on this bill, so I was surprised to find my face here. I will go away and leave you all.
Well, so it actually worked when I said you will go away.
Yes, tell me to go away and it works.
Okay, thank you. We'll see you soon, I imagine. I'm looking at the attendee room and I see that there is no person interested in testifying in support of LD 1374. Again, although we do have testimony in that capacity. Are there any persons in the attendee room who wish to testify in opposition to LD 1374? If so, could you please raise your electronic hand? Seeing none, I will ask if there are any persons in the attendee room who wish to testify neither for nor against LD 1374. If you want to testify in that capacity, please raise your electronic hand. And again, seeing none, having heard testimony from all those present wishing to testify, I now close the public hearing on LD 1374 and wish Representative Terry good travels on your way down south. Take care.
Thank you so much. Have a great weekend, everyone.
Okay, we will now move to LD 858, which is an act to expand recovery services to persons on probation. And I welcome the bill's sponsor, Representative Jay McCrate. Welcome to the Judiciary Committee, Representative McCrate, and please introduce your bill. You're muted, Representative McCrate.
Happens at least 10 times a day. Sorry about that.
It's going to be a bumper sticker, I'm certain, before the year
I think
is
we
up.
need a little sign we hold up. Thank you, Mr. Chair. Thank you, committee. Senator Carney, Representative Harnett, esteemed members of the Judiciary Committee, I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House. I come before you to present LD 858, an act to increase access to recovery services for persons on probation. As you all know, a critical part of our legislative service is the opportunity to help those we represent to find solutions to a wide range of problems. Sometimes it's a phone call or a visit. Other times achieving solutions requires legislative action. And this is one of those cases. A constituent, a person in long-term recovery from substance use disorder and on probation, has shared with me over the last several years how impactful the support of recovery services and the recovery community have been in helping him to get the life he intended. In long-term recovery, with probation ending soon, fully employed, in a committed relationship, a volunteer in the community, and a sponsor of others in recovery. He has also been sharing his recovery experiences with his probation officer to make her aware of their value. He spoke with me about wanting other probation officers to know about these services so that they could help others with substance use disorders know about and have access to recovery services. Our conversations were the start of the proposal before you. At first, I focused on probation officer awareness of the value of recovery. To research this, I had conversations with everyone I could think of who's involved with the issue: directors of recovery centers, recovery and intentional peer support coaches, advocates, harm reduction and civil rights advocates, as well as those working in Maine's law enforcement and probation systems to learn how things work and what could be done. It became clear that the solution goes beyond probation officers' awareness of and referral to these services. It's also about the problem of people on probation being reincarcerated when other options are much more constructive and much less costly to the individual, the family, and the community. We need to make sure that someone isn't returned to incarceration for a violation that's unrelated to the crime they were convicted of or related to a new crime. Common conditions of probation include refraining from drug and alcohol use. This bill sets out that if a probation officer has cause to suspect a violation of these conditions, but not a violation of laws that constitute a crime, arrest and revocation of probation are not permitted. Instead, other options need to be offered, and those should be appropriate to the situation. These could include referral to a recovery coach or intentional peer support, to a recovery center, participation in treatment, or in a restitution program. Too often people are reincarcerated for relapse, also called return to use. This ignores the very nature of recovery. Return to use is not unusual or unexpected and mustn't be treated as a crime in and of itself. The committee may hear, as I have from people involved in law enforcement, that, well, we really don't do that so much anymore, at least not as much as we used to, but some probation officers still do it. I'm really glad that there's progress, but we need to make sure it doesn't happen at all. I propose that we end reincarceration when it's not about a crime. The options for assistance with recovery offer a path forward rather than backward. I want to stress strongly that this proposal isn't about forcing involvement in recovery service, but about making sure probation officers are aware of the other options and that they offer them to people on probation when appropriate. The person doesn't have to accept the referral. Let's make sure we're not participating in a damaging cycle of reincarceration, and instead that we're offering alternatives that are just and that help people succeed. And if you'd allow me, Mr. Chair, my constituent wasn't able to be here, but provided a short statement. Is it okay if I read that?
Yes, it is, Representative McCray.
Thank you. This is from my constituent. I'm an educated 60-year-old man, a good father, brother, son, grandfather. I volunteer for my community. I reach out to suffering people. I am successful at work and a responsible community member. I put a substance into my system and all of that goes away. It's really as simple as that. Recovery really is life or death to me. It is a physical, mental, and spiritual disease. Recovery breaks the cycle. Sometimes people return to use. It happens, sometimes quickly, sometimes slowly. Learning something new sometimes comes with a cost of a few scrapes and scratches. We call that relapse or return to use. Jail is not a solution. I know, I've been there and done that. The bill you are proposing will give people an opportunity to reach out. What got me sober was that hand of loving recovery, reaching out with a new way of living. Thank you for your attention, and I'll do my best to answer any questions.
Thank you.
Oh, one comment. I was advised that where the bill says certified recovery coach, it really should just say recovery coach, because those certification is in the works. We don't have it established yet.
We can
Thank you.
prepare an amendment before the work session. Thank you. Thank you very much, Representative McCrate, for presenting this important bill to the committee, and our clerk, Supi, who knows all, has informed me that you are a former member of the Judiciary Committee.
No
So,
chocolate.
one, we welcome you back, and two, we let you know that she is keeping a list of all former members who have testified virtually, and we are going to be just slathered in chocolate by the time we all get together in person. But thank you
It's a
very
deal.
much.
Thank you.
Testimony. And I now open it up to committee members for questions, and I see Representative Reckett.
My mic is off. See, I'm searching around because I was sure I was muted, but I'm not. So here's my question. Let me give you a hypothetical thing and tell me whether or not this is what you're trying to get at. So somebody's on probation, and they were on probation for, I don't know, stealing a snail. I have no idea, but for theft of some sort. So they're on probation, and they're not supposed to have drugs or alcohol, because that is a pretty routine thing that gets put on probation. So the probation officer comes to the house and notices there's a beer in the refrigerator. So that's a technical violation, right? Which he could be returned to jail for, but it's not connected to the theft charge at all. So that is a situation in which the referral would be to one of these people that you've outlined, but it would not be an option to send the person back to jail. Have I got it right?
Yes. Yeah.
That's what I was trying to figure out, if that's the scenario kind of thing. So, okay, thank you.
And a couple of people following me will be able to talk more about the situation as you described.
Okay, thank you very much, Jay.
Thank you, Representative Reckett. And I would point out that one has to be very quick to steal a snail. Thank you for using that.
Well, I'm a marine biologist, so yeah, I could catch the sucker, no problem.
Thank you very much, Representative Reckett. Are there other questions from committee members for the bill's sponsor, Representative McCrate? Representative Moriarty.
Thank you, Mr. Chair. Representative, I just want to take Representative Reckett's question one step further. Again, suppose a conviction for theft in a period of probation, and there's the beer in the fridge, but the person doesn't have a substance abuse disorder, just enjoys a beer once in a while. Would that person be referred to a recovery coach, or does there need to be some indication of an actual underlying dependency or substance abuse problem?
Well, what I would picture is that probation officers aren't expected to be diagnosticians, right? But it may be something that they bring up. And if it seems like it's relevant to the person, they might suggest that there are services out there. Did they feel like that's something that would be helpful? But if there's no indication that there's a substance use disorder, or I would add a mental health issue, which often go together, I don't think this would come up. I would like it to be in the back of the probation officer's mind, so that if there is something that puts up a red flag, like maybe this would be helpful to this person, and it might be a conversation that happens more than once if they do feel like there's something going on. But no, it's not intended to have people who have no reason to use that kind of service, use that service. It's to make sure that if it would be helpful, it's an option that they have.
Okay, that's good. Thanks.
Thank you.
Thank you, Representative Moriarty. Are there other questions for the bill's sponsor from members of the committee? Seeing none, again, thank you very much, Representative McCreight, for bringing this bill forward, and we look forward to seeing you at the work session if needed. Thank you. I will now turn to people who have registered to testify in support of LD 858, and I will wait for my committee clerk to start moving people in from the order in which they registered. And I will begin with Aaron Woolard. And I would remind all persons testifying in support of or in opposition to or neither for nor against that we will be running a 3-minute clock for your testimony. Once you begin, I will start the clock and I'll show you when you're at about 10 seconds left. Welcome to the Judiciary Committee, and begin when you like, sir. Just unmute your microphone.
Thank you for having me. Chairwoman Carney, Chairman Hornet, other members of the Judiciary Committee, thank you for having me. My name is Aaron Woolard. I'm a third-year sociology major at the University of Maine and a member of the Drug Policy Research Fellowship. As a member of the fellowship and as a student, my views presented today do not represent or reflect the University of Maine or the University of Maine system. As I'm sure all of us are aware, New England and Maine in particular have been deeply affected by the opioid epidemic. Governor Mills has made it a priority to address the crisis in the state of Maine, and one of the governor's first executive actions was to create the Opioid Response Task Force headed by Gordon Smith. While this task force has made significant and important progress in addressing substance use disorder in our communities, it is equally important to support those affected by substance use disorder in the legislation. 2020 saw the worst year for overdoses, with 500 individuals experiencing one. This continues a trend over the years of an increase in fatal and non-fatal overdoses in Maine. The presented bill acts as a kind of cushion to help offenders with substance use disorder receive the treatment they need and potentially save lives. Countless studies have shown that incarceration does not decrease drug use during or after incarceration, and in many cases leads to a fatal overdose upon release. In Maine, it is estimated that 70% of the adult incarcerated population struggle with a substance use disorder, yet nationally, only about 12% of incarcerated individuals with a substance use disorder receive any kind of treatment. Because many county jails nationwide, and some here in Maine operated by county sheriffs, are reluctant to treat those identified as struggling with a substance use disorder, those released often return to using drugs. After not having used drugs while incarcerated, their tolerance for drugs is lower, which places them at a higher risk for a fatal overdose once released. Gordon Smith and his team are working to make this medication-assisted treatment more widely available for residents in Maine jails and prisons. The landmark decision that came from Smith v. Aroostook County Jail determined that administration of medication-assisted treatment, if requested or already being used, is required by Maine law, and has also helped put Maine in a position to become a national leader of drug law reform. But there's still work to do. Ultimately, drug testing those on probation who may struggle with substance use disorder, then incarcerating them because of their illness, creates a cycle that can lead to the death of a member in our community. Legislators must remove incarceration for those who fail a drug test on probation and replace it with the care and commitment the Opioid Response Task Force is hoping to make. In doing this, we can help to prevent members of our communities dying a premature and tragic death. Recovery from substance use disorder is often not a linear or easy process, and as it stands, the Maine Criminal Code makes recovery more difficult. I urge legislators to pass LD 858. Chairwoman Carney, Chairman Hornet, other members of the Judiciary Committee, I thank you for your time and do hope you will consider passing this bill. Thank you. I believe you're muted, Representative Hornet.
I muted myself. Thank you very much for presenting your testimony today. I would now open it up to questions from committee members. Are there questions from committee members for Mr. Woolard? Seeing none, again, I thank you very much for your testimony. We now move back into the attendee room. The committee appreciates your time. I would next call upon Courtney Allen from the Maine Recovery Advocacy Project. Welcome to the Judiciary Committee, Ms. Allen, and begin your testimony as soon as you're ready.
Thank you so much, Representative Harnett. And good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Courtney Allen. I am the Policy Director for the Maine Recovery Advocacy Project, a grassroots network of people across Maine working to redefine justice, access, connection, and recovery from substance use. I'm here today to testify in favor of LD 858. We are in support of this bill because people with substance use disorder should not be subject to incarceration for exhibiting a symptom of their disease, as outlined by the DSM-5. Incarceration for drug use is not a treatment for substance use disorder. As arrest and incarceration destabilizes an individual's life, including their housing, healthcare, employment, and social connectedness. Even brief incarceration leads to adverse consequences, including loss of employment, future employment opportunities, loss of housing and future housing opportunities, and disruptions in family life and social connections. Furthermore, for individuals already receiving medications and treatment for substance use disorder in the community, these services may be interrupted during incarceration, creating lapse in their treatment. Many of our county jails across the state of Maine are now providing access to medication-assisted treatment, but have policies that someone must have a valid prescription and can provide a negative drug test at the time of their arrival. This would be impossible for someone who is arrested on a probation violation for a resumption of use. This bill seeks to find a solution to that issue by providing probation officers with one more way to connect people to the resources and recovery support services that they need, like a recovery coach or an intentional peer support specialist. I've attached to my testimony today a detailed description of a recovery coach from the Portland Recovery Community Center, one of our statewide providers who offer the CCAR training of recovery coaches, to my testimony. But briefly, a recovery coach is a person with lived experience who acts as a motivator, cheerleader, ally, and confidant. They also serve as a resource broker, lifestyle consultant, and a recovery planner. I've also attached to my testimony today a more detailed description of the SIP certification and the process in which folks get that certification. It is an 8-day training that is a requirement for peer support specialists working in Maine on the warm line, in emergency departments, behavioral health homes, and on some ACT teams. Intentional peer support is grounded in a philosophy that through relationships, SIPs think about help in a new way. Rather than focusing on problem solving, they discover together what their hopes and dreams are. And together, SIPs learn, grow, and move towards what they want in their lives. I want to recognize that I'm not a specialist in either of these disciplines. Therefore, I would encourage the committee to request a representative from the Department of Health and Human Services who train or who are certified intentional peer support specialists, and someone from the recovery community to present at your work session. If you have any questions, I'm here to answer them, and I'd be willing to work through with the committee.
Thank you very much, Ms. Allen. The committee appreciate you taking the time to present testimony to us on this important issue this afternoon. And thank you for all the work that you do with the recovery community. Are there questions from committee members for Ms. Allen? I am not seeing anyone. So once again, I thank you very much for your time and for your submitting the written testimony with the attachments as well.
Thank you, Representative.
Next person that we will hear from is Marshall Mercer. Just begin testifying when you are set, and welcome to the Judiciary Committee.
Thank you. Good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Marshall Mercer, and I'm a volunteer recovery coach and project coordinator at the Down East Recovery Support Center in Machias. Also an organizer for MERAP, Maine Recovery Advocacy Project, and former slave to the system and drugs, and I'm now a student of recovery. What I mean by that is I will remain teachable as I walk out my path of recovery while acknowledging there are multiple pathways, and will lead as many people as possible as I can find to find their own pathway. All that being said, I am here to support LD 858. I came to Washington County on a prison bus in 2015. I got out in 2016 after spending most of my life on drugs or selling drugs to support my habit. In jail, I was able to remain clean, but I wasn't able to learn any of the tools I needed to remain safe on my own on the outside. And I wasn't connected to any safety net when I got out. And all that I was given was the $50 of my money that I earned where the rest I didn't get was into a check. Needless to say, I ended up overdosing 3 months later and sitting in jail waiting on another possible prison sentence. But I was blessed with the opportunity to get the treatment I needed. And because of that and God, I am who I am today. But the cold hard facts is many of my friends didn't get that same chance, and they are not with us today. This is why there needs to be a different system in play. Since becoming a recovery coach, I have been given the honor to walk by those who are struggling like I once was. And the bond we build with our recoveries allow us to walk beside them in their recovery as a peer. And the system works. My recovery Mark was just arrested almost a year ago in a police standoff, arrested for a Class B Schedule W drug, deemed a menace to society like I once was. After working 6 months with Mark, Mark is now back residing in the same community he used to terrorize. Now looked up as a leader in the recovery movement that he is involved in Machias. He runs his own support group, has a fiance, is starting a new business that employs people in recovery. All because of a system that was put in place by his community. Emphasize, not prison systems. Just think how many marks there could be if LD 858 gets voted for, and how much money the state could save. Thank you for your time, and I am available for any questions. Thank you.
Thank you very much, Mr. Mercer, for your testimony and in particular for sharing your personal journey that brought you in front of us today. Are there questions from committee members for Mr. Mercer? Seeing none, again, I thank you very much for taking the time and sharing your tale with us. Thank you, sir.
Thank you.
I will now turn to Megan Sway, who I'll not make disappear. Right off the bat, welcome Ms. Sway to the Judiciary Committee and begin your testimony whenever you feel comfortable.
Thank you so much, Representative Harnett and members of the Judiciary Committee. Good afternoon. My name is Megan Sway and I'm Policy Director at the ACLU of Maine. On behalf of our members, I am here to testify this afternoon in strong support of LD 858. Probation violations and drug-related crimes are significant drivers of incarceration in Maine. According to the Maine DOC, violations of probation have made up roughly 40% of the yearly prison admissions for men over the last 5 years, and closer to 50% for women during that same time. Data also shows that for people admitted to prison for new crimes, so not probation violations, over the same time period, so the last 5 years, around 30% of men and around 50% of women were there for drug convictions. This information is in keeping with nationwide research that shows that approximately 65% of people in prison have diagnosed substance use disorders, and another 20% did not meet the diagnostic criteria for a substance use disorder, but were under the influence at the time they committed their offense. What is happening in our jails and prisons is influenced by and interplays with outside events. This includes the overdose death crisis we have been in for years. The pace of loss has accelerated over the last year, and more people died in Maine in 2020 from drug overdoses than from COVID-19. The data this year shows things getting worse, not better. But there's good news to this bad news. The legislature has the power to chart a new course. This legislation does two key things that would make meaningful difference for people caught in the criminal legal system while experiencing a resumption of drug use. First, it states that people who violate probation because they have resumed use of alcohol or other drugs cannot be arrested or have their probation revoked. This doesn't mean that there can't be sanctions, but arrest and reincarceration would not be an option in the absence of a new crime. Second, the bill allows people who violate probation by resuming use of drugs to be referred to a recovery coach, a peer support specialist, or qualified recovery support service. This would connect people struggling with substance use disorders to find connection and support instead of being locked away from the supports they need to enter and sustain recovery. As you have heard from people in recovery and people who work with people who use drugs, we can't punish people into stopping. Trying to do so ignores scientific realities of substance use disorder, sets people up to fail, and punishes people for their disability. Punishment is expensive and counterproductive. Many probation officers already recognize this and have stopped revoking people's probations if they resume use of drugs. But not all do, and it is the job of this committee and of the legislature in general to set guardrails on what is an appropriate response to a technical violation of probation. This bill does just that, and we urge you to vote for it. Thank you.
Thank you very much, Ms. Sway, for coming before the committee today on LD 858. Committee appreciates your time and testimony. Are there questions from committee members for Ms. Sway? Representative Hagan.
Thank you very much, Mr. Chair. Hello, Ms. Sway. Nice to see you again. You just mentioned in your testimony that if they had, I thought in prison they did offer programs. And can you help me with whether or not they do? I don't know. So this is not a loaded question. I thought in prison they offered programs for substance abuse, disorder, and whatnot to help people to free themselves of their alcohol or drug program while they're in prison. Am I wrong on that?
There was a opioid use disorder that the DOC enacted, and I'm going to turn off my video because I'm getting a message that I'm breaking up. My understanding is that the Department of Corrections has some programs, but that they are not completely fulsome yet, and that and even though there are things on the inside, punishing people for using drugs is not something that gets them to stop on their own. And I think that's the message here. Also, the Department of Corrections program is limited to certain people who have been in for a certain amount of time, and it's, there are certain contours to that. Whereas it's not clear that it's necessary if someone relapses or resumes use, I think is the way that folks talk about it, that maybe incarceration is not the right way. And it's definitely cheaper to provide that support in the community than to ask DOC to pay for it.
All right, well, I thank you for that.
Thank you, Representative Hagan. Are there other questions for Ms. Sway from committee members? Representative Poirier.
Thank you, Mr. Chair. I just want to know if there's been any research or if there's any information available as far as what resources are available in areas throughout Maine, not just in heavily populated areas, but outlying areas in Maine, to resources for, say, peer-to-peer groups, or these resources for people to get help that may not be available, like I say, to towns or places that aren't heavily populated?
That is an excellent question. And I believe Courtney, who was on before, has a lot of that information, so maybe she can provide it for you for the work session. I know that trying to resource rural areas is something that we are working hard on, so that it is not just, people don't have to live in Portland in order to access recovery. And there are recovery services in rural areas, and Courtney can get you that information so that you can see the breadth, where we have services and where there are holes, so that you can make that informed decision.
Thank you.
Thank you, Representative. Representative Thorne.
Thank you, Mr. Chair. Thank you, Ms. Sway, for showing up and testifying on behalf of this bill. And not sure if you can answer my question, but I'm confused and bewildered about the line of definition between using drugs and breaking a law. Isn't use of certain drugs breaking the law?
That, yes, you are not wrong. I think currently under Maine law, it is illegal to use drugs. On the other hand, we know that substance use disorder does not discriminate between alcohol or drugs. And so when people use drugs that are not alcohol or that are not that are scheduled drugs, although it is technically illegal, it is still a symptom of substance use disorder. And so you are correct to point out the distinction that I blurred the lines there. But when someone resumes using drugs, that is something between them and their health, and not necessarily something that harms the greater community. And I think, and Representative McCreight would have to be the one to tell you the intent, but I think the point is we're trying to make stronger communities. And when someone resumes drug use, getting connected with recovery services helps that person and helps communities in a way that is different than when someone commits a theft or is a crime that hurt somebody else.
Okay, follow-up question, Mr. Chair.
Absolutely, Representative Thorne, go ahead.
And I'm asking you this on your position, and I may be a little off base, but you're the policy director for ACLU Maine, correct?
Correct.
But isn't part of civil liberties accountability for your own actions? Right? Taking responsibility for your own actions as a member of our society. That's part of the recovery process, I would hope, is that you're accountable for your actions and you have a responsibility to abide by the laws that is fair for everybody. So it wouldn't be fair to say somebody else would be arrested for doing this, but where you're in recovery, we're not going to charge you again for this. That's my only point, is trying to assume responsibility for everybody's own actions and not waiving it for one, but waiving it for another.
If you're someone who has substance use disorder and you commit a new crime, this bill would not absolve you of responsibility for committing that harm because you have substance use disorder. But if you are someone with substance use disorder and you resume using, there's a recognition that oftentimes substance use disorder is the repeated seeking of substances despite consequences. And so this is an attempt to not punish people for their substance use disorder. It doesn't mean that you're not held accountable. So as I said in my testimony, there are other ways short of incarceration that a probation officer could deal with that. A lot of states do things called graduated sanctions, where they look at the risk, look at the offense, and choose a sanction for the violation that is appropriate. But there's an understanding that incarcerating people because of their substance use disorder, I'm not saying what you do when you're on substances, but because of your substance use disorder, is not a way to get people in recovery. And it's not accountability if someone is compelled to take regardless of the consequence. And so there are consequences available. Incarceration is just not one of them.
All right, thank you for your answer. Appreciate that. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there other questions from committee members for Ms. Sway?
Thank you all so much. Have a great one.
Thank you very much for your testimony and time today, Ms. Sway. I will now recognize Tina Neto. Ms. Neto, whenever you are ready, just unmute yourself and I will begin the infamous clock. Nice to see you again.
Nice to see you again, too. Thank you, Representative Harnett, and thank you, everyone. My name is Tina Nato. I'm here today on behalf of the Maine Association of Criminal Defense Lawyers in support of this bill, and thank you to Representative McCreight for bringing it forward. I'm going to depart just a little bit from what Attorney Sway just commented about whether or not it's illegal to use drugs in Maine. The only time when it's illegal to actually use drugs, not possess, but use, is if somebody's either on conditions of bail or conditions of release or on conditions of probation. And that also includes the use of alcohol. And if you're over the age of 21, there's no illegality in consuming alcohol unless you're prohibited from doing so by conditions of release or conditions of probation. And I think that's important because that's what this bill addresses, is removing the illegality for people who are struggling with substance use disorder from the potential of severe sanctions if they are caught or tested positive for the presence of alcohol or drugs. I can tell you as a defense attorney who represents many people on probation, this is a sanction that is imposed. Incarceration is imposed for repeated violations by using substances. And because of the fear of incarceration, it makes it more likely that my clients are going to try, if they have relapsed, to avoid checking with probation, to avoid meeting with their probation officer, because they don't want to get caught using, because the downside of that is remarkable. So we're kind of building into, because of that fear, people are no longer working with their probation officers, which is itself is a problem. If the goal is supervision to keep people on the straight and narrow and prevent new criminality, we should really seriously consider removing those prohibitions in order that people feel comfortable being open and honest with their probation officers, checking in with them consistently, and being real about if they need help in the moment to access the services to actually address the relapse. These are really important considerations. I mean, obviously we support any increase in access to treatment and services, whether it's medical treatment or psychological treatment or supportive treatment, of course. But our main concern as criminal defense lawyers is removing the penalty of imprisonment from people who are struggling with substance use disorder, who happen to be on conditions. This bill focuses on probation, but there's also the issue of bail, from being imprisoned for doing what is part of the recovery process. Prosecutors and judges often say, we understand relapse is part of recovery, but they also agree to imprison people for relapsing, and we can't have that anymore. Thank you.
Thank you very much, Ms. Neto, for your testimony today, for the written testimony that you submitted as well. Are there questions from committee members for Ms. Neto? Seeing none, again, thank you for taking the time to present the testimony to the Judiciary Committee. The next person to testify is Whitney Parrish. Welcome, Ms. Parrish. Nice to see you again. Please begin your testimony whenever you're comfortable.
Representative Harnett, distinguished members of the committee, my name is Whitney Parrish, and I'm the Advocacy and Communications Director for Health Equity Alliance. Health Equity Alliance is a public health and harm reduction organization that envisions and works toward a world where all people are valued and celebrated, and health justice is realized for everyone, regardless of who they are, where they come from, or what their lives look like. I'm here to testify in strong support of LD 858. Because anytime we can adapt our practices to the realities of drug use and addiction, provide alternatives to incarceration, and avoid compounding harm, we will see better outcomes for people who experience substance use disorder or use drugs. One thing we say often in recovery communities, whether it's related to substance use, mental health challenges, or illness, or a combination of both, is recovery is not linear. There can be ups and downs, just like any experience or journey in life. Experiencing what is considered a down does not mean someone has failed. It does not mean their recovery or any effort to change their use or management of their condition or situation has ended or even fundamentally changed. What it does mean, however, is that punishing someone for resumption of use or symptom illness is not going to support them in their path toward wellness or a better life, however that looks for them. This is why we support the opportunity for individuals on probation who may need support, the ability to access it if they choose, in lieu of punitive measures like incarceration. Repeated incarceration, as you've heard, even for short periods of time, is traumatizing and does not promote wellness. It offers no incentive, as many claim, There are stories like that, and we must honor them, but we cannot assume they're the norm. What we see in our work is this: people losing jobs, income, healthcare, stable housing, losing full hope that anyone even cares about them, and people losing any semblance of connection to a community that truly cares about them or what happens to them. This is one of the most heartbreaking parts of the work. We must understand that systemic barriers, a system built around carceral solutions to social and health issues, and misunderstanding of drug use and substance use disorder generally is not only hurting people, but it is contributing to the overdose death rate in Maine. To be clear, we are not a recovery organization. We work with people who actively use drugs through our harm reduction services, and many of these folks do find a pathway to recovery through our services. Evidence shows that when you support people where they are, build a relationship and trust with them, and show you truly care about them, they are apt to use more safely and consider options and services related to increased wellness and recovery. Access to supportive, qualified individuals who fully understand a situation someone may be in and can work to build a relationship and connection, so critical to better sustained outcomes, could be a significant game changer in reducing recidivism and increasing wellness for so many Maine residents and communities. We believe this bill honors the reality that recovery is not linear, and I will wrap up. It recognizes that health is complicated and challenges with it should not be automatically met with punishment, especially incarceration. We must give people agency and opportunity to build the connection they need and treat drug use as a personal health matter, not a criminal one. So we respectfully urge you to vote ought to pass. Thank you for your time and attention.
Thank you very much, Ms. Parrish. Are there questions from committee members for Ms. Parrish? Seeing none, thank you very much for taking the time and presenting testimony to the Judiciary Committee today. Very much appreciated. That is all I have on my list for people testifying in support of LD 858. I will turn to the attendee room and ask if there is any other person who wishes to testify in support of LD 858 to please raise your electronic hand. Seeing none, I do not have anybody registered to testify in opposition to LD 858, but I will give an opportunity for any person in the attendee room who is interested in testifying in opposition to LD 858 to raise your electronic hand. And seeing none, I will turn to our final category, and that is persons testifying neither for nor against LD 858. And my first person registered and has been moved in as a panelist is Julia Finn. Welcome, Ms. Finn. And nice to see you again in front of the Judiciary Committee after lunch, so you don't have to worry about holding us up from our meal.
All right, thank you very much. It's a pleasure to be after lunch today. Representative Harnett, Senator Carney, esteemed members of the Joint Standing Committee on Judiciary, and former member, Representative McCreight. My name is Julie Finn, and I represent the judicial branch. I would like to provide very brief testimony on this bill. The bill prohibits arrest and revocation of probation for the violation of probation conditions when a violation of a condition requiring the person to refrain from drug use and excessive use of alcohol is suspected. While the judicial branch does have data on the numbers of probation violations, unfortunately, our system does not differentiate between different types of probation violations. However, the judicial branch stands ready, as always, to serve as a resource to the committee and to provide information on the procedures and practices that the court follows when motions to revoke probation are presented to the courts. And with that, that's all I have. Thank you very much for your time this afternoon.
Thank you very much, Ms. Finn, and your brevity is always appreciated. Are there questions from committee members for Ms. Finn? Representative Thorne.
Thank you, Mr. Chair. Ms. Finn, thank you for appearing and presenting in this. And I remember the the problem we had with marijuana. Everybody was getting arrested for it. It was taking up everybody's time. There were people that thought it was bad. There were people that thought it was good. And I'm just wondering on this one, what if we made these drugs not illegal to use? Would that help facilitate non-incarceration and help with the recovery process?
Well, I believe there are bills that address that issue during this session. I can't really comment on legalization or other bills. I will say, though, that with respect to probation violations, I believe it was Ms. Netto who pointed out that, alcohol use is not illegal. And that is still sometimes something that people who are on probation are prohibited from. So I'm not sure that would change the situation with respect to probation violations.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there other questions from committee members for Ms. Finn? Seeing none, always nice to see you in front of the committee. Thank you very much for presenting your testimony today.
Thank you.
The next person testifying neither for nor against is Peter Lehman. Mr. Lehman, nice to see you again. Proceed when you are ready.
Good afternoon, Representative Harnett and distinguished members of the committee. My name's Peter Lehman. I live in Thomaston, and I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition. Our goal is to promote restorative practices in order to increase public safety and the health of the community. I introduced myself as a person in long-term recovery. I'm thinking not only of my recovery from substance use disorder, but my recovery from other addictions and from other mental health challenges for more than 22 years. I've benefited from recovery support services and have long been a champion of recovery peer support centers. I'm also a certified recovery coach. MPAC very much supports the intention of this bill. We support in avoiding incarceration for mental health issues. One of the issues of those struggling with substance use disorder has been stigmatizing of this disease as a moral weakness and criminality, rather than as a mental health affliction. Unfortunately, in attempting to confront this stigmatization and isolation, this bill unintentionally stigmatizes and isolates those dealing with non-substance use mental health challenges. When Mary Ellen Copeland developed the idea of wellness recovery plans, action plans in 1997, she wasn't thinking of substance use disorder. Now, RAP is an evidence-based approach that is also widely used in substance use treatment and in peer support and the peer support community. It's time we stopped compartmentalizing and pretending that some of us have a better or morally superior mental health challenge than others. Many of the people MPAC and the Maine Prisoner Reentry Network encounter and support are recovering from a variety of trauma-induced mental health issues. Moreover, there's a strong and vibrant mental health peer support community that includes peer support for those with substance use disorder. It makes no sense to create another community that excludes those without SUD. So we strongly recommend that the bill not be restricted to a single mental health issue by the addition of and/or other mental health issues when appropriate in the bill. We recommend that the definition of recovery residence be expanded with the addition of the terms and/or other mental health issues in the definition. In short, we support the concept and the intention and hope you can correct these significant flaws. Thank you very much. Appreciate it.
Thank you very much, Mr. Lehman. The committee appreciates your time and your testimony, which you've also submitted in writing. Are there questions from committee members for Mr. Lehman? Seeing none, I thank you again for your time and testimony, sir.
Thank you again.
I will go to the attendee room one more time just to make sure I've not missed anyone. Is there anybody in the attendee room who wishes to testify in any capacity on LD 858? Seeing none, I want to thank the bill sponsor, Representative McCrate, for bringing this forward and appreciate the testimony of all that came before the Judiciary Committee today. And with that, having heard all public testimony from people present wishing to testify, I will close the public hearing on LD 858. Thank you. We will now move to our next bill, which is LD 834. And that is an act to ensure the appropriate allocation of victim restitution. And that is brought by Representative Stover, and she is here to introduce the bill today. Welcome, Representative Stover, to the Judiciary Committee.
Thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Holly Stover, and I represent House District 89, including the towns of Boothbay Harbor, Southport, Edgecombe, Westport Island, and part of South Bristol. Thank you for the opportunity to provide testimony today in support of LD 834, an act to ensure the appropriate allocation of victim restitution. In Maine law, an offender's obligation to pay restitution is not impacted by the death of the victim to which the restitution is owed. The money collected as restitution is paid to the victim's estate. There's a serious omission in the law that LD 834 seeks to correct. Presently, there's nothing currently in statute that prohibits a deceased victim's restitution paid from an offender if the offender is an heir, beneficiary, or recipient of funds from the victim's estate. Under the changes proposed by this LD 834, the offender may not receive any of the victim's restitution, even if that offender is an heir, beneficiary, or recipient of the victim's estate. The estate distribution would exclude the offender for the portion of the estate that contains any collected restitution, and those funds must be redistributed to the benefactor's estate. If the victim's estate only names the offender as the beneficiary, the restitution must be paid to the victim's compensation fund or the victim's property compensation fund, determined by whether restitution is ordered for personal injury or for property damage. This is a bill that provides added protection for the rights of a victim of crime. There are cases where restitution has been paid back to an offender as part of the estate distribution. LD 834 provides a mechanism to honor the victim by not providing any part of the restitution paid into the estate of the offender. It may seem like a small matter, but for a victim's family, it is critically important to provide this protection even after the victim is deceased. This is something we can do to honor the life of a victim of crime by ensuring that we do not allow an offender to benefit in any way from this portion of the estate. And I just want to add that Maine Coalition Against Sexual Assault, Elizabeth Ward Saxel, could not be here today and was planning to testify. She sends her apologies to the committee. She had a personal emergency, but wanted you to know that she, the Maine Coalition Against Sexual Assault, is in full support. And I believe you've also been provided testimony from Commissioner Liberty from the Department of Corrections, also in support of this bill. And the Department of Corrections does oversee victim services. It may not sound like a large problem, but there have been incidents and cases where this has actually happened, even within the past year. And this is it's a small change with a big impact for those cases where it happens. Thank you.
Thank you very much, Representative Stover, and thank you for bringing LD 834 before the committee today. Are there questions from committee members for Representative Stover? Representative Moriarty.
Thank you, Mr. Chair. Representative Stover, I'm just trying to get my hands around the idea of how widespread a problem this might be. Assuming that the victim died intestate, the offender must have been a blood relative entitled to take a share of the estate through the intestacy laws.
That would be correct. Or it had some personal relationship to the victim. And, you know, there are instances where a personal crime may have occurred and the victim, for whatever reason, we all have those things we're supposed to do, like our wills or our living wills or whatever, that we don't get to. And there have been 1 or 2 cases in the past year, according to Tessa Mosier from the Department of Corrections, who also couldn't be here today, but will be here for the work session, where maybe we can get into how many actual cases. What I would say about that, having worked in domestic violence and sexual assault, to me, there only needs to be one for it to really matter, because having worked with victims of crimes, it wasn't in the plan to make to have the offender gain from that restitution of that estate. And maybe it was because the change hadn't been made and it was an untimely or unplanned death. But if we can fix that for one individual in one case in one family, then I think we will have done our work here.
So the concern, I gather, is that the offender who has paid restitution should not be reimbursed from the estate of the person to whom he paid restitution.
That is exactly it. It's sort of it goes in a circle, but that is the point. You know, I don't think that, and you certainly know better than I, that we're allowed to dictate that an offender can't have the victim's estate if the victim left the estate and didn't make a change. But however, we can make the change that the restitution not be returned to the offender.
That's only the restitution and not
only
whatever.
The restitution. Yes.
Okay. Okay. Thanks then.
Thank you very much, Representative Moriarty. Are there additional questions from committee members for Representative Stover? Representative Reckett.
Representative Stover, I'm a little confused now. Is there already something that prevents, let's say that, I mean, both you and I have sat on the Domestic Violence Commission. I don't know whether you ever sat on the Homicide Review Panel, but I did for a long time. And I'm thinking about a case where an offender kills his partner. They never got their life insurance straightened out, and he inherits the life insurance from this person. Is that already covered by the law?
And I'm not an attorney, and I did serve on the commission and on the Homicide Review Panel. And it is my understanding, although for any of the attorneys sitting on this committee, it is my understanding that if that life insurance named him, that there's no provision for that not to go to him. However, this is directing the restitution if there were any not be paid to him. The case you're describing, there would be no restitution because we're talking about someone who actually committed murder and benefited from the estate. I don't know if that's a different subject, although very connected, and I could feel equally passionate about that.
Perhaps we should talk next year.
I think we could talk about that one, because that, I believe from serving on Homicide Review, there's been many cases where life insurance and personal property ends up being transferred to the person, the surviving, the offender, the murderer. And that's a different issue that we should discuss.
Yeah, thank you.
Thank you.
Thank you, Representative Reckett. Are there additional questions for the bill sponsor, Representative Stover, from committee members? And I am not seeing anyone, so thank you very much, Representative Stover, for bringing this bill forward. And you can remain as a panelist if you would like for the rest of the public hearing.
Thank you very much. Have a good afternoon.
I will now turn to persons testifying in favor of LD 834, and I will recognize Andrea Mancuso. Welcome to the Judiciary Committee again, Ms. Mancuso. Please begin testifying when you're comfortable.
Thank you, Representative Harnett. Good afternoon, Representative Harnett, distinguished members of the Committee on Judiciary. I'm here today on behalf of the Maine Coalition to End Domestic Violence and our member programs in support of LD 834. As you've heard from Representative Stover, our laws currently require a person ordered to pay restitution to continue to pay it, even if the person to whom they are supposed to pay it to has died. They are then required to pay it to their estate. And LD 834 addresses the technical loophole that currently exists that allows that person to pay it to the estate and then receive it back from the estate if they are the beneficiary of the estate. The impact of domestic abuse and violence is not felt by the individual victim alone. Quite often, it's also carried by family, friends, and the broader community. This bill would ensure that the obligation of the person who has caused the harm, that has to work to repair the harm through restitution, that obligation will continue in those circumstances where the primary victim has died before restitution is paid in full. Seems like a very simple, quick technical fix. We hope you all support it. Thanks for the opportunity to share our perspective with you. Happy to answer any questions or be a resource in the work session.
Thank you very much, Ms. Mancuso. Are there questions from committee members for Ms. Mancuso on LD 834? Seeing none, thank you very much for your time today and for presenting testimony and for volunteering to participate in the work session if needed. Greatly appreciated. I would ask my committee clerk, I had one other person who was signed up to testify in favor, but I do not, I'm going to check the attendee room. I do not see that person, so I'm going to ask if there are any persons in the attendee room who wish to testify in support of LD 834. Could you please raise your electronic hand? Seeing none, I would ask if there are any persons in the attendee room who wish to testify neither for nor against LD 834 to please raise your electronic hand. And I do see a hand up. I bet it's already happened. I would now call upon Jan Collins. Ms. Collins, nice to see you again. As soon as you're ready, just unmute your microphone and begin your testimony.
Thank you, Representative Harnett and members of the esteemed Committee on Judiciary. I had not planned to testify on this bill. And so my words are extemporaneous, and I hope you will forgive me. One, there was a question about insurance policies, and I just wanted to say that insurance companies generally do not pay those policies when a murder has occurred because it voids the policy. And two, in terms of the victim, I have knowledge of an example where I believe the victim would still want the perpetrator to receive the funds. Many of us have loved ones who have mental health issues. This particular example, and I'm sorry the person isn't here and that I'm speaking for them because I don't know if they would want me to, but I'm going to just put it out there. I know of a person whose son killed their spouse. He had severe mental health issues. He was in the midst of an episode, and he would never have done in his right mind, would never have killed his mother. He, under the penalty of law, he went to prison. And unfortunately, due to poor health care in the prison system, he also died. But had he survived and was able to be released from prison, I believe his mother and his father would both have wanted him to have some means of support so that he would be able to survive in the world without them. So although I think this bill is in general very well-meaning, it does take away the ability of those people who are understanding and loving of the person who was, in fact, the perpetrator and would want them to have those funds. So with that, I thank you and I'm willing to take any questions.
Thank you very much, Ms. Collins. Now ask if committee members have any questions for Ms. Collins. Representative Moriarty.
Thank you, Mr. Chair. Ms. Collins, I don't quite understand your testimony because this applies only to restitution.
Correct.
If the son in your hypothetical who had a mental illness killed his mother, and his mother had a will which gave her estate to the son, but there was never any restitution ordered as between them, as I understand it, the son would still receive the estate.
Thank you for that question. So restitution can be sizable, and it also often includes funeral expenses. So
but I'm saying, supposing there was no restitution ordered.
But there likely would be restitution ordered for the funeral expenses.
Okay. Okay, I'm still a bit confused, but I won't belabor the point.
I hope I didn't muddy the waters. I apologize.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. Welcome, Ms. Collins. Thank you for appearing today and testifying. And I may have missed it in your introduction, and pardon me, I'm new to the committee and I'm not familiar with a lot of the folks that testify. And I know you did testify on behalf of 842 earlier today, but are you here representing the Maine Prison Incarceration Association or on another behalf?
Thank you for that question. I am here representing myself at this moment.
Okay.
We have not discussed this bill with MPAC.
Okay. Thank you for that clarification. Appreciate it.
Thank you, Representative Thorne. Representative Babbage.
Thank you, Mr. Chairman, and good to see you, Ms. Collins.
Thank you.
Always appreciate your thinking. And it is your job to muddy the waters, at least for us to consider all consequences. I actually was thinking along the same line. I'm always trying to be the devil's advocate. Is there a mental health condition or a mental health designation that would be an appropriate exception or amendment to this? And I just want to ask you if you have something like that or would work on something like that before the work session. It may be something that we would take a close look at. That's all I'm saying.
Thank you, Representative Babbage. I would be glad to do that.
Thank you, Representative Babbage. Are there other questions from committee members for Ms. Collins? Seeing none, thank you very much for testifying before the committee today. We appreciate your time and testimony.
Thank you.
I would ask one more time, are there any persons in the attendee room who wish to, Representative Moriarty?
Mr. Chair, is it too late for me to ask a question to the sponsor?
I will say no, it is not too late, as the sponsor is still here.
Okay.
So go ahead.
I've just been dwelling on this, and this is the hypothetical. Assume that restitution had been paid 5 years before the victim's death and was not owed to her estate, therefore. Would this statute apply to the distribution of the victim's estate some years after restitution had been paid?
Yes. What this bill would do, if the offender was the sole heir, then it would take that restitution portion and it would go to one of the two victims' compensation funds. And then the rest of the estate would go as it was directed. If there were other heirs or benefactors of the estate, then the restitution would go to those members and the rest of the estate would be shared with everybody, including the offender, because of the way that the current law exists. The offender is entitled to the estate if still named in the estate. That makes sense. So it would just be this restitution piece that would be excluded out. That's what 834 is asking for, is to exclude. So it's one of two things. Either gets excluded and shared only with the other heirs, or it gets excluded and given to the victim's compensation fund.
And that's regardless of when the restitution was paid, or how many years prior to death.
Yes.
Okay, I don't quite see that in the language, but I should look closer. So,
And we can flesh that out some more in the work session, perhaps.
okay, thanks.
Thank you.
Thank you, Representative Moriarty. Are there any questions from committee members? And are there any attendees who still wish to be heard on LD 834? Seeing none, having heard the testimony by all those members of the public who are present today and wishing to testify, I will thank the bill sponsor, Representative Stover, and close the public hearing on LD 834. Committee members, there is a problem with the availability of the sponsor for the next two bills. So I am going to put the committee in recess for the next 15 minutes as I figure out the best way to proceed. So we will come together again at 2:45, and I will give you an update at that time.
Okay.
Thank you all, and remember to mute your mics. And to,
Tom, can you stay on and talk to me? So I have information about that.
I know you do, but I don't want to do
Okay.
that on YouTube. I will give you a
Okay.
call as soon as we are in recess.
All right, no problem.
Thank you. I would ask people to shut off their video and mute their microphones, and see you in a little under 15 minutes. And Lois, I will call you right when I'm done.
All right.
Somebody's microphone's still on.
committee members, you may have noticed my sign has been changed. We're actually going to be out until 3.
And I apologize for that.
Oh.
We're still trying to figure out the logistics. We will see you at 3 o'clock. My apologies.
Thank you.
Some tea.
Welcome back, committee members. As you return, if you could activate your video so I know that you are here, and we will resume our public hearings. We had some logistical issues that needed to be worked out, and I believe that we have worked them out. I need to remember that time in the legislature has a different concept than it does in many other places, so I appreciate everyone's flexibility. We are going to begin the public hearing on LD 1134. The bill sponsor, Rachel Talbot Ross, is tied up with legislative counsel and is unable to be here at this time. So the bill will be introduced by our colleague, Representative Lois Galgay-Reckett. And whenever you are ready, Representative, you may proceed.
Thank you. I'm going to try to transliterate this testimony as if I were speaking, but I may screw up. So, but let me, this is testimony obviously prepared by Rachel Talbot Ross. Senator Carney, Representative Hartnett, and distinguished members of the Joint Standing Committee on Judiciary. This testimony is from Rachel Talbot Ross, who represents House District 40, which makes up the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and the University of Southern Maine campus. We want to thank you for the opportunity to present LD 1134, an act to amend the Maine Bail Code regarding certain conditions of release, and the Maine Criminal Justice Code, the Maine Criminal Code regarding warrantless arrests. I'm presenting you with an amendment that addresses a few minor issues identified by CLAC, as well as other feedback she has received since the bill was printed. That amendment will be presented to you by Megan Sway when she testifies, I believe. Over the past several years, and it's also attached to Rachel Talbot Ross's testimony in our materials. Over the past several years, Maine's jails have faced a series of crises in funding and overcrowding. Much of this has its genesis in our underfunding of social safety nets and our over-reliance on police arresting for low-level offenses to address public health and poverty problems. As a result of these crises, there have been numerous task forces and working groups put together during this time to figure out solutions to the state's very real pretrial problems. And then at the beginning of the COVID-19 crisis last year, recognizing the very high stakes that this virus presented to people in congregate settings, law enforcement in our state tried a new way. Police stopped arresting people for low-level offenses and issued warnings or summonses instead. Cash bail became a less frequent reason people were incarcerated pre-trial. And while our arrest and jail numbers dipped, public safety did not. We were safer even as we were dealing with public safety in this new way. This bill attempts to enshrine some of these new ways of approaching public safety in law. The language, however, was largely written long before the pandemic, during the 2019 Intergovernmental Pretrial Justice Reform Task Force, of which Rachel Talbot Ross was a member. That task force was made up of stakeholders across various systems, including legislators, the commissioners of the Department of Public Safety and Corrections, judges, prosecutors, victim advocates, pretrial service providers, civil libertarians, and more. It was actually the second task force in recent years on the subject of pretrial justice reform, convened under the leadership of then Chief Justice Lee Softly. Members of the task force spent the summer and fall of 2019 discussing and debating policy changes to Maine's pretrial system. One of its subcommittees crafted much of what is before you now as LD 1134 to address the task force's unanimous recommendation that police use summonses instead of arrests whenever possible in addressing misdemeanors and in addressing the proliferation of charges involving violations of conditions of release on bail. During her time on the task force, she learned that Maine is one of only 7 states that criminalizes violations of conditions of pretrial release other than failure to appear in court. That means that we are one of 7 states that takes acts that are otherwise largely not crimes and makes them a crime, simply because they are committed by a legally innocent person out on bail. According to the Council of State Governments, approximately 1/5 of the arrests in this state every year are for these violations. These violations can include things like having a beer in one's refrigerator, maintaining or looking for employment, going to school, or undergoing outpatient mental health services, among other things. This bill approaches these issues identified by the Pretrial Justice Reform Task Force in 2 ways. First, it removes criminal penalties for most violations of conditions of release, other than 1, abiding by specific restrictions on personal associations, places where the defendant is allowed to live, and places where the defendant is allowed to travel. Secondly, avoiding all contact with alleged victims of a crime. Third, refraining from possessing a dangerous weapon. 4, returning to custody during a work release program. Or 5, participating in electronic monitoring. These conditions were identified by the prosecutors on the task force as important to them to retain as crimes. The bill retains a criminal penalty for violations of conditions of release for charges related to domestic violence, as I heard from prosecutors that victims advocates that they believe victim safety is protected by retaining those crimes. A person can still have a motion to revoke bail filed if a prosecutor feels that it is necessary. And if a person commits a crime while out on bail, they can be charged with that crime, but they will not be charged or convicted of a separate crime of violating conditions of release. Second, the bill looks at the reasons for warrantless arrests and attempts to narrow them. It clarifies that for misdemeanors, when it is safe and feasible to issue a summons instead of arresting, police must issue summonses. The Black Law Dictionary definition of feasibility is, and I quote, the possibility that something can be done, made, or achieved, or that it is reasonable, practicable. This change to the law is intended to guide but not to unduly restrain police. If it is not safe or reasonable to issue a summons for a misdemeanor, they need not do this. But where it is safe and feasible, there is no reason to arrest or haul someone to jail unnecessarily. According to the Council of State Governments, approximately 77% of arrests in Maine every year are for misdemeanor charges. That means around 28,000 people every year are arrested for our lowest level offenses. Arrests and even a day in jail can have serious repercussions on mental and emotional health, as well as jeopardize housing, education, and employment. The effects disproportionately burden people of color, especially Black and African American people in our state. Although they make up only 1.6% of Maine's population, Black and African American Mainers make up 5% of the people arrested here every year. If we want to address these inequities, we must look at new ways of addressing public safety. This bill represents a common sense way to do that. It recognizes that we can hold people accountable for their wrongdoing without unnecessarily incarcerating them before they are ever convicted of a crime. And it removes unnecessary or duplicative criminal penalties for violating conditions of release. Both of these would mark a small but meaningful change in the way that we address low-level offenses. I ask for your support in passing LD 1134. Thank you for your consideration, and someone will be happy to answer any questions you may have. Thank you very much.
Thank you very much, Representative Galgay-Reckitt, for standing in for Representative Talbot Ross to introduce LD 1134, and for committee members and the public, as Representative Galgay-Reckitt mentioned, the proposed amendment is attached to the testimony of the bill's sponsor. And obviously, we will all review that, and it can be the subject of discussion at our work session, although some testifying in support of the bill may be testifying in support of the bill as amended, and we'll give you some insight into that. In deference to the fact that Representative Galgay-Reckitt was just handed this testimony about 15 minutes ago, I am not going to open it up to questions from the committee at this time and put her in that position. So again, thank you very much, Representative, for doing that. And I will now turn to people testifying in support, beginning with Megan Sway from the ACLU of Maine. Welcome, Ms. Sway.
Thank you, Representative Harnett and members of the committee. Hello again, my name is Megan Sway and I'm Policy Director at the ACLU of Maine. I had testimony here provided, but I think I was asked to discuss the amendment because I was part of the task force subcommittee that drafted where this language came out. So I have some personal knowledge about what was said and hopefully can walk you through the bill and the amendments and answer questions to the best of my ability. One of the things that the testimony that Representative Talbot Ross's testimony said was that there was a unanimous agreement in the task force that where it's safe and safe and reasonable, I think we should encourage police to issue summons and not arrests. And so that was a unanimous recommendation. However, the committee did not, or the task force didn't come up with a way to do that. So I don't want to represent this bill as representing having their support in terms of how it's done. Although it did come up in the subcommittee, we didn't end up voting on it. So I just want to be completely clear that this came up in the task force, was drafted in the task force, but I don't want to misrepresent the level of support because it was never voted on. What the bill does is two main things. One, when you're out on bail and you violate bail, it is a separate crime, regardless of what the violation is. So the violation could be not checking in with your attorney, not coming back on curfew, having a beer in your fridge. These are all violations that happen that can lead to a revocation of bail, but it's not just a revocation of bail, it's also the basis of a new crime. And Maine is one of only 7 states where that happens. What this bill does is it vastly narrows which conditions of release would be subject to a new crime. It doesn't mean if you violated your bail conditions that the police could not arrest you for that violation. It's just not a separate charge. And so this is not taking away the ability to hold someone accountable, or if someone is truly dangerous, or there's a reason that police feel that they need to take someone into custody. That is not changed by the bill. It's just this extra Class E or Class C offense on top of whatever is actually happening that would no longer be a crime. And again, Maine is one of 7 states where we sort of duplicate, we double punish someone. So we not only revoke bail, but also can charge them with a new crime. The second thing it does is under Title 17A, Section 15, there are a list of offenses for which police can effect a warrantless arrest, so without a warrant. This bill says for all felonies, police can still effect warrantless arrests. But for certain misdemeanors, they have to have a warrant, so something signed by a judge in order to arrest. And then at the end, it says where it is feasible and not a danger to public safety, a summons should be used. So that brings me to the proposed amendment that I was going to present. And
Ms. Sway,
yes. Is it better for me not to present it? That's fine if it's like completely confusing and you'd rather move on with your day.
I think we'll move on and have the opportunity to hear from that later. And I appreciate your testimony very much. And I know we had some conversations going back and forth, and apologize for any confusion. But thank you.
I will just say, when you do talk about the amendment, it was an effort to address the CLAC concerns. One, that that police should always have the ability to arrest if there is safety implications, and that was something that was, of course, the representative was on board with. It also fix some drafting errors in this first section. Mr. Pelletier was nice enough to tell us that the way it was drafted was not, didn't lead to our intended effect. And so we reworded it pursuant to his great legal knowledge. So those are the two amendments.
Thank you very much, Ms. Sway, and I appreciate your testimony as always. I will now open it up to questions from committee members. Representative Thorne.
Thank you, Mr. Chair. Welcome back, Ms. Sway.
Thank you.
Appreciate you coming on. Am I to understand that maybe you helped Representative Talbot Ross with the wording or any portion of this bill?
So what happens, I was the scribe in the pretrial task force who in a subcommittee. And then yes, I helped her with the amendment language to try to address people's concerns.
Okay, and on that note, in Representative Talbot Ross's opening remarks that Representative Galgay-Reckitt read, she mentioned that there's a disproportionate number of our Black population that have been charged with these, in that she mentioned, I think 1% of the population of Maine is Black, but yet they account for 5% of arrests. But yet the bill doesn't really address anything about minorities or that. Was that just a sidebar, or is that part of what this bill does, is address that I'm not seeing?
I think, I can't speak for her, but my understanding is that she made that remark as part of why she cares about this issue, but not that this bill is attempting to specifically address disproportionate arrest numbers.
Okay, and a follow-up, if I may, Mr. Chair?
Yes, Representative Thorne, go ahead.
And you may be in a position, Ms. Sway, that you will be able to address this or know something of it. Because when I look at this, and again, the mentioning of the opening line was reference to pandemic and how some violations were lowered in the pandemic, and that I won't say they weren't enforced, but they were just not fined or not warranted. Is that a correct terminology?
My understanding is what happened during the early point of last spring was not that I don't know about violations of conditions, but that police were not arresting people for low-level offenses at the same rate that they are generally speaking, that they were offering summonses instead to try to keep jail populations low.
I see. Okay, thank you.
Of course.
Thank you, Representative Thorne, and thank you, Ms. Sway, for those answers. I believe we have a few more questions. Representative Moriarty.
Thank you, Mr. Chair. Ms. Sway, this may be the first time I've heard of the Pretrial Justice Reform Task Force. Did that task force prepare a report and present it to this committee or perhaps another committee?
They did prepare a report, but it was not presented. So it's on the judicial branch's website, but it was not presented to, I think my guess is what happens is that COVID happened and everything shut down before all business was attended to last session.
So it exists, but it was not voted upon by the members, or?
So the certain members of the task force voted on what went in on different recommendations in the task force, but then that task force never presented to the legislature.
Okay, thank you.
Representative Moriarty, we will make certain to get to the entire committee whatever was presented to the Judicial Department that was done by the task force.
Okay, that'll be helpful.
I saw Representative Hagan had a hand up, but I don't see it up anymore.
Well, I thought I had a question, but it's more of a statement than a question, so I don't think I need to say that.
Okay.
Thank you.
Thank you. Thank you, Representative Hagan. Are there additional questions for Ms. Sway and committee members? Seeing none, thank you very much for your time.
Thank you all so much. Have a great
testimony
afternoon.
today, and I suspect we'll be seeing you at a work session.
Great.
Moving forward. I would next recognize Doug Dunbar. Mr. Dunbar, welcome to the Judiciary Committee whenever you are set. And I failed to mention this in the earlier testimony. I do run a 3-minute clock on testimony from anybody other than the bill sponsor or someone speaking for the sponsor. So as soon as you begin to talk, I will start running the clock. But welcome, sir.
Thank you, Senator Harnett, and all the members of the committee. Representative Moriarty, you certainly are welcome to read the task force report. The sad part is that it's very similar to the same type of task force and the same type of report that came out about 5 years prior to it. What we don't do, sadly, is solve problems. And I blame myself for this. Some of you know, I worked in the legislature, I worked in the governor's office, I worked in the US House, I worked in the US Senate, I was Maine's Chief Deputy Secretary of State. I did other things in government. And it all came to an end in October of 2017 when I went to jail for 4.5 months. And you don't need to read task force reports. You don't need to do all sorts of research on your own. I tell my friends in the legislature, my friends who are judges, my friends who are attorneys, you all need to go to jail for 2 weeks. You will trip over each other racing to the revisor's office to submit long overdue and desperately needed submission. I could not believe what an education it was to be in jail. It was the most profound and transformative experience of my life, not because it changed my life, but because of what it opened my eyes to. From start to finish, from top to bottom, we do almost everything wrong. I was in jail with a man named Chad, young man. He lived in the woods in Newport. He loved living in the woods in Newport. Chad was very limited mentally, probably had mild schizophrenia. Chad was in jail over and over and over again for misdemeanor violations. When I was in jail with Chad, he ended up spending 90 days there. At Penobscot County Jail, on average, it's $109 a night. He was there for 90 days for shoplifting because he was hungry. And he couldn't get out because he couldn't come up with $200. And you know, this is what happens. This is what we do. And I'm not speaking specifically about the bill at this point, because I want you all to think of, and I'm sure you do, but I want you to all be passionate and have an urgency about the overall problems. We confine people over and over again, like Chad, to our jails because they're poor and because they're ill. And it's probably 3 minutes, it's probably almost up. But again, I'll submit articulate written testimony. But anything you can do to keep people out of our jails, please try to do that. Lastly, I will say that yes, our law enforcement agencies need to be issuing more summonses. When the numbers dropped last year in our jails because of COVID, we didn't see rampant outbreaks of crime. It didn't happen.
I'm going
to be issuing
to wrap up,
yes.
sir. I'm
Thanks
sorry.
a lot. Yep.
There will
No.
be the opportunity for questions from committee members.
Yep. Thank you all. I understand what it's like to be in your shoes.
Are there questions from committee members for Mr. Dunbar? Seeing none, Mr. Dunbar, I have one, and it may be, I hope that it's something you can answer, and you may give me more than one answer, but of all the, first of all, thank you for sharing your personal experience with us. Of all the lessons, you talked about the education you received when you were in jail and prison. What was the number one lesson that you learned?
Well, you know, very briefly, I spent 4.5 months in jail. Then I spent 15 months in the Penobscot County Drug Court program. I was in jail because I couldn't stop drinking and driving. I self-medicated with alcohol beginning September 11th, 2001. I was John Baldacci's communications director in Washington, D.C., and 2 lifelong mental illnesses that I had, OCD and anxiety, went completely out of control, and I began self-medicating. And years went on and no one knew about any of that, the mental illnesses, the self-medicating. And then not until my 6th arrest did I go to jail for more than a night. I would go back to jail in a second to learn what I've learned. And I really encourage all of you to really talk to people who have been incarcerated. And what I learned is one thing, which most people don't know. Do you folks know that as a country, we incarcerate 6 times more people per capita than Canada? Maine, which is low on the list, between 45th and 50th in rates of incarceration. We in Maine incarcerate 3 times more people per capita than our neighbors to the north. We incarcerate 5 times, almost 5 times more people than they do in Norway. And by the way, I believe Representative Thorne, you asked about how this bill might impact people of color, our indigenous population. Anything you do to keep fewer people out of jail will benefit in an extra way people who are Black, African American, and our indigenous population. Go to jail and see how disproportionately we punish people who are Black, people in our indigenous community, and ultimately people who are poor and ill. The healthy and the wealthy are not in our jails, my friends. They bail themselves out and go home. It's the poor and the ill who are punished again and again and again. And by the way, they're punished again and again before they ever get their day in court. 70% of the people in our jails on average are there in pre-trial status. They can't go home because they can't come up with $200 or $500 or $1,000. So while they sit there, their life outside unravels. Did they have a job? It's gone. Did they have an apartment? It's gone. Did they have main care? It ends, not because they've been convicted of a crime, but because they're in jail. In our society, presumed innocent, right? Presumed innocent. Yep. Convicted of nothing, but punished severely. I say to people, our jails do only one thing remarkably well. Only one thing.
Point of order.
Yeah. I asked a question he's responding to. I'm going to wrap it up very quickly.
I think this is going very far.
Yeah.
Way out of the scope of the question.
I am going to let him finish his answer, but I'm
Thank you.
to wrap it up, sir.
I appreciate that. The one thing that our jails do remarkably well, consistently well, is prepare people to go back to jail. And again, I just want Representative, I don't know your name, but 70% of the people in our jails are there in pretrial status. They're just waiting their day in court, and most can't go home because they're poor and ill. So thank you, Senator. I appreciate it very much.
Thank you, sir. I'm not a senator, but I appreciate the title.
I'm sorry. I'm sorry.
Okay.
Yes, Representative Hart.
But I do want to add, about 20 years ago, I served on what was then called the Maine Bar Foundation. And one of the things I did in that capacity was visit the Maine State Prison, the prison in Warren. And I received an education, and I was only there for 4 or 5 hours. It is a remarkable and not in a good way thing to see. But I thank you very much for your time. And unless there are other questions from committee members, thank you again for being here.
Thank you all.
To our next person to testify, and would welcome back Peter Lehman. And I will begin the 3-minute clock, sir. Thank you for being here again.
Good afternoon. Representative Harnett, distinguished members of the committee. I'm still Peter Lehman. I still live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. As you know, violations of conditions for release, VCR, or bail violations make up more than 20% of arrests in Maine. I actually attached the chart. To a large extent, this is because VCR is a crime. It's a Class E offense. Now, this bill, it took me a long time to figure out exactly what this was, and as near as I can see, if I got it straight, Frank is charged with a crime and released on bail. Employment is a condition of release, but he's laid off from his job, violating that condition of release. Now, so far, Frank hasn't been convicted of any crime, but now he's charged with VCR, charged with losing his job, which is now a crime for Frank. Now let's keep imagining that let's imagine that Frank is found not guilty of the original charge, or the case is dropped, but he's still clearly guilty of VCR. So now Frank has a criminal record that follows him the rest of his life when he applies for housing or employment or licensing or lots of other things. Now, that's not justice. It's also a waste of time and money. It clogs the jails and clogs the courts. This bill examines and selects the conditions of release that may be considered a crime. It also addresses another issue in Frank's story, his arrest for losing his job. VCR is warrantless, but Frank can be taken to jail nonetheless. The bill also prohibits clogging up the jail when a summons would be a feasible alternative. So we urge you to vote ought to pass on this bill that promotes justice and increases public safety and the health of our community. Thank you. Thank you.
Thank you very much, Mr. Lehman.
Sorry to go over.
Are there questions from committee members for Mr. Lehman? Seeing none, I thank you very much for your time.
Thank you. Wish you well for the afternoon.
Thank you, sir. That is all that I had signed up for persons testifying in support of LD 1134. I will check the attendee room one more time to see if there is anybody else who wants to be heard in support of the bill. And I see Andrea Mancuso, if she could be moved over as a panelist, committee clerk. Panette? Ms. Mancuso, you are here to testify in favor of LD 1134?
Yes.
Thank you very much. It's good to see you again this afternoon. Sometimes it's just hard to keep track from how people have registered. But in your testimony whenever you're comfortable.
Thank you. Representative Harnett, distinguished members of the committee. I'm here today. My name is Andrea Mancuso again, and I'm here today on behalf of the Maine Coalition to End Domestic Violence in support of LD 1134. As this committee has heard from me already this session, in Maine, conditions of release are an important component of achieving safety in times of acute crisis for survivors of domestic abuse and violence who reach out for criminal justice system intervention. The ability for law enforcement to effectively respond to a violation of conditions of release in the moment is important, particularly as it pertains to orders around no contact with the victim, staying away from certain locations, and firearms relinquishment. LD 1134 advances an approach that moves us forward with needed reforms around limiting the ways in which violations of conditions of release have had a harmful and disproportionate impact on defendants and Maine's criminal justice system, while ensuring these reforms are not likely to compromise victim safety in the moment. We greatly appreciate the willingness of Representative Talbot Ross and other interested stakeholders to collaborate over the last several years around ensuring this proposal attends to the need for that balance. MCDV did participate on the pretrial criminal justice reform task force that was referenced by Attorney Sway, and for the most part are very supportive of those recommendations. Just again emphasize that a defendant who is charged with OUI and released on conditions not to have a beer in the fridge, who is then found with a beer in the fridge, is a very different public safety challenge than a defendant who has assaulted a partner, prohibited from having contact, who is then re-engaging and having contact with that partner. And our criminal justice system should be structured in a way to ensure that we're allocating resources in a way that makes sense to respond to both of those public safety needs. We would submit to you that LD 1134 gives this committee a path to decreasing the overcriminalization of substance use and untreated mental health struggles without compromising the ability of the criminal justice system to respond in the moment to those violations that are most likely to have real consequences around victim safety. So thank you for letting us be heard on these important issues. MCDV and our member programs are happy to be a resource to the committee on this issue, and would enthusiastically continue to work with other interested parties around any work that needs to happen to move this forward.
Thank you very much, Ms. Mancuso, and thank you for your service on the task force. It's greatly appreciated. I will now turn to committee questions, and I recognize a real hand from Representative Libby. You may proceed.
Thank you. I still proceed to look for my electronic hand to lower it, ironically, after I have a physical hand raised. Thank you for being here, Ms. Mancuso. Do you intend to submit written testimony? I usually read along, and I had noted that there wasn't one.
Yes, my apologies. I have it. I just have not taken the administrative step to load it into the system yet.
Thank you. It's always helpful to be able to reread that for work session.
Thank you.
Thank you very much, Representative Libby, and your real and electronic hands are no longer on the screen. So thank you. Representative Moriarty.
Thank you, Mr. Chair. Ms. Mancuso, is your primary concern the revocation of bail upon a violation of a condition, or the treatment of that violation as a separate freestanding crime?
Both.
What's the problem with, let's say it's a serious offense, not just a minor one. What's the problem in revoking bail if someone does something, really inappropriate or threatening? Or
I think given the resources and the current structure of the system, it would not be administratively feasible to accomplish a bail revocation in the way that charging violations of conditions of release allow you to take the defendant in the moment and move them away from the victim and give that victim some peace and clarity. Our bail codes are very purposely structured to be able to provide that sense of security on a Friday evening until a judge can see a defendant in the morning for domestic violence assault and for violations of conditions of release. In terms of the separately charged crime, I think that our state often uses that as a method for evidence-based prosecution that alleviates the need for the victim to relive in trial their traumatic experience. Instead, quite frequently, the state will move forward with a conviction for violations of conditions of release as opposed to the underlying domestic violence assault. So there's utility in both aspects of that from the experience of our network.
Okay. Mr. Sherry, one more question, if I may.
Absolutely, Representative Moriarty.
Ms. Mancuso, has this, well, not this very bill, but something like it been assigned to criminal justice and public safety? Are they dealing with any bail reform bills to your knowledge?
The two conditions of release bail bills that I've seen have landed in this committee. I believe Representative Morales's bill around conditions of release was heard earlier this week in this committee, and this one. I could be wrong about that. I think we're sort of responding to them as they get scheduled.
Okay, thank you.
Thank you, Representative. Representative Galgay-Reckitt. You're muted, Representative.
I pay pretty careful attention because I'm on both committees to which, if things end up in the same topic ends up in both places. And I think there was a deliberate intent to shift this particular type of violation into the Judiciary Committee. And there's a bunch of other stuff in criminal justice that will impact these same people, but not in the same kinds of ways.
Thank you, Representative Reckitt. Did you have a question, or is it just filling us in on?
No, I just trying to give you the info. Yeah.
Thank you. Thank you very much, Representative Reckitt. Are there any additional questions for Ms. Mancuso? Seeing none, I thank you very much for your time today, and the committee appreciates your testimony.
Thank you.
I will check the attendee room one more time to see if there are any persons wishing to testify in support of LD 1134. Please raise your electronic hand. Seeing none, I will ask, are there persons in the attendee room wishing to testify in opposition to LD 1134? And I recognize Bill Harwood, who had registered to testify, and he's been moved over as a panelist. Welcome, Mr. Harwood. We appreciate you being here today, and you may proceed when you're set.
Thank you very much, sir. Good afternoon. I'm Bill Harwood. I'm the Lieutenant Colonel of the Maine State Police. I'm sitting in for Major Bill Ross, who is away today, and I'm going to be reading his testimony. So this is the testimony of Major Bill Ross. Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. This is the testimony of Major Bill Ross. I'm here to represent the Department of Public Safety and the Maine State Police to testify against LD 1134, an act to amend the bail code regarding certain conditions of release, and the Maine Criminal Code regarding warrantless arrest. The proposed bill would remove several provisions from the Maine bail code related to violation of conditional release, all Chapter 45 offenses, which are drug offenses, theft less than $1,000, forgery, and failure to appear are proposed to be removed. These items should remain in statute as a violation of a conditional release as a Class E crime. Drugs, theft, forgery, and failure to appear are significant crimes, which should continue to have a conditional release component. Without these conditions as a violation, offenders potentially could continue with the same or similar behavior they were initially apprehended for when out on bail. This bill as written would have a detrimental impact on public safety and officer safety, leading to the repeat calls for service without the ability to take someone into custody. Bail is intended to ensure one's appearance in court and to protect the greater public. The law enforcement's ability is also hamstrung when these conditions are removed. The removal of failure to appear as a violation could significantly increase the number of warrants by removing an effective mechanism to ensure court appearances. Most notably, the proposed legislation would remove all drug offense conditions as a violation, further inhibiting law enforcement's ability and keeping the public safe. The second part of this bill amends provisions of the Maine Criminal Code regarding law enforcement making warrantless arrests and prohibits a warrantless arrest for certain Class D and E crimes when it is feasible to issue a criminal summons. The bill would limit law enforcement's ability to make an arrest and require a criminal summons for the same violations mentioned earlier. There are instances where an arrest or summons would be the better choice for law enforcement to handle a situation. Currently, law enforcement officers have discretion with the ability to issue a summons in lieu of arrest. There are times when a summons is more appropriate than arrest and vice versa. Law enforcement encounter multiple incidents where taking someone into custody and deciding not to issue a summons is the more appropriate course of action regarding public safety. When a law enforcement officer is unable to take an offender into custody, essentially removing the problem from the area, these incidents, which usually start as nuisance complaints, can quickly escalate, leading to more serious incidents and crimes. Bail reform is an important topic for discussion. The Department of Public Safety and the state police are committed to constructive conversations related to the safety and well-being of all people. For these reasons, I strongly urge the committee to vote ought not to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time. I'd be happy to try and answer any questions that you might have. And if I could add just a little bit to the end of the testimony, I did meet with Representative Talbot Ross this morning. I'm very newly assigned to this bill to speak to you today. I also spoke with Ms. Sway in the same conversation with Representative Talbot Ross. It was a very constructive conversation. We are going to meet again before work session, and we are committed to working together on this bill. Do recognize that it's possible we didn't fully understand what the first half of this bill would do related to violation of conditions of release. Still trying to digest all of that and consider it. So just wanted to put that in there as well. Thank you.
Thank you very much, Lieutenant Colonel Harwood, and thank you for that addendum. I know what it's like to be thrown into something at the last second that can be incredibly complicated. And we truly appreciate your being here today and reading that testimony into the record. I would ask if there are questions from committee members, and I will call on you in the order that I think I saw the hands come up, starting with Representative Thorne.
Thank you, Mr. Chair. Welcome, Lieutenant Colonel Harwood. I appreciate you being here today, and thank you for all the hard work you and everyone at Maine State Police do to help keep us safe.
Thank you, sir.
My question is, you kind of touched on it there when you said that there's a possibility that maybe some of your ability to remove someone from a situation, i.e. take them into custody, would be a tool that would be taken away. Did I understand it when you said that?
Yes, sir.
For some of these lower level things that maybe at the time they're lower level, but if you walk away and you're not able to take them into custody with your experience and being able to read people, that maybe it could escalate into something greater and cause more confusion than the initial reason for the response. Is that correct?
Yes, sir, that is correct.
Okay, thank you for clearing that up for me.
Thank you, thank you, Representative Thorne. Representative Moriarty.
Thank you, Mr. Chair. Colonel Harwood, like you, I'm sort of grappling with this for the first time and struggling somewhat to understand the full scope. But I wanted to draw your attention to the final section of the bill, section 6. This, I take it, really has nothing to do with violation of bail conditions. I don't mean to put you on the spot, but is that a fair statement?
I believe section 6 is related to our ability to make an arrest for a misdemeanor committed in our presence, and it's not part of bail conditions. That's my understanding as well.
Right. Okay. So if a person is caught in the act, so to speak, they're running out of Walmart with a cart full of merchandise not paid for, probably it's an E or a D level based upon the value of the merchandise. In your judgment, would it be feasible to issue a summons in that instance and not actually arrest the person?
In that specific circumstance, it's so hard without being in the very circumstance.
Yep.
There's so much that goes into the decision as to whether or not you need to arrest somebody or whether you can summons them. Certainly, I think we already do apply very good discretion. It certainly has been my experience from my own career and for the officers that I'm with. You're not looking to arrest somebody. There's no, arresting is not the goal. It's stopping the problem. Whatever is occurring, which the public is complaining about, which they're asking you to help with, that may continue if you give them a summons and you walk away or you leave, that condition, whatever it is that might be, might continue after you go. And then you come back and I'm not sure what you do. There is the provision, I just want to make sure I'm clear because I'm still grasping, still trying to understand it, that it does talk about when feasible. So maybe that is that ability, or maybe that doesn't constrain us as much as I'm thinking. So I have to think that all through. And I know that there's an amendment that's coming on that as well. So there's a lot to consider and a lot to think about. How much do we still have the ability, if this law passes, to solve a problem on the spot? And maybe it's okay, I don't know, but we need a little more time to work on it.
Okay. As a very quick follow-up, is a person's status as a transient versus a resident something that you would consider in issuing a summons or making an arrest?
I can tell you, I can't think of an instance that I can draw from to say that I have done that I've considered, whether I actually just can't think of my Chelsea, Randolph, Pittston, Dresden patrol areas that we had transients. So it might be something that more that a municipal police officer deals with more than a state trooper.
Sure. Okay, good. Thanks.
And Representative Moriarty, I just want to point out, as Lieutenant Colonel mentioned, the section that you asked about, section 6, which is title 17A MRSA, section 15 sub 1 hyphen capital A, is part of the amendment, and added the language after it when it is feasible and not an undue risk to public safety. So that is part of the amendment that's been submitted.
Good. Thanks.
You're welcome. Are there additional questions for the Lieutenant Colonel Harwood? Seeing none, thank you very much, Lieutenant Colonel. And I live in Gardner, so you worked in the area right close to my home. Thank you again for your service.
Thank you. Thank you all.
I will now again turn to the attendee room to see if there are any persons here today that want to testify in opposition to LD 1134 that might not have registered through the online portal. And seeing none, I will turn to our final category and ask if there are persons who are interested in testifying neither for nor against. And I will recognize John Pelletier, who's been added as a panelist on behalf of the Criminal Law Advisory Committee. Welcome back, Mr. Pelletier. Seems like we see you every day, but thank you very much for being here.
I hope that's not tiresome for you folks. Representative Harnett, members of the committee, John Pelletier, Chair of the Criminal Law Advisory Commission. The commission was divided on the bill. The bill would reduce criminal charges for violating conditions of release. It would reduce the number of instances where a warrantless arrest was authorized. Those are the two main things it would do. If you're looking at the bill, section 4 of the bill and below deal with warrantless arrests. They don't have anything to do with bail conditions. So what the bill wants to do is in the bail code, there's a list of 19 bail conditions that are numbered. What the bill says is that you can be arrested for violating conditions of release if you violate conditions 4, 5, 8, 13, 19, and 10A in the original bill, and in the amendment 10A comes out. So all of the other conditions that are in the bail code a violation of those conditions would not give rise to a charge of violation of condition of release. Some of our members think if your bail condition is a court order, if you violate it, that should constitute a crime. Others think that the charge of violation of condition of release is overused and it's appropriate to roll it back. We have sort of the same thoughts about warrantless arrest. But I'm sorry, I want to go back to the violation of conditions of release. There's a large carve out in the bill. So if the underlying charge, the thing you're on bail for, is a domestic violence charge or a sex offense, basically, then you can be arrested for violating any condition. So it creates two sets of people on bail. If you're on bail for a sex offense or domestic violence offense, under the bill, you would still be liable for arrest for any condition. But if you had some on bail for some other offense, then you could be arrested or charged with violating condition of release only for violating some conditions. There was, I believe Ms. Sway said you could still, even if you weren't able to charge violation of condition of release, you could still arrest someone for violating their bail conditions. That is true in the process of revoking bail, but it requires either a warrant from the court, or in a warrantless context, it requires a specific request from a prosecutor to a law enforcement officer saying, go arrest this person. So it's a very cumbersome thing as compared to violation of condition of release. And I think with that, I'll stop and I'll be glad to answer any questions.
Thank you very much, Mr. Pelletier, and I apologize for the phone making noise. Are there questions for Mr. Pelletier from members of the committee? Seeing none, thank you very much for your time and testimony on a variety of bills. We appreciate, as always, the testimony that you provided. I will take one last look in the attendee room to see if there is any person who wishes to testify in any way regarding LD 1134. If so, please raise your electronic hand. And seeing none, I will close, having heard all the testimony presented by members of the public present and wishing to testify, I will close the public hearing on LD 1134. Appreciate, again, Representative Galgay-Reckett stepping in for the bill sponsor to introduce the bill, and for Representative Talbot Ross for bringing it forward. And with that, we will move on to our final public hearing of the day. And I will now open a public hearing on LD 1226, which is a resolve directing the Permanent Commission on the status of racial, indigenous, and Maine tribal populations to examine restorative justice. It's my pleasure to recognize and welcome the bill sponsor, Representative Rachel Talbot Ross, to introduce LD 1226. Welcome, Representative.
Oh, good afternoon. And before I begin, I just want to offer my sincere thanks to Representative Reckett for coming in and handling that rather intense testimony at the very last minute, and to you, Representative Harnett, for making the last minute changes, along with every member of this committee, for your understanding. So thank you very, very much, Representative Reckett. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary, my name is Rachel Talbot Ross. I represent House District 40, which comprises the neighborhoods on the peninsula of Portland. I also sponsored the legislation that established the Permanent Commission on the status of racial, indigenous, and Maine tribal populations in the 129th legislature, and I now serve as one of the chairs of that commission. I want to thank you for the opportunity to present LD 1226. For those of you who do not know, the Permanent Commission is an independent entity with a mission to interrupt structural racism by examining racial disparities across all Maine systems, and to specifically work toward improving the status and outcomes for historically disadvantaged racial, indigenous, and tribal populations. We are empowered to advise all three branches of government and can submit our own legislation. Our membership includes representation from the federally recognized tribal nations in Maine, along with people from diverse racial backgrounds. LD 1226 directs this commission, the Permanent Commission, to review restorative justice legislation that has been proposed and passed across the country. It charges the Permanent Commission with making recommendations for restorative justice legislation in the following areas: education, juvenile justice, adult diversion, and correctional settings. Finally, the bill authorizes the Permanent Commission to submit legislation based on its findings and recommendations for consideration during the second regular session of this legislature. What is restorative justice? It is an approach that focuses on rehabilitation of offenders through reconciliation with those who have been harmed and the broader community. It is a value. It is an ideology. and it is a practice. In terms of the specific practice, there are three fundamental tenets as follows. One is repair. So crime causes harm, and justice requires repairing that harm. The second is encounter. The best way to determine how to do that is to have the parties decide together. And three, transformation. This can cause fundamental changes in people, relationships, and communities. Research shows that restorative justice programs improve outcomes and lower recidivism. They are also very cost-effective. Over the past 20 years, Maine has seen a growing movement of citizen-led restorative justice organizations. You will hear from some of them and practitioners, stakeholders today, and they will speak to the transformational impact and incredible potential of restorative justice practices. As I have worked with these stakeholders in recent years to identify the best way to codify restorative justice in Maine law and support its practice in our systems, it has become clear that we need to bring everyone to the table to determine the right path forward. Stakeholders identified the Permanent Commission as the best place to convene this work. Why the Permanent Commission? Well, because any meaningful examination of restorative justice must be led by people of color who have been disproportionately impacted by disciplinary practices, expulsion, and incarceration. Restorative justice is also deeply rooted in Indigenous practice and values, not just here in Maine, but around the world, and not just historically. Indigenous people continue to lead efforts today, and the Penobscot Nation Adult Healing to Wellness Court is a prime example. Another would be the Wabanaki Truth and Reconciliation process that happened several years ago. We believe there is no need to create a new commission or working group when the Permanent Commission is so uniquely positioned to convene this effort. And I will just emphasize, this bill is about a convening of all parties and stakeholders who are concerned with and utilize restorative justice in their efforts today. On a personal level, I have been involved in restorative justice for years and have witnessed firsthand its potential to address root causes of harmful behavior and support healing throughout the community. To me and to the restorative justice practitioners you will hear from, this is clear. We must focus on restoration, not retribution, in our justice system and beyond. That is why I am so deeply committed to alternative methods of addressing harm and resolving conflict. I want to end by thanking Senator Carney and Representative Harnett for signing on to be co-sponsors of this bill. And I ask you for support in LD 1226. And thank you for your time and consideration. And of course, your patience and flexibility throughout the day today.
Thank you very much, Representative Talbot Ross, for bringing LD 1226 forward to the committee. We appreciate your time. And I would now open it up to questions from committee members for the bill sponsor, Representative Rachel Talbot Ross. Seeing no questions from committee members, thank you very much, Representative Talbot Ross. You are free to stay as a panelist in the public hearing, although I wouldn't.
No, I want to stay. Thank you.
Okay, well, you're welcome. You've got a good seat right in the box on my left. I will now turn to persons testifying in favor of LD 1226, and I will begin with Arthur Jones. Welcome to the Judiciary Committee, Mr. Jones. I will only announce this once, but we do run a 3-minute clock on persons testifying other than the bill sponsor. So as soon as you are ready to go and feel comfortable, please begin testifying. Thank you.
Thank you, Representative Harnett and distinguished members of the committee. I am Dr. Arthur Jones, and I'm a career professional in the criminal justice field with 28 years of experience in corrections and juvenile justice. And I'm a volunteer at the Restorative Justice Project in Maine, and I live in Belfast, Maine. I strongly support LD 1226 as an unbiased tool to research and examine the best practices of restorative justice. It is time to take a new look at the way we do things with criminal justice in our community. I've worked for 28 years and I've served on our pro board in 2 different states, total of 18 years in New Jersey and Rhode Island. I moved to Maine 15 years ago, and shortly after got involved with restorative justice. And I've firsthand seen some of the people that has been affected by participating in restorative justice who would otherwise have ended up in the criminal justice system and coming before a person like me in the parole system. But unfortunately, Maine doesn't have parole, but that would have been the case. And it has been, I've seen that it's been a waste of money for some of these people to have been incarcerated. It made them worse individuals when they return to the community. And so this is why I strongly support 1226 as a way to research and find out if restorative justice really works and try to get support behind restorative justice. Now, what are the benefits of restorative justice? Reduces recidivism. Restorative justice has a high rate of success in reducing repeat offenders. Increased safety. With reduced recidivism comes safer community. Very cost effective as opposed to incarcerating people. I won't go into trying to compare the cost. I think most of you who serve in the legislature know that there's extreme cost with incarcerating people. A stronger community, empowerment, meaningful dialogue, victim input, recovery and satisfaction, and an opportunity to make things right for the victims and for the community. I feel the Permanent Commission is a genius idea to have this research done by the restorative by the commission. As I found today, and I don't know if it's correct, I just got it through the grapevine that the budget has been approved for the Permanent Commission, whereas they didn't have a budget before. They just got approved for $2 million to be able to hire staff and put the people in place that they need to be able to do this type of research. So I think it's an excellent idea to have them doing this research.
Thank you very much, Dr. Jones. You have gone a bit over the 3 minutes, but if you could just wrap up, and then there will be an opportunity to respond to questions from the committee.
Okay. Well, I want to thank you for allowing me to participate, and I'm here for any questions that any of you may have. And I'm also available for any criminal justice bills that come up or police reform bills that come up. If individuals want me to volunteer or be involved, I'll be more than happy to do so. And thank you, Mr. Chair.
Thank you very much, Dr. Jones. Thank you for being here today, and thank you for that gracious offer. The one problem is when you make a gracious offer like that, we will take you up on it. So, but thank you very much. I will call on committee members in the order that I believe I saw their hands go up, starting with Representative Thorne.
Thank you, Mr. Chair. Welcome, Dr. Jones, again. Thank you for your testimony. And for a point of clarity, and if Representative Talbot Ross is still on, maybe she could verify for me that I thought I heard her say that in her introduction for the bill, that the commission would be made up of people of color and indigenous people only. Did I hear that right?
Not only, it will be, there are members of both people of color and indigenous people on the committee, but it's not only people of color and indigenous people on that commission.
Okay. No, and I did hear. So it would just be a makeup that would be assured at least one person of color and at least one Indigenous person represented on the commission.
Yeah, that would be the reverse order, and we don't want to do that. It's like almost like reverse discrimination.
That's why I ask these clarifying questions. Thank you. And if I may ask a follow-up, Mr. Chair?
Yes, you may, Representative Thorne.
Thank you. And at this point, we don't know how many people will be on this commission. Is that correct, or am I missing that somewhere in the language?
I'm not sure. I didn't do, I haven't looked at the numbers, but I could find that information out for you, make sure that you get it.
All right. Thank you.
Thank you very much, Representative Thorne, for the questions. Thank you for the answers, Dr. Jones. Representative Evangelos.
Thank you, Mr. Chair. Well, Mr. Chair, halfway through his testimony, my hand went up, and he's got his first taker. As I heard him speak, I realized that how important his expertise and voice would be in LD 842, the Act to Reestablish Parole in Maine. At the leave of the chair, can we invite him to that bill to help us?
He did make an offer and discuss his experience and expertise with parole. I will certainly take that under advisement, Representative Evangelos.
Can I speak?
Absolutely, Dr. Jones. Question was posed to you
Yes,
as well.
I'm happy that you brought that to our attention. It was on my agenda to give you a call because some of the things that are in your draft bill, I would like to sit down with you and the committee and maybe participate in the work section on that. There's a lot of work to be done. I think it's a good idea to bring it back, but we need to make sure we bring it back where it's effective and don't cause any further harm to parole or the people in the community. So I'm more than happy to work with you on that.
Thank you. Thank you for that offer. Any additional questions, Representative Evangelos?
All set, thanks.
You're very welcome. Are there questions from other committee members for Dr. Jones? Seeing none, thank you very much, Doctor. Appreciate your time, your testimony, and your willingness to come see us over and over again. It's greatly appreciated. I will now look for our next panelist, who I imagine will be slid over very quickly. I believe it will be Abigail Maycock, but I'm not certain. And indeed it is. Ms. Maycock, whenever you are ready to testify, please activate your video and unmute your microphone and begin speaking as soon as you feel comfortable. And welcome to the committee today.
Thank you for having me. Thank you all esteemed members of this committee. Thank you for your time. I know it's been a long day and for all the work you do for this great state. My name is Abigail Maycock. I am the co-director of the Maine Youth Court. I'm a clinical social worker and resident born and raised in Midcoast, Maine. I live in Portland now. I'm here today to express my strong support of LD 1226, directing the Permanent Commission on the Status of Racial, Indigenous, and Maine tribal populations to examine restorative justice. We're living in an important moment where conflict and change are calling for us to evolve and transform the inequities and biases that cause so much pain, suffering, and even death in our own home state. Today, we must face the facts that these disparities fall along lines of race and cause harm to Black, Wabanaki, and other communities of color. From disproportionate contact with law enforcement, judicial systems, expulsions from schools, lack of access to resources and supports, it's clear that we need to do something better to serve everyone in Maine. This commission was created last year to examine these disparities and to make recommendations, such as focusing on the disproportionate effects of COVID. But there's so much more work to be done. And we're really at this critical moment now with restorative practices in Maine. It's such a popular way to move forward for us. It's being activated in our schools, in our Department of Corrections across Maine, and it's also being practiced in the Wabanaki communities, as Rachel expressed earlier. At the heart of restorative justice are values that align with what I think you all would want for every Mainer: to experience mutual respect, human dignity, humility, choice, and opportunity to make things right. Research has shown that restorative justice saves taxpayer dollars, supports recovery from substance use, keeps kids in school and out of jail, and offers a path forward for those with mental illness. Across political divides, independents, Republicans, and Democrats have come together calling for criminal justice reform in support of restorative practices nationwide. The Maine Youth Court was started by a diverse bunch across the aisle, an attorney, several youth who actually got in trouble themselves, a JCCO probation officer, and a social worker. They all came together to find a different way forward. And that was through restorative practices. While everyone doesn't always agree, the willingness to work together and come together to find a path forward, to listen to each other and to hold each other accountable with support and honesty is what LD 1226 offers our state. It's an opportunity to take accountability for the inequities and the unfairness that exist here in Maine and do so in a restorative way that is led by those who are most affected. This commission is an independent body that can speak from lived experience as well as make recommendations with the latest research and policy to inform best practice in restorative justice and reform in our state. At a time when our own state systems of care are utilizing this practice, is that my time?
It's your warning to wrap up, if you could, ma'am.
Perfect. Yeah.
Questions. Thank you.
I'm on my last paragraph, so thanks. This work takes time and must be held in a sustainable and adaptable way. There's still much work to be done. So I'm calling on all of us to roll up our sleeves and do this work for every Mainer. And I urge you all to support this important commission and make it permanent by voting for LD 1226. Thank you so much.
Thank you very much for your time and testimony and for the work that you're doing for the people in the state of Maine. I would open this up to questions from members of the committee. From Ms. Maycock. Seeing none, again, thank you very much. Representative Hagan.
Okay, this is new to me, so I appreciate the information. So is this bill saying that restorative justice practices could possibly replace jail time for crimes committed?
My understanding is that this would inform legislation. And so we don't actually know what that legislation could be quite yet, but that it would inform best practices based on policy and research and what specifically is happening here in Maine.
Okay,
and,
and would that entail like any crime?
Sorry, could you repeat that again?
All right, would that entail, would this commission provide advice on all crimes A through E?
I'll have to get back to you specifically on that. I do know earlier Rachel was talking about specific spots that it is going to focus on. I'm not sure in terms of the law and which crimes that would fall under that, but I know it's specific to education, juvenile, diversion for adults specifically. I might be missing one, but I know Rachel could offer more with that.
Yeah, I have a lot to learn, so so I thank you for your answers. Continue to stick with it.
Thank you very much, Representative Hagan. Are there additional questions for Ms. Maycock while we have her before us? Seeing none, thank you very much for taking the time out of your day today to provide the committee with testimony. We greatly appreciate your input. The next person I will recognize testifying in support of LD 1226 is Cushman Anthony. Welcome, Mr. Anthony, and just activate your video, unmute your mic, and begin testifying as soon as you're comfortable. Welcome to the Judiciary Committee.
Thank you. I trust you can see me. I can't see myself anymore.
We can hear you, but we cannot see you. Your video is not activated, and I do not know how to activate it from my end.
I got it.
There you are.
So, Representative Harnett and distinguished members of the Judiciary Committee, my name is indeed Cushman Anthony, and I live in Yarmouth. I am a retired lawyer and mediator. I was a member of the House of Representatives from 1986 to 1992, and was a member of this committee during the 114th and 115th legislature. I am not representing any organization in my appearance before you here today. I'm here in support, strong support of LD 1226. I believe that restorative justice has much to offer to the state of Maine. Here's a little history for you all. I first became interested in restorative justice starting in 1998, when I helped to establish and run a small community mediation center in Portland. A friend introduced me to the concept of victim offender mediation, and we began using those techniques in dealing with juvenile delinquency cases. I quickly discovered that this is a far better method for helping juveniles fully understand the effect of their negative actions they have on other human beings, and thus is quite successful in particularly that setting and some others. The Department of Corrections began using it, and this is about the time that the Restorative Justice Project of the Mid-Coast began its operation. Now, several years later, a friend established the Restorative Justice Institute of Maine, and I agreed to be a member of its board of directors. Its first activities were helping communities set up panels to address school discipline issues and related problems. The organization has grown well beyond that now. It has learned that there are many different practices described as restorative, which are useful in resolving a broad range of conflict situations. And to answer the question, all crimes, probably the more minor crimes, but it has been used in even, well, murder and rape, not in Maine, but some people have decided to try that. And I think it was partially successful. So many other groups have become active in approaching restorative practices. All restorative practices share some core values, as you've already heard. Belief that when conflict arises, the goal must always be restoration of peace and harmony rather than punishment. The first task is to determine who has been hurt and what are their needs. How can things be made right, and who has the responsibility to do that? And what can be done to prevent that from happening again in the future? Restorative practices include helping groups to avoid or minimize conflicts as well, along with resolving issues after they arise. Learning about the many restorative techniques can help the Permanent Commission come forth with some good recommendations and address its central mission. I urge support for this.
Thank you very much, Mr. Anthony. We appreciate your being here and bringing the expertise of dealing with restorative justice over the decades. Are there questions from, and actually Representative Hagan, I had seen your hand up and I hope that I didn't miss it. Was that just a residual hand from?
Yes, I had my first brain cramp where I completely forgot to take it down. Thanks.
We always forgive one brain cramp. Are there questions from committee members for Mr. Anthony? Seeing none again, thank you very much for taking the time to present your testimony to the Judiciary Committee today. We greatly appreciate it.
I will plan to be present for the work session.
Well, thank you. We appreciate that as well. I will next.
I'm just one of many experts in this field. I see Jay Davis is coming up and he's another one.
And we are about to hear from Mr. Davis, and welcome to the Judiciary Committee, Mr. Davis. Whenever you are comfortable, please begin delivering your testimony.
Thank you, Representative Harnett and members of the Judiciary Committee. I'm Jay Davis, Chair of the Restorative Justice Project Maine Legislative Committee, and I live in Belfast. We strongly support LD 1226 as the best opportunity we have seen to bring successful, equitable experiences with restorative justice from across the country and in Maine to the legislature. The bill presents two key questions that I will try to answer. The first is, why restorative justice? RJP has been training, coaching, and facilitating the use of restorative practices in schools, the Maine Coastal Regional Reentry Center, Long Creek Youth Development Center, and community venues for 16 years. This work would not have been possible without the partnership, collaboration, and support of community volunteers and agencies such as the Department of Corrections, Sheriff's Departments, and school administrators who were seeking alternatives to practices of punishment and exclusion. We believe the best form of justice is based in communities and is focused on repairing harm rather than punishment. Our work is highly cost-effective and it works. Later this year, we'll roll out 2 of 4 community justice centers in the Mid-Coast with a nearly $1 million grant from the Department of Justice. The centers are both a signal of our success and a call for growth. We and others are ready to see that restorative justice services, already proven but not yet deeply or inclusively studied here, become available statewide. The second question is, why the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal Populations? To me, the Commission is uniquely qualified to research and analyze the use of restorative practices. The foundational principles of restorative justice come to us from Native cultures around the world. The Permanent Commission is aware of and committed to resolving the disparities among races and classes in Maine, and restorative justice is both an ethos and a set of tools and practices central to that effort. And when it receives the support funding LD 1034 will provide, the Commission will have the staff and research strength it needs to accomplish its many vital tasks. I see the mating of restorative justice and the Permanent Commission as a strong signal that Maine is ready to resolve important disparities in our society. I strongly urge the committee to give a unanimous ought to pass vote on LD 1226. And I thank you, and I'm happy to take any questions.
Thank you very much, Mr. Davis. The committee appreciates your time and testimony, the work you're doing on this, and your collaboration, successful collaboration with the Department of Justice. Are there questions from committee members for Mr. Davis? Seeing none, I would again thank you very much for your time, testimony, and willingness to work on this issue. Greatly appreciated.
Thank you.
The next person I will recognize is Jonathan Sarbeck, the Cumberland County District Attorney. Welcome, DA Sarbeck. It's nice to see you again. And please begin testifying as soon as you're ready.
All right. Thank you for having me, Representative Harnett, members of the Judiciary. I'm here in support of LD 1226. I also wanted to thank Representative Talbot Ross for bringing this forward. Myself, as the District Attorney of Cumberland County, along with numerous other district attorneys throughout the state of Maine, support 1226 because we believe that it would give a study that would allow the expansion of restorative justice, not just through our community, but also into the criminal justice system. I've been very fortunate in Cumberland County to have started some restorative justice programs and expanded other ones that already existed here in the District Attorney's Office, not just as a diversionary tactic from the criminal justice system, but also as a means of resolving cases in a way that bring about victims. From doing research and talking to people who have worked in restorative justice for many years, and you've heard from experts today, and you'll continue to hear from experts, the victim satisfaction that comes out of participating in this restorative justice is something that drew me to the restorative justice process, because in a way, the District Attorney's Office doesn't just go about trying to bring about public safety, but also speaking for victims and reducing recidivism, with the hope that we were going to come up with a resolution in a case that's going to decrease the chances that an offender would return back into the criminal justice system. So that's a draw for me as a prosecutor and as a district attorney. We've been working with the Portland Center for restorative justice, the Restorative Justice Institute of Maine and Maine Youth Court, some people that you've already heard from today. And we've really come to realize that this doesn't just work in the juvenile setting, but also in the adult setting. And we've been diverting cases since last year from the criminal justice system, either pre-complaint or post-complaint, but before the dispositional conference, leading to a dismissal. We've had about 200 successful cases with dialogues that have resulted in dismissals, and very few reoffenses from those individuals who have participated in the dialogues. Granted, it is still early to come to conclusions completely. At the same time, though, I think that those signs are very promising, and I'm hoping that this study being done by the Permanent Commission would allow the expansion of these restorative practices into the criminal justice system and throughout the community. I can't, obviously I work in the criminal justice setting. However, I've seen these be successful in school settings, including South Portland High School and the Wyndham High School here in Cumberland County. When these things grow organically, you really see a buy-in that really can help with people being diverted from that system. So I would support, I would ask that the committee vote ought to pass, and I'd be happy to answer any questions. And I apologize for going over my time.
Actually, you did not. I gave you the warning at 10 seconds and you wrapped it up.
Okay.
Thank you, District Attorney Sarbeck.
Thank
Are
you.
there questions from committee members for DA Sarbeck? Representative Hagan.
Yep, thank you very much, Mr. Chair. I've been looking, I like to read as Representative Libby likes to read the testimonies. I do too. I can't type fast enough to get everything. I was looking for yours in both portals. I didn't see it. Do you mind sending one?
You just heard my testimony, sir. The trial attorney in me likes to kind of speak from my notes and what I've done. And, I'd be happy to try to put that into context for you if you'd like, but I did present testimony today.
All right, thank you.
Thank you, Representative Hagan. Are there additional questions for DA Sarbeck? I have one before we let you go, sir. Listening today about the principles of restorative justice, I keep hearing terms like it reduces recidivism, can reduce incarceration, reduce costs, resolves conflict, and one that was important to me, that it allows victim input. And I'm wondering if you could address your experience in that regard.
So from speaking to people who have participated in victims, they have really come away with feeling more satisfied about the whole process by being part of the process. I mean, I think that one of the things we pride ourselves in at the Cumberland County DA's office, and I think that other DAs would say the same, is that we by statute, but also by our ethical obligations, have to keep victims informed through the process involving criminal justice or involving a criminal case. This allows an opportunity for individuals to come face to face with their offender and not just understand the harm that was done, but in a way, as Representative Talbot Ross talked about, really kind of transforming their understanding of why it happened. So I think once you can really sit down with an offender and understand why this person did this, it really can bring about that satisfaction of a person understanding the harm that was done. Now, granted, offender accountability is very important in the restorative justice process. And it's also very important to me because I do think that if somebody had a better understanding about the harm that they cause to other individuals or to the community as a whole, they're more likely to not reoffend because they will have that better sense or that greater sense of how their actions can affect other individuals, as opposed to simply paying a fine or something along those lines. So I think really sitting down and digesting what is being told and the effects that it had on other people really can be that transformative process that restorative justice can bring about.
Thank you very much for that answer. And just a quick follow-up. Am I correct to assume that a victim can never be forced to participate in
Yes.
restorative justice? That's totally voluntary on their part.
Absolutely. And when this concept came up, that was something I did really explore because I think that it would be inappropriate to ever force an individual into a situation that they wouldn't be comfortable with. However, though, it is something that when we explain that process, we've actually had victims saying that sounds like a process that I would like to participate in.
Thank you very much. Greatly appreciate your testimony and the answer to the questions.
Thank you, sir.
Additional questions? You're welcome. Additional questions from committee members? Seeing none, again, thank you very much for your testimony. We look forward to working with you on this issue moving forward. The next person I will recognize is Kells Park from the Restorative Justice Institute of Maine. Kells, welcome to the Judiciary Committee. When you are comfortable, begin your testimony. We look forward to hearing from you.
Thank you, Representative Harnett. Good afternoon, members of the Judiciary Committee and Representative Harnett. Thank you for having me here today. My name is Kells Park, and I'm the Policy and Community Advocacy Coordinator with the Restorative Justice Institute of Maine. I'm a resident of Auburn, and I'm here today to speak on behalf of RJIM with full support for proposed LD 1226, a resolve directing the Permanent Commission on the status of racial, indigenous, and Maine tribal populations to examine restorative justice. I'd like to begin by thanking both Representative Talbot Ross for her work in convening restorative justice practitioners to create this bill, as well as Representative Harnett and Representative Pluker, Warren, Senator Carney for co-signing this nationally unique piece of legislation. The Restorative Justice Institute of Maine has been working for the past 9 years to ensure Maine transitions away from traditional punitive models of carceral justice towards accountability models of restoration and healing. For far too long, the United States has used carrot and stick legal precedents to justify unjust plea deals, the silencing of victims, and further monetary investments in mass incarceration. The carceral epidemics of the 80s, 90s, and 2000s have not only failed to address harm done within communities, but further perpetuated harm. We at RJIM, as well as other restorative justice practitioners, community members, defense attorneys, district attorneys, know that it is past time for a paradigm shift in how we as a community respond to harm. Restorative practices have been used in Maine to resolve harms in schools since the 90s and has been used successfully to promote healing and accountability in communities while reducing harm caused by involvement in the criminal justice system. Restorative practices have been endorsed by community-based organizations, school systems, legal advocates, state prosecutors, police departments, and the Department of Corrections. We now need its support in legislation too. LD 1226 puts power into the hands of directly impacted people, Black, Indigenous, and other people of color who have disproportionately been harmed by the worst parts of carceral state apparatuses, to review national restorative justice legislation, research Maine specific applicability of restorative practices, and bring forward their suggestions from a place of both trauma-informed and critical race analysis lens. RJIM has been in ongoing conversation with other proponents and practitioners of restorative justice about whether we should have a set standards of practice. One of the most prominent questions that comes up is who gets to set these standards. This piece of legislation is an essential component in answering that question. And I'll just close with saying that the Permanent Commission, as entities like Department of Corrections and Department of Education are getting more invested in restorative justice, we really need a body that can provide the guidance so that it's coming from a place that's outside of those entities, not coming from internally within systems. And so as practitioners collectively, we really stand strongly in thinking that this is the right direction for Maine in restorative justice. And I'm happy to answer any questions, and thank you for your time.
Thank you very much for your time and for your testimony today and for the work that you're doing in this area. I would open it up for committee questions for Kells Park. Are there any questions from committee members? Seeing none, again, thank you very much for your time today. We really appreciate hearing from members of the public that have so much to offer. Thank you.
Thank you very much.
Next person on my list is Leslie Ross. Leslie, when you are ready to testify, please unmute your microphone, activate your video, and begin as soon as you're comfortable.
Thank you. Thank you, Representative Harnett. Yes, thank you. And thank you also members of the Judiciary Committee. So my name is Leslie Ross and I live in the town of Penobscot. I'm the Hancock County Case and Program Coordinator for Restorative Justice Project Maine and Down East Restorative Justice, on which I also serve as board member. Down East Restorative Justice, or DRJ, strongly supports LD 1226, putting the task of reviewing and making recommendations for the advancement of restorative justice into the hands of the Permanent Commission. It is time to envision such, it is time to have this, to envision such a state of wide comprehensive approach in the state of Maine. DRJ has seen firsthand in just a few years the changes in a community when the opportunity for a restorative approach is made possible. We have seen seriously troubled school with high rates of teacher turnover, student absenteeism, and frequent drug confiscations be turned around by school-wide implementation, changing the culture of the school from one of isolation and dysfunction to one of inclusion and connection, nurturing a healthy learning environment. We have seen youths gain an understanding of the negative ripple effects of adverse decisions and actions taken, gain self-worth by being able to redress the harm caused by their actions, while seeing those harmed find a path to healing through voicing their harm, having a say in how that harm can be addressed. The process also often lays bare unmet needs of the participants. And with those, which those present witness and acknowledge, and we see this truly as a step towards support and interconnectivity within the community. We have recently expanded our program to include adult referrals. None of our programs would have been possible if it weren't for the support of our collaborators, which include Restorative Justice Project Maine, our DAs and juvenile community corrections officers, various community organizations, our granges and churches and libraries and community centers, and importantly, our dedicated volunteer mentors. Restorative justice principles come to us from Indigenous cultures around the world. And from this continent, the source coast to coast is from its Native Americans. Restorative justice strives to be at its foundation collaborative and inclusive. It believes that every individual has worth and it honors mutual respect, dignity, and choice. It accepts its fundamental premise that we live in community and that when harm occurs, it damages relationships, and that is only through coming together as a community that these damages can be repaired. Entrusting the Permanent Commission with examining restorative justice in all of its spheres and make recommendations and decisions based on their scrutiny and their equity lens acknowledges those who have been historically excluded and discriminated against. It is an affirming step forward in beginning to redress past harm. I am truly appreciative also of the words of my colleagues from organizations across the state who have spoken before me, and hoping that as a collective, we have managed to cover most of the strong reasons to support LD 1226. Down East Restorative Justice strongly urges the committee to give a unanimous opt to pass. Thank you.
Thank you. Thank you very much for your testimony and the work that you're doing in the community. Committee members, are there questions for Leslie Ross? Seeing none, again, thank you very much for taking the time out of your day to present to us in this unusual new format that we now have.
Thank you.
And take care.
Thank you.
The next person I have on my list is Ridgely Fuller. Good afternoon, Ridgely Fuller. As soon as you are comfortable, please welcome to the Judiciary Committee and begin testifying as soon as you feel ready to do so.
Thank you so much, Representative Harnett. And good afternoon, members of the Judiciary Committee. I'm just a simple on-the-ground volunteer with Restorative Justice in Waldo County. And I just really wanted to take advantage of this opportunity to be able to support LD 1226, a bill to resolve and direct the Permanent Commission on the status of racial, Indigenous, and Maine tribal populations to examine restorative justice. And I wanted to testify because I'm deeply grateful for the experience my participation in restorative justice has meant to me both personally and professionally, and my earnest desire to see that the higher standards of restorative justice remain present in Maine. I believe that when we can make sure that all future restorative justice legislation is examined and applied through a racial equity lens, we will be able to ensure that the core values of restorative justice, which, as you know by now, are mutual respect, dignity, humility, equity, and choice, will be maintained. The Commission, through its broad and trauma-informed perspective, is best positioned to weigh the impact of restorative justice legislation on the most disadvantaged and marginalized communities of Maine to ensure accessibility and anti-discrimination. And the Commission is finally best able to engage all our communities in identifying and reducing root causes of harm so that restoration and not retribution can become the foundation of healthy communities throughout our state. Before coming to Maine 8 years ago, I enjoyed a long and rewarding career as a social worker, engaged with marginalized youth and families in schools and clinics. I was often involved in the formal justice system. The justice system, as I knew it before coming to Maine, was impersonal and retributive, where dispositions were rendered by anonymous court officers. Offenders didn't consider the impact of their behavior, nor did they have the opportunity to take personal responsibility or repair the harm their behavior caused. Thus, the opportunity for their growth and connection was denied. Similarly, the impact of their behavior, the people impacted by their behavior, be they individuals or communities, were denied the opportunity to feel empowered and uplifted by engaging with the offender and repairing the harm. So many opportunities for restoration and community building were lost. By volunteering in restorative justice here in Maine, I've learned that there is indeed a flourishing system that provides individuals and communities with the opportunity for both personal and structural change. During the past 8 years, I have joined harm repair circles, sometimes as a facilitator. I've served as a mentor and most recently learned about community engagement circles where restorative principles are used to build communities that care for all their members. I've been more excited about comprehensive social healing in these past 8 years than any time during my social work career or training. To those who've lived in Maine for much longer than I, it might be easy to forget that with restorative justice practices, this state is in the forefront of real justice reform in our nation. Making sure that our practices remain the best practices will be possible by directing that all future restorative justice legislation be held to the higher standards possible through scrutiny vision of the Commission on Racial, Indigenous, and Maine Tribal Populations. I ask you to vote this. Thank you.
Thank you very much.
Thank you for this opportunity.
Wrap it up. We appreciate your being here today and offering your testimony and personal experience with restorative justice. Are there questions from committee members for Ridgely Fuller? Seeing none, again, thank you very much for taking the time out of your day and sitting with us through this important yet lengthy hearing.
Thank you.
I will next recognize, and I'm going to be tested on the last name here, Suzanne Rudalevich.
Yes, you did pretty well. Good afternoon, late afternoon, Chairperson Harnack, Senator Carney, and members of the committee. My name is Suzanne Rudalevich. I'm living in Cape Elizabeth, and I'm testifying on behalf of the Anti-Racist Policy Committee of the Hope Gateway Church in Portland. I have spent many years advocating for restorative justice procedures to be used in cases of conflict, particularly in schools and in the criminal justice system. I firmly believe in its forward-looking philosophy towards actual accountability of the offender and focus on the healing of all parties involved, including the community. A little bit of history. When I came to Maine over 20 years ago to work for the Maine Council of Churches, restorative justice was beginning to be seen on the criminal justice radar due to the work of then Commissioner Lehrman I've spelled it wrong. It doesn't have an R. At that point, restorative justice was cited at the Department of Corrections Victim Services. It was included in legislation and mainly used for juvenile misdemeanors. And I was part of a community resolution team, which were formed under the auspices of the Victim Services. I'm going to skip, because you've heard enough. But I would want to just put out that not everything that is out there when exploring legislated or proposed restorative justice practice is all restorative justice. Some do not follow the basic principles coming out of Howard Zer's seminal work in the 1990s. We must also understand that any process, however benign or helpful, can be administered in a biased manner. Access is key. You've already heard why it's really important that the Permanent Commission do this work, because it's the tribal cultures who have been doing this kind of conflict resolution for many years, both here and in other parts of the world. So I just want to say to those who are not really familiar with restorative justice, that no one is saying that this is the process and the alternative to what we have now. You can do both and. Many times somebody raised that it can be done, the process can be used in rape cases or murder cases. And this usually happens after the regular court process has be completed, when often the victim wants to know certain things that nobody else knows except the person who did the deed, or the victim needs to talk to the offender. So it can be both and. And another important point is that it is only when the defendant is admitting the wrongdoing and when the victim wants this process. So I would love it to be in vain that we have this alternative, and I really hope that you will support this bill. Thank you.
Thank you very much for your time and testimony this afternoon. Are there questions from committee members? Representative Thorne.
Thank you, Mr. Chair. Welcome, Ms. Rudelich.
Rudelich, that's all right.
I'm just curious, with your experience, have you ever encountered a situation where a victim believes they want to speak with their assailant, but then afterwards wishes that they never had done it?
Well, I don't know, but that is unlikely to happen, because both the victim and an offender, if they're going to meet actually in person, they are very well prepared separately, so that they have each person has gone over with a mediator exactly how it works and the kinds of things that can come up, so that they have done a rerun before they get there. I don't know, but if it's done in a restorative justice manner before you get there, it should not happen. But it could happen, yeah.
Thank you, Mr. Chair.
You're welcome, and thank you, Representative Thorne. Are there additional committee members with questions? Seeing none, again, thank you very much for your time and taking advantage of the opportunity to address us directly today. It's greatly appreciated.
Thank you.
That ends the persons that I have who pre-registered to testify, but that does not mean you are unable to speak if you are in the attendee room. So I will ask if there are any persons in the attendee room who wish to speak in favor of LD 1226 to please raise your hand, and magically Supi has brought over Jan Collins. Welcome, Jan, again. And as soon as you are comfortable, please begin your testimony.
Thank you so much. My name is Jan Collins. I'm Assistant Director of Maine Prison Advocacy Coalition, and I'm here to support LD 1226. I just ran into the hospital to get my second COVID shot, and I'm out in my car doing this testimony, so I hope I have good connection. As you have heard this morning, and in testimony on other bills, putting someone behind bars does not remove the pain and suffering of victims. Neither does it heal the wounds. Those who committed the crime and those who were victims are separated by the law and kept from speaking to each other. That may be good for at least a while, but it does not allow for mending. Restorative justice is concerned with healing victims' wounds, restoring offenders to law-abiding lives, and repairing harm done to interpersonal relationships and the community. It allows victims to have their pain heard, offenders to take responsibility for the harm they have caused, and to make restitution. And it helps mend the fabric of the community. This is not a new concept. Though it may be long out of use in the United States, traditional societies have often incorporated some form of restorative justice as a necessary measure in ensuring that all individuals work together for the protection, safety, and betterment of the community. In Maine, restorative justice has primarily been used with youth offenders, where it is currently in use. It has reduced recidivism rates to single digits. It has allowed these youth to go on to lead loving and productive lives. The opposite is true of those young people who are sentenced to Long Creek. Youth at Long Creek have a 70% recidivism rate. They have a high rate of suicide, and their future employment, housing, and educational prospects are poor. Maine would benefit if the opportunity to participate in restorative justice programs were expanded both across the state and to adult populations. How to do this and who should be included would be the responsibility of the Commission. We look forward to the Commission's suggestions, plan, and report. And I do thank you for listening to me again today. Thank you.
Thank you very much for your testimony again this afternoon, and congratulations on getting your second shot. Are there questions from committee members for Jan Collins? Seeing none, I guess that means you can turn off your camera and start up your car if you like, or you can stay with us and listen some more. But thank you very much for being here. And I am still looking for persons who wish to speak in favor, and I saw a hand up by Jake Kalaw. And as soon as you are ready, are you testifying in favor of LD 1226? Thank you. Please begin your testimony whenever you feel comfortable.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jake Kula. I live in South Portland, and I am also a teacher at Deering High School in Portland. I'm also the congressional liaison at First Parish UU as part of the Maine Unitarian Universalist State Advocacy Network, also known as MUSON. I strongly support the passage of LD 1226, resolve directing the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal to examine restorative justice. Restorative justice is values-based, emphasizes inclusiveness, collaboration, and aims to build relationships. This legislation puts decision-making in the hands of those appointed to bring scrutiny, research, vision, and action to raise up the needs and voices of Maine citizens who have been historically marginalized, traumatized, and discriminated against. It also invites the commission to bring a race equity lens to consider how national restorative justice legislation might best serve all citizens of Maine, ensuring accessibility, choice, and anti-discrimination practices. Because the commission is independent, trauma-informed, and has a broad perspective, they are uniquely positioned to consider the evidence and inform legislative strategy in Maine. Restorative justice acknowledges that harm happens and is a natural part of the human experience, whether in families, schools, workplaces, or carceral settings. The intent of restorative justice is not retribution, but restoration and healing, believing that every individual has worth and dignity. It is equally important that we fund this measure with the passage of LD 1034. Culture shift takes time and resources. This resolve will play a role in healing and repairing relationships with the most marginalized communities and won't create further damage. As a person of faith, as an educator who cares deeply about young people, I urge you to strongly support LD 1226. I have seen so many students not get the help they need due to zero tolerance policies that actually do more harm and also feed the school to prison pipeline. I use restorative practices in my classroom, and I have watched students heal, forgive, and grow. I have witnessed firsthand how restorative practices have a positive impact on students, teachers, and marginalized people. And I just want to end with a personal experience I had as a teacher where an assistant principal came into my classroom, asked where a student was. Student was then handcuffed by a police officer, leaving everybody in that room, myself included, completely traumatized. And I had to process that with my students after that event happened. This is not a way to treat people with dignity and respect. Thank you.
Thank you very much for staying with us through this hearing late this afternoon. We greatly appreciate you taking the time to come before the Judiciary Committee to testify. And thank you for the work that you do with our young people at Deering High School. Are there questions from committee members? Seeing none, again, thank you very much for your time and for your testimony and sharing your experiences with youth. Greatly appreciated. Again, I will ask, are there persons in the attendee room who wish to testify in favor of LD 1226? If so, please raise your electronic hand so we may move you over to the panelist room. Seeing none, I would ask if there are any persons in the attendee room who wish to speak in opposition to LD 1226 to please raise your electronic hand so you will have the opportunity to address the committee. Seeing none, I would ask, are there any persons in the attendee room who wish to speak neither for nor against LD 1226? If so, please raise your electronic hand so that we have the opportunity to hear from you. And seeing none and having heard testimony from all those persons present and wishing to present testimony to the committee today, I would like to thank the bill's sponsor, Representative Rachel Talbot Ross, for bringing this bill forward. And I will now close the public hearing on LD 1226. Thank you, committee members. Thank you, bill sponsors. Thank you for all persons who testified before the committee today. Greatly appreciate your effort. And unless there are committee members that have something they'd like to discuss before we call it a day, I would, Representative Thorne.
Thank you, Mr. Chair. This will be an easy one. I have my printed out Judiciary Committee schedule from a while back, and I'm just curious if Friday's bills as presented on this are still accurate.
Not knowing what you have in front of you, I will read the bills that are on the calendar for tomorrow morning.
Thank you.
LD 32, an act regarding remote participation in public proceedings. LD 668, an act to ensure public accountability while implementing a practical approach to remote participation. LD 746, an act regarding remote participation in municipal meetings. LD 1224, an act to authorize remote participation in Maine State Cultural Affairs Council's meeting. As you can see, we're going to be talking about remote participation. LD 1200, an act to bring gender parity to corporate boards. LD 1368, an act to require due process in asset seizure. LD 1499, an act to improve accountability in asset seizure and forfeiture reporting. And finally, LD 923, an act to stop guilt by accusation act. I hope that's perfect.
100% accurate. Thank you.
I rarely hear that in my life. I appreciate that. Did I miss anything, Soupy?
No, that is correct. You have Peggy on your left, though, might have something to add.
Well, Peggy always has something to add. That's why I didn't call on her right now. But Peggy, we have not heard from you much today, so please.
Thank you. I appreciate having a day where I can just listen to all of you. But LD 1521 is sponsored by Representative Falkingham, and it is also about civil asset forfeiture. It's been referred to the Criminal Justice Committee. The chairs have invited Representative Falkingham to come to the public hearing tomorrow if he would like, and talk about his bill, since we're doing two other asset forfeiture bills. I haven't heard back from him, so I don't know if that's going to work with his schedule or not. But I just wanted to warn you that he may appear so we can continue the discussion about asset forfeiture.
And thank you. We agreed to that last evening, and I forgot to mention it or write it down on a piece of paper. But thank you very much.
I'll let him know. He'll be happy to know that the committee's been warned he might show up.
Okay.
Anything else for us, Peggy, before I finally let the committee get to go home? No? Okay. I remind everyone we begin our public hearings at 9 o'clock this morning. For Democrats on the committee, there will be a committee caucus at 8:30. I wish you all a very nice evening. I hope it's not still snowing outside. It was this morning. That surprised me. And have a very good night. We'll regroup tomorrow morning. Thank you.
Bye.
Good night.